All right, good morning, everyone.
Morning.
My name's Rob Register from the Beasley Allen Law Firm. Welcome to the 2026 Jury Trial Seminar. This is sponsored and presented by the General Practice and Trial Section of the Georgia Bar. We really appreciate the bar allowing us to have this seminar for our section. We appreciate Lane Sosby and Charlie Smith from the bar helping us put on this incredible seminar. We really appreciate all the speakers who have prepared topics and are going to present everything to you today. Abby Patterson, our executive director, she does an incredible job running our section and keeping us straight and organizing not just this seminar, but the Institute, usually at Amelia Island. We also have a sponsor this year, Rita Carroll from Solve It Mediation. She sponsored the breakfast and lunch, and I hope that you all that are here will enjoy some of that and take a moment to speak with Rita and what her company offers through mediation in personal injury cases and other types of cases. Thank you, Rita, and Solve It Mediation. As in every year, what I try to do is look back over the prior year and see who had verdicts or who participated in meaningful trials that I believe would be helpful to learn about. And so I contact these attorneys and ask them about their case and if there's things that they could present so that everyone who watches and participates in the seminar can hopefully walk away with something that'll help your practice. And I think we have a great lineup of speakers again this year. A couple housekeeping matters. There's a Wi-Fi password up here if you need it. And before you leave, Abby has stickers that you can put on your parking pass that allow you to get out without having to pay. So we'll get right to it. Our first speaker is Ashley Mitchell. Years ago, we would do this seminar at the Georgia Public Broadcasting Center off of in Midtown, and they would have the whole studio set up. I guess that was before it was easy to broadcast online, so we would have to use the broadcast center. And I remember Ashley was a young associate at a defense firm, and she came to those seminars, and you could tell even at an early age that she was soaking up all of this information. After some time at a defense firm, she joined a really successful plaintiff's firm, learned how to try cases there, and then has recently gone out on her own and formed Ashley Mitchell Law Firm, the Mitchell Law, and she's come out hitting home runs already. She had a great trial victory last year. As you will see today, a lot of the topics we're going to talk about SB 68 and the changes that that law has made to our jury trial system and other things, and how attorneys are dealing with that post SB 68. But Ashley, come on up here and talk to us about how you were successful in your trial and about storytelling post SB 68.
So much. Good morning, and thank you for that introduction, Rob. Again, my name is Ashley Mitchell. I'm the owner of Mitchell Law Firm that's here in Atlanta. And as Rob said, I've been coming to this seminar for years. I did defense work for about 7.5 years, and then I switched over to the plaintiff side. And I think it was either the first or the second year that I was attending. We were having lunch, and Rob came over, and I had my insurance defense firm on my name tag. It's kind of like, hey, how's it going? We don't see a lot of you around here. But I had never really thought that I was surrounded by plaintiff's attorneys, because I think the concepts that you learn in this seminar specifically, it can really benefit you if you're on the defense side or the plaintiff side. And I hope that there are some good takeaways for all of you here from storytelling post SB 68, possibilities and pitfalls. As Rob mentioned, I had a trial in December. It was my first bifurcated trial. And so a lot of this, the things I'm going to be talking about is what I learned via that trial, some of the research, and talking to folks who do appellate work and are a lot smarter than me. So I'm going to give you some tips and tricks for that. But first and foremost, I want to talk about storytelling and how that may help you kind of in this new landscape of bifurcated trials. Attorneys are storytellers. That's what we do. And when I say storytelling or storytellers, I don't mean it in a flippant sense, I don't mean it in this, oh, we're just magicians. We go into court and we weave these tales and try to get people to give us buckets of money. When I use the term storyteller, what I mean is the most classic, authentic, timeless tradition of being a vessel for somebody else's life, for their story. And that is what we are tasked with. Now, unless you've been living under a rock, you know that tort reform has changed a lot about how we do things in the courtroom. I think one of the purposes of bifurcation was to interrupt your ability to tell a cohesive story. So traditionally, for the most part, we had concurrent trials. That meant a jury got to hear liability and damages before they had to make a decision. And now what we have, this will work. Well, of course this would happen. Bear with me 1 minute while.
I work on the laptop, but I'll get.
Yeah, no, it's good. Let's see. So what we have now is a story that's really cleaved in two. So a jury is going to hear evidence of duty and breach before they ever really know about the impact on your client, which is typically the emotional heart of the story. Your client doesn't see a line of demarcation between what happened to them and the emotional and physical effects of the incident. So bifurcation was sort of this intended stumbling block to force us to put all the more clinical, more sterile judgments that have to be made in one stage and the emotional heart in the second stage. But I want you to think about this as if it is a possibility instead of a pitfall. Now, procedurally, there are a lot of pitfalls that we'll talk about, but from a narrative standpoint, your job is to craft a phase one that is just as compelling as the phase two. And you have to draw your audience in and keep them interested, because if it fizzles out in phase one, then what have you done? The other part of bifurcation that I think is a little bit paternalistic is what they intended to do was insulate the jury from hearing about injuries and damages. You know, these jurors, they come in and they can decide if somebody's liberty is taken away. They can't be trusted with the whole story before they make a decision. That was the message. And I don't think that that's true. I think that is primarily something that we're going to have to navigate, but you can still feed your jury information and evidence about the ramifications of what happened despite bifurcation. I don't think that bifurcation is really going to be the boon to the defense bar that they thought it was. In some cases, I think it will actually harm the defense. But from our perspective, if we're looking at it like a possibility and we are open to the challenge of telling a story in a different way, we have a lot of opportunity to be gained. I want you to consider the story of Steven Spielberg and the making of the movie Jaws. I'm going to assume that everybody has seen the movie Jaws here, but the story that was ultimately told that became the blockbuster hit that it was not the story that Spielberg intended, is not what he had planned. But because he was nimble and could pivot, it led to great success. So if you know anything about the backstory of this, Jaws was being filmed in the 1970s. Spielberg was not a household name. He had had some success, but this was really his first major motion picture. And the story that he wanted to tell was really focused visually on the shark. I mean, the movie's name is Jaws. What else are you going to do? And what he had planned and spent a lot of money doing was building Bruce, the mechanical shark that you see here. There was just one problem with the plan and the story that Spielberg was going to tell. Bruce had only been tested in freshwater. So by the time that they take this mechanical shark out to the coast of Massachusetts and put it in salt water, they have a major problem. All of the salt water and the elements and the currents completely destroyed Bruce. They would fix it, would mess up again. They would fix it, it would mess up again. And this was costing the studio a ton of time and a ton of money. So Spielberg had to pivot. And instead, he decreased the screen time to where the shark is only featured 3% of the time. He bumped up other elements of the story to draw the audience in and keep their curiosity. The music and the score was a huge part of that. Donna, Donna, Donna. I know you've all heard that before, and it's iconic. He had to do that because he was prevented from originally crafting the story that he wanted to. What happened? That movie defined summer blockbusters. It turned him into a household name and really launched his career. So when you were thinking about bifurcation and maybe have some trepidation about telling a story in a different way that you haven't typically done before, I want you to think about it as a challenge that you are open to. You can pivot, you can use other things, and I guarantee you, you may be better off for it. So before we talk about some of the other storytelling elements that you can draw in order to build your case, we have to get to the boring stuff, which is the statute itself. But the statute is important because that is what you're going to use to set your stage and figure out what characters come in when, okay? So quick facts, it applies to all pending cases. Doesn't matter if your case was filed before the law was passed or after. If a party elects bifurcation in writing before the pretrial order is entered, it's mandatory, except in two very small exceptions. So I want to emphasize that any party can elect bifurcation. In my last trial, I actually elected bifurcation for various reasons. I had a situation where I had clear liability case. I felt the defense had some very poor positions that they had taken and were contesting liability. And the defense attorney was talking about the medical bills and how high they were and all of this and how he was going to use the amount of the medical bills to really cast a poor light on the causation. And when I was looking at the case, I was like, well, if that's the only tool you have, I'm going to take it out of your toolbox because you're not going to hear about it in phase one. You can only hear about it in phase two. Would I do it again? I don't know. I think it could go either way. It definitely slowed down our trial, but if you're a plaintiff's attorney, you should at least consider the possibility that you might want to bifurcate it in certain situations because you do have that right to elect via motion or via demand. There are two small exceptions where a judge can deny the motion for bifurcation if one of two things are true. The amount in controversy is less than 150K. That's pretty straightforward. You still have to file something in opposition saying, Judge, we want you to reject this request for bifurcation. So file your motion, probably 3 sentences long, and you will get that if your case is worth less than 150K. And the second exception is a little bit more complicated from an evidentiary standpoint. It is if you are a plaintiff or the plaintiff is the legal guardian of a minor and you're involved in a case related to an alleged sexual offense, you can ask the court to deny bifurcation if it would be likely, the person testifying would be likely to suffer serious psychological or emotional distress. I think that you would be at risk if you have a case like this to just go in and argue to the judge without any sort of evidence to show them that it would be likely that this person is going to suffer serious psychological or emotional distress. A tactic that's worked for me in other cases and other venues is, and I handle a lot of child injury cases, some of a sexual nature, but what has been successful in other venues where I've been concerned about that is I just simply went to the treating physician or I've hired an expert to give me an affidavit or give me opinion that yes, the common sense that testifying twice about this traumatic event would cause them emotional distress, just go ahead and get some expert opinion on that. And then that way, when inevitably they move to bifurcate the case, you have that in your back pocket and you can show it to the judge and make their decision very easy. Because I think the defense would be very hard pressed to find somebody else to say, no, this particular person would not be put through emotional distress for having to testify twice. So those are your very limited exceptions. whenever you're thinking about your case and setting the stage, I think there are categories of cases that are going to be, more defense friendly in the world of bifurcation, and then some that are actually going to be a lot more advantageous to us. So if you have a case that doesn't have great liability and it doesn't have great damages, you're in danger girl category. That's probably not one that you want to be trying, right? And sometimes we're forced to try those cases anyways, but in my opinion, those that fall in that realm are the worst cases for plaintiffs in a bifurcated world. Now, on the flip side of that, if you have a case that has great damages and great liability, and the defense still wants to try it, I think bifurcation might actually help you, especially if there are some bad defense positions along the way. And that's what I call the Michael Myers bloodbath territory. Because in my mind, when I'm going into a trial, I want the jury to say yes to me as much as possible. Just like in my pretrial motions, I want the judge to be saying yes to me as much as possible. So if you have a bifurcated trial, great liability and great damages, what you can typically do is put on an incredible phase one. And then in phase two, there's not much of an answer most of the time for great damages, right? If you're dealing with a quadriplegic or something like that, the defense doesn't really have a lot of tools in phase two. And that's the last thing that the jury is hearing before you ask and before they are determining the amount to award your plaintiff. So that can be very, very dangerous for a defense attorney. And then the other category is what I would call the land of opportunity. My case that I tried in December, on paper, the liability was great. It was a rear end trucking case. My driver was also a commercial driver, but the damages on paper didn't seem that great. I used to work on the defense side, and everyone always wanted to know how much the medicals were, what the future medicals were, lost wages. And he really didn't have a lot. I mean, he had 168 in past meds, and we ended up getting a 2.5 verdict. But where we found the opportunity was in the non-economic damages buildup. Because if you have a case and the defense is not exploring that in depositions because they just think it's a run-of-the-mill case, especially if it's an MVA or a trucking case, you can really sandbag in phase two. Because most of the time people are not doing a really thorough job of finding out what your damages witnesses are going to say in that context. If you're a defense attorney listening in, what I would do is challenge you to take those depositions, really delve into a plaintiff's damages. I think a lot of people don't want to do it because no one likes to talk about pain and suffering. We don't want to hear that from somebody else that we're opposed to. But if you're a defense attorney, it's your obligation. You need to be doing proper reporting, and you need to be prepared for trial, because you can be sitting there in phase two on a case that you thought was run of the mill, and you have no answer to some things in phase two. It can really be a dangerous position to be in. So going back to the statute, there is a hot debate over what a few little words in the statute mean. What we did in our case is we wanted to set the stage immediately out of the gate. We did not want to show up on Monday to select a jury and have an argument about, okay, well, what comes in phase one and what comes in phase two. The defense bar's argument is the intention was that duty and breach have to be decided in phase one, and causation and damages come in phase two. They want to completely isolate it from that. And I do think that that was what the lawmakers intended to do. That's not what they did. When you read the statute, these words are very important. If the trier of fact in the first phase of trial, the trier of fact shall determine the fault of each defendant, and if the trier of fact finds that any defendant is at fault for the plaintiff's injuries or wrongful death. I'm going to say that again. At fault for the plaintiff's injuries or wrongful death. Necessarily, my argument, and the one that has won in our particular case and in other cases, is in order for the jury to make that decision in phase one, they obviously have to have information about the plaintiff's damages and their injuries. You see that there. It says for the plaintiff's injuries. So they have to decide duty, breach, causation, and they have to have evidence of injuries. That is the way that it is interpreted, I think, and it marries best with the apportionment statute. So that was the argument that we made via trial briefs. Do not show up on Monday not knowing where the edges of your stage are. File your trial briefs, and even better than that, pick up the phone and call opposing counsel. I know no one likes to do that these days, but if you can get on the same page as to what types of evidence are coming in what stage, you'll be better off. And if you don't agree, then you can at least tell the judge that you tried. And you go and you ask for clarification and a ruling. If you have a trial that's coming up and you want to see my trial briefs or any of the orders that we've collected, please let me know. I'm happy to send those to you. We also were arguing this very language in the statute again on Monday in post-trial motions, and she actually denied their motion for new trial from the bench and said exactly what I just described as duty, breach, causation of injuries is all phase one. The only things that I argued that should be going in phase two is the amount of the damages, the number of your medical bills, the number of your lost wages, and then arguably the extent of your pain and suffering, right? I think you have to be careful in phase one when you're talking about the extent of the non-economic damages. And you may be better off just holding them off until phase two. That way you don't risk an appeal. A storytelling technique that you could use is foreshadowing. If you're in a bifurcated trial and you know that they're not going to talk about damages, you can't even really breathe a word of it. You can't talk about the non-economic damages either until phase two. That does not change your ability to talk about those things in voir dire. Bifurcation has not changed it. You have one jury selection and you have one jury that decides all the phases. And there are different schools of thought when it comes to voir dire. You can do the exclusionary method, which is your typical, does anybody have a police officer in their family? And that may be your style, and that's fine. There's another school of thought that's inclusionary, which is where you get the jurors talking about their experiences. And there's no such thing as a bad juror. You just want to know about them so you can make the proper strikes. I do a little bit of a blended jury selection, but what we did in our last trial is we knew we weren't going to be able to talk about certain things until phase two. So we asked very open-ended questions and got the jury to give us the information that we were looking for about non-economic pain and suffering. So for example, in my case, my client was back to work 3 months after the incident. He was working full-time as a truck driver, which is a physically demanding job, but he was suffering. He was doing the best he could. He was playing hurt. So one of the questions that we asked the prospective jurors in jury selection is, has anyone here had a serious physical injury, but you kept working? What was that experience like for you? What did your body feel like? What were the kind of concerns that you had? And we got them talking, and there was a ton of people in the jury that had been in the exact same situation that my client had been in. So when we were talking about that, we are foreshadowing for them something that they're going to hear from the plaintiff down the road, right? You're planting the seeds of what they are going to hear in the future, and this is your first opportunity to talk to the jury. Obviously, some judges handle jury selection different ways, and your mileage may vary. We had a judge that was pretty much allowing us to do whatever we wanted to do as long as it was within the statute. And if you were crafting your questions to foreshadow to the jury about your damages, what I would suggest is going ahead and having notes beside each question that say, if it's challenged, you can go to the judge and say, this is exactly what I'm going for. I'm entitled to know about their bias against non-economic damages related to diminished earning capacity or whatever it may be. Go ahead and have those notes because it's going to be challenged. The defense team in our case, they only challenged a few questions, but I think it was because they kind of didn't know what we were doing with the inclusionary jury selection questions. But that is a good way that you can go ahead and lay the breadcrumbs for your jurors even when you know you're walking into phase one and you're not going to be able to talk about for a while. My second piece of advice is storyboarding. It's something that people do when they're creating movies, novels. They take certain scenes and certain vignettes and they piece them together in the whole story. And Mark Twain used to basically say the same thing, that your story, each component of it, you may have episodes within a cohesive story, but it all has to serve the main one that you're telling. And a good way to visualize this is to storyboard. So you take the experiences and the vignettes and the characters that you're going to use, and you look at them as a whole and you switch them around. There may be some stories that you want to save to phase two because they have maximum impact there, or the layering of certain stories could be beneficial. And when you do it in a storyboard way, you can really see the impact of the whole. So I had a high school chemistry teacher back in my hometown, and he was trying to corral a bunch of high school rednecks like myself. What he would say is, don't be a pantser, be a planner. And that doesn't mean pantsing in the, play a joke on your buddies standpoint, but do not fly by the seat of your pants and go into trial thinking that, you're just going to call witnesses in whatever order that you want to. You really have to put a lot of thought into this and plan for it. One of the things that I did to plan for it is something I've been doing for a couple of years. Whenever I get a case at the very beginning, I start an Excel spreadsheet and I call it my players list. I list every single person that could possibly be a witness on the players list, and I build it throughout the case. So for example, I'll have the plaintiff, the medical providers, the police officers, their names, their contact information, if I've spoken with them, notes about them, what they are good for and what they are bad for my case. And so now all I've done is add another column. Is this a phase one or a phase two or potentially both? And when you start out and you know your cast of characters before you walk into trial, you can figure out, okay, who do I have that can tell this one concept or show this one thing to the jury in the most impactful way? For example, in our trial, we had, my guy was a trucking driver. He had been at he'd been hauling basically for Coca-Cola. The terminal manager, his supervisor, was an amazing witness. Salt of the earth guy, former military, knew everything about trucking, and really liked my plaintiff. He drove 2 hours to come to trial 2 days, and he hadn't seen him in 3 years. So when I was talking with him, I was really weighing whether or not he was phase one or phase two. He had gone to the scene. He had overheard some things that the defendant had said that I thought was helpful to us. He had seen the property damage. He had seen my guy shaken up at the scene, right? So he could have gone in phase one. But where he really shined when I started planning and looking at my players list was phase two. He said this was one of my best workers. He drove all over the country and would be gone for weeks at a time. I know that he drove hundreds of miles away to see his family and take care of them and would take a load back. And when I saw him when he came back to work, he was not the same. He was depressed. When he was climbing in and out of his cab of his truck, it was like an old man was doing it instead. And because I was able to look at all of the characters as a whole, I made the decision to keep him in phase two because I didn't want to bring him twice, number one, and put him through all that. And I also didn't want the defense to be able to do anything with him because by the time we got there, we were pretty much home free as far as damages go. Another thing that I do in order to plan for a bifurcated trial is I take every element of the pain and suffering charge, go through it, know it by heart, and really think critically about it. And I got this method from Christy Childers. She's amazing. She has what's called a damages house method, where you go through and you have an assigned value for each of the elements of pain and suffering. So what I did before we ever got to trial was I went through and I listed out on one of those big sticky sheets of white paper, each element, and then all the facts that related to that. And I looked at it critically and I thought, all right, what facts can I bring out in phase one when we're talking about causation, that also have to do with damages. So for example, we had the defense medical expert, Dr. Paul, on actual pain and suffering. And he admitted that back pain can be excruciating. It can be burning, stinging. He gave us that. And so on the stand in phase 1, we had him admit that these signs that he had seen in the medical records that he reviewed, and he kind of poo-pooed. But we said, don't you agree that this is a sign that's in his medical records? And back pain can be excruciating. It can be debilitating. And that was all in phase 1. We were talking about those concepts. So by the time that my client got back up in phase 2 and was describing his pain, the jury had heard it before. And there is science in psychology studies to say that the more that a jury hears something at least 2 or 3 times, they hear it 2 or 3 times, then it adds to the truthfulness. They believe it is true because they have heard it more than once. And so we were using their witnesses by pre-planning to embed some of those concepts in phase 1 without running afoul of the judge's order. So I would suggest you do that well in advance so you know where you can lay those breadcrumbs from the jury that you started with in jury selection. And my last point for bifurcated trials from a storytelling perspective is streamline, streamline, streamline. That's something that I really wish I had done in my trial. I think that when we were looking at some of the medical evidence, we did cut it down. We could have cut it down more. You know, if you have a medical expert that's testifying via video, really 15 minutes is about all you need. You don't need to go much longer than that unless it's an extremely complex topic. And the example that I give for this is one of what I think is the great storytellers and singers of our time, Dolly Parton. And I was going to play you a clip of the song Jolene, but if you're familiar with it, in the first 30 seconds, she gives you everything that you need to know about that song and about that conflict and about those characters. Jolene, 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 I'm begging of you, please don't take my man. In the first 30 seconds, you know who's involved: Jolene, the singer, and the man. You know what the conflict is, and you know the storyteller's perspective. She's not angry, she's pleading. So whenever you were thinking about your case, I would say the minimum effective dose for each witness. Streamline, streamline some more. Studies show that jurors cannot keep complicated concepts in their brains for very long. And if things get too messy and they're too drawn out, they completely shut down. You lose their attention and you lose those narrative hooks that you've set so far. So anchor through the repetition, jury selection, your phase 1 witnesses if you can, and then bring those concepts all the way home in phase 2. And that will help with the jurors' recall, because once they go back to the deliberation room, studies have shown that the more that they have heard it, the more accessible it will be in their memory. So you will have jurors back there that are fighting for you based on what they recall from your presentation. Overall, like I said, there are some pitfalls, especially procedurally, that you have to know about the bifurcation statute. But overall, there is a massive creative opportunity here. And jurors honestly don't know, unless they've served on a jury before, they don't know that this is different, right? They come in, maybe it's their first time being on a jury. They may not even remember what stages they had to make decisions back then. But unless you make it a big deal, and unless you drop the ball, they're not going to know. They're going to trust you as the captain. They're going to trust you as the storyteller. But you have to use your pre-planning. And if you do that, I think you'll find that it's actually not that hard to navigate. So does anybody have any questions?
How did the court handle bifurcation aspect with the jury? Did the judge tell them at some point after you reach this verdict, you're going to have to come back for us? How did you guys handle that aspect?
Yeah, that's a great question. So I think when you're setting the stage and you're doing your trial briefs, something else that you need to consider is crafting a preliminary jury instruction that basically says you're going to make your decision in stages. And that's what we did. We put together just a very brief one for the court that she read. We also filed a motion in limine, so the defense couldn't get up and say, you know, if you find for the defendant in phase one, you get to go home, because I don't think that that's proper either. So we had filed the motion in limine on that point, which she granted. And then we also had the jury instruction, and they didn't seem, as far as the decision making, they did not seem perturbed by that at all. The only issue was getting that hashed out beforehand. So again, pre-planning, make sure that you're going in, you know how the stage is set before you get there. And I think as we get more orders and we get more jury instructions, we collectively, at least on the plaintiff's bar, can use them to our advantage and say, look, this is a jury instruction that's been given in 5 other cases. Here you go. Here are all these orders and guidelines on bifurcation. Here you go. And that makes the judges feel warm and fuzzy, because they're not just left out on their own trying to figure out how we're going to do this thing. Any other questions? Yeah.
From a storytelling standpoint, what would your recommendations be for the simplification of testimony from like a really technical expert witness, like an engineer, biomechanical, somebody like that?
Okay, this is maybe a millennial life hack, but I struggle with that sometimes. And my husband, he works with architects and engineers all the time, and they can really get in the weeds. So generally with experts like that, what I start out with in the first 30 seconds of questioning them, I'm like, give me your overall opinion, and I want you to tell it to me like I'm 5. And I work with them in order to do that. And then the other kind of life hack is run it through ChatGPT or Claude. I know that Matt, I think, is presenting on that later, but there have been times where I'm looking at a concept and I'm like, man, that just seems very complicated. And I describe it to Claude and I say, if you were explaining this to someone with a high school education, how would you go about it? And you actually will get very good ideas from that you can then riff on, right? But if you're having not writer's block, but storyteller block, that is a good way that I found to kind of condense it in a way that makes sense for your audience. We have a tendency to make everything like overcomplicated, but that turns people off, especially when we are in an attention economy. They expect everything simple. They want to know within 30 seconds to a minute what the main concept is, or they're moving along. But those are 2 things that I've used that's worked well. Yeah. Hey.
When you are deciding if, like you said, you ask for bifurcation,
Mm-hmm.
can either side go back and forth? Like, could someone get up to the EVA trial and say, never mind, I don't want to bifurcate? Or could you change what's in the CPTO versus what you do at the pretrial hearing?
Yeah, I think that based on the judge's discretion to amend the pretrial order in the interest of justice, I think if both parties came in and they said, you know, scratch that, we've come to an agreement, this trial is going to take forever, for example, and we don't want it bifurcated, I can't see a judge not using their discretion in that way to amend it and just do it the concurrent way that we've always done it. I don't know what would happen in a situation where, for example, if a plaintiff elected it and then decided to not do that, and then the defense was like, well, now I want it. I think you would probably run into a problem there, but I haven't seen any cases or any case orders about that specific scenario. Any other questions? All right. Again, I am around. I'll be here for the rest of the day. If you have any questions or if you would like any of the materials that I talked about, the trial orders, the jury instruction, that sort of thing, please email me, call me anytime. I'm happy to chat about this whenever you would like. So thank you so much for your attention.
Thank you, Ashley. That was great. And I meant to tell you, but I'll tell the other speakers, if someone in the audience asks a question, if you could repeat the question for all of our online viewers. I don't think they can hear the audience. So to kind of orient the online viewers on what the question is and try to repeat those. Our next speaker is Lloyd Bell. He is a good friend of mine. I have known him since we were very young lawyers, so long ago that when we went on a beach trip in 1999, I think, he was 30. And I was like, this is the oldest guy I've ever hung out with. But we were young attorneys then. I remember when he left a defense firm to go out on his own. I went to the first office, and it was this tiny little room in a small building in Midtown. And it has just been incredible over the last 25 years to watch Lloyd grow into one of the preeminent attorneys in not just Georgia, but the United States. And he did that through hard work and learning how to become good at his craft. I watched him in his younger years try small cases, and he just kept trying cases. If there's anything that will make you a better trial lawyer is to try cases. And now he's got record-setting verdicts year after year, the largest med mal verdict in history. Just last year, he had two more nine-figure verdicts, eight-figure verdicts. And it's just a record of consistency representing his clients and obtaining justice. In fact, I had a trial just a couple weeks ago. I leaned heavily on Lloyd to help me navigate these new rules. And so I asked him to come and speak with us today and share some of his wisdom on how he has been so successful in trying cases.
Setting up my
Lloyd Bell.
PowerPoint, I was getting a little concerned about where Rob was going with his storytelling from back in the 90s when we used to run around together. I was about to launch an objection if got things off track a little bit. But one thing is funny about us thinking about that first office, and I called it the Cinder Block Palace because it was about a 8-foot by 6-foot sort of cell is what it looked like. And you could see all the cinder blocks that had been painted. There was a tiny little window, and I could just see the sadness on my friends' faces when they come by to see me. Like, oh my gosh, you've got kids. What are we going to do? And all I could do is just work, as he said, just worked really hard. And I remember when I realized that my practice was going in the right direction when I had transitioned from doing soft tissue cases that only involved sprain to new ones that involve sprain and strain. I was like, I'm moving in the right direction here. These cases are getting better and better. But I'm going to talk this morning, I think, if my PowerPoint works out well, about some of the lessons I've learned over the past year, because it has been a year. Over the past 12 months, we've had 3 trials. 2 of the trials were successful, thank goodness. One of the trials was a mistrial. We had a juror, I think the term is sort of pejorative, but we had a quote, Karen on our jury who refused to be persuaded, refused to consider the evidence, and she locked the jury down for 3 days of deliberation. And I had one of the jurors on that trial join me on my podcast, which is kind of fun. And he sat down with me for about 2 hours, and I asked him every question I could think of that I wanted to ask a juror. That you sort of talk to him after trial's over. You have a few minutes to talk, but I did the deep dive. What are y'all talking about on the breaks? What are y'all talking about? When you go to lunch, how do y'all decide to go to lunch? When did you feel like you became close? All those questions you want to ask. And he told me that this one juror would not be persuaded, and they were very respectful, he said, and presented the evidence to her, and said, well, this is why we feel the way we do, and this is the evidence that we think supports us. What evidence do you have that makes you feel the way you do? And she's like, I don't have to tell you that. That's literally what she said. I don't have to tell you. It's my business, she said. And you can't tell me just that kind of thing. Anyway, so that was a hung jury. We're going to be trying that case again. But I do want to share some of what I've learned on the other cases, as well as the mistrial, because I've walked away with, I think, a clear view of things. And I talked to younger lawyers who are on the way up. Yeah.
I'm sorry.
First question.
I want to ask you a question about the drawer.
Yeah.
What happened in voir dire that you didn't catch you had a Karen? Tell me about that.
Well, it's tough to catch them all. I mean, they don't sit there and say, hey, I'm a Karen who's going to hang your jury. And we had 60 panel members. We had 2 hours to do our jury selection. And we didn't love her, but she gave us some answers that tilted her in our favor. And of course, you're always balancing the ones who are clearly going to be trouble, stinkers, as Adam's dad used to call them. But yeah, it was all very clear after the mistrial that we should have struck this person. It was not as clear at the time, but so I'm going to talk about these three trials and some of the lessons I've learned. So I'm going to start off sort of broadly and sort of shake things up, I think, on how a lot of folks approach trials. Because you're coming out of law school, and I went to Mercer, and I was proud of the school because they have such a strong trial emphasis. Trial lawyer, they have the headquarters for the National Criminal Defense Colleges there. So really good, experienced faculty who've actually tried cases. But I came out of it thinking that it was about the facts, or it was about the law, or the application of the facts to the law. And there's never a class, I never took a class in law school about psychology and really what motivates jurors and what moves jurors in trial, because facts don't do it and the law doesn't do it. And I learned through hard experience that, jumping up and down and yelling and, the pathos, that doesn't work for me either. But what I started realizing is that trials are about morality, and a trial is really not about the medicine. I do almost all medical malpractice now, so I'll speak in context of med mal, but I think it's broader than med mal. But trials are not about the medicine. Medicine is sort of the window dressing. Instead, trials are about morality, right and wrong. And what do I mean by that? When I think about a case being a moral case, I consider that every trial is a community answering a question. Okay, and it's a question that is a personal question to the jury, and it's structured around the morality of the case. And the medical care we want is, I don't know if y'all watch The Pit, it's my favorite show, with Noah Wiley. The medicine we want and that jurors expect is Robbie. I know you've got to be watching the show, Robin. Are you watching the show? Yeah. I mean, diligent, concerned, patient-oriented. That's what we want in our healthcare. We want somebody to take that level of ownership and concern. But sometimes what we get the arrogant, know-it-all, indifferent, judgmental Ogilvy. Now, I've got hope for Ogilvy if you watch the show that maybe he'll come around, and he's a young doctor. Maybe he'll get there. But there's an expectation that the jury has in terms of what we're going to get. And we come into these jury trials with certain kind of foundational baseline. Jurors expect, as we all do, that we're going to get good medical care, and that there's no higher moral imperative than delivering good health care. I mean, we're all in the healthcare system, whether we want to be or not. Our family is, our children are, we depend on ERs when our child has a fever or something, an insect bite, whatever it might be. So that's sort of our baseline going into this. But when healthcare providers deliver substandard care, it's not a mistake, it's not a bad day, it's not negligence, it is a moral failing, because we know that healthcare works in a system. And I was actually talking to my friend Adam about this yesterday, that our cases have to be presented as a system judgment, not as an individual providers having a bad day, because individual providers have a bad day. You know who else has bad days? Airline pilots have bad days. They have stomach flus. They have distractions. They go through bad divorces. And we would not tolerate airlines crashing and killing people because the pilot's having a bad day. What we expect is the system to anticipate the mistakes, the human failings that we all have, and engineer around those to create a safe system. So every case is a systems case at its core, and it is no excuse for, a doctor to say, I didn't look at the nurse's note, or this wasn't brought to my attention. That might be underlying the system failure, but the overall problem is a systems case, and that's a moral choice. What type of system we're going to have, and what type of system are we going to tolerate? So in these cases, you want to identify the moral failing in the case that led to the bad outcome. If it's just about a doctor making a mistake, if it's just about a nurse misreading a vital, much more forgivable, much more understandable to a jury, and doesn't have the moral weight So you want to look for the moral failing in your case, and that's how we approach our cases. And I think about the 7 deadly sins as a sort of a place to start. A couple of these typically don't have as much application. Lust. I mean, I guess I can imagine a fact pattern where lust is leading to a bad outcome, maybe distraction, maybe, inappropriate, interpersonal activity in a hospital. Typically not a major area. Gluttony, same thing. Maybe somebody's back at the, in the dining hall when they should be. I don't know. Typically not the 2 that I focus on. But the next 5 I certainly focus on. Greed. Okay, where do we see greed in medical malpractice cases? One of the great mythologies in our state, I'll just limit it to our state, is that hospitals are non-profit organizations. They are just there as members of the community to service our community. Well, under the law, they may be classified as nonprofit, but have not met an organization that acts more like a for-profit, predatory, aggressive, growth-oriented, wealth-acquiring oriented organizations than some of these healthcare companies. I mean, you see it all over town. You see new hospitals popping up. You see the big sort of Game of Thrones activities between the big hospital systems competing for high-value revenue patients, trying to discard low-value revenue patients. These hospitals all want practice patterns where they have stroke patients being funneled into their system because those are very high reimbursable patients that mean more revenue. They try to get rid of the psychiatric parts of the practice, the parts that are the internal medicine parts, the parts that don't pay as well. So greed is definitely something we look at. It doesn't always fit our fact pattern, but sometimes it does. Think of private equity. Why is private equity so interested in acquiring healthcare systems? I mean, private equity is only in the one business, which is profit maximizing. So I'm still trying to work out a way where I can introduce private equity involvement in some of my cases. And I think we'll get there because they're so prevalent. Sloth is another major one. Think about the doctor who is on call, the consultant who gets information about a patient that is in a critical state, a post-surgical patient who returns to the hospital with 10 out of 10 pain and swelling at the area of the surgical site. And the doctor who doesn't come in to see him. That's foreshadowing of one of the cases I'll talk about. But sloth in that sort of, in that human failing, if you're, my dad was a doctor, and I remember he hated being on call. I mean, nobody wants to be woken up at 3 a.m. and be pulled into the hospital on what you are sure is just a hysterical nurse who's not, who's just nervous about something. My dad used to kind of have that bias, and I got to think that hasn't gone away with other doctors who don't like to be pulled out of bed. But that's an area where jurors are unforgiving. If it's your job to take care of a patient, get out of bed, go see your patient. Wrath. How often have we seen this between doctors and nurses? Doctors taking out their problems on nurses or their anger, their frustration. I have a case I'm working on right now where a little girl came in with ant bites, anaphylactic shock. Doctor made the decision to intubate this little girl, even though she was fully oxygenated, she was crying, no reason to intubate her other than the doctor believed that was the thing to do, and then proceeds to sedate the little girl, which is what you do with an intubation, a rapid sequence intubation, and then realized she didn't have pediatric equipment. She didn't have the right tubes for this little girl, and her parents were literally feet away as the nurses were pulling drawers out, the doctors yelling at people, and there was a lot of wrath and other problems, and this little girl passed away in front of her parents. The media covered this case, and it's Baby Maya and Piedmont Eastside are the parties, are the 2 relevant parties. But anyway, that's where wrath and all kinds of problems can be demonstrated. Envy is another area. You'll see envy sometimes between residents, interns, And we have a number of cases that involve resident care where they're allowing young residents to take on too much responsibility. And then you'll see sometimes conflict between the residents and of course, pride. Pride is a major sin in medicine. And we tried a case this past, when was it? July. I tried it with my friend Natanya Brooks, I think is here somewhere. She's going to be, where's Natanya? There's Natanya. Anyway, and Natanya was a great asset in that case. And we dealt with a case of, where the doctors were just so full of themselves and feel like, well, I didn't need to talk to the other doctor. I knew what was going on, and that sort of level of pride. And in a case I tried this past December, where a dermatologist literally said, well, I could look at this thing on the side of your patient's face, of the patient's face, and I could tell to 100% certainty that it wasn't cancer. Really, 100% certainty, doctor? Yes. And no doubt in your mind, no doubt in my mind. And the next patient who comes in next week, under the same facts and circumstances, would you treat that patient the same way as you treated Tony? Absolutely. And you could just sort of feel the revulsion at that level of pride and ego. So you want to frame your case with the language of morality. You want to speak in terms of violation of trust, betrayal of trust, lack of respect. This last trial, that was a major theme in the case, is that they didn't respect the cancer, they didn't respect the patient, and guess what? They don't respect you, the jury. And that theme of lack of respect is very powerful. I try to stay away from personal conflicts with defense counsel. I don't like snippy defense counsel. I don't like, when I find myself snipping back, I try to protect that. And I think about it in terms of how's this looking to the jury? And if you think about it, if you go to a house party and the host and hostess may be back in the kitchen fighting about something, and you walk in on them and you see them, in a big fight, you don't care who's right. You just want to get away from it. It's like you sort of inch, like Homer Simpson kind of backing up away from the kitchen. I think jurors have the same reaction when they see lawyers fighting. Even if you are completely justified in some sense and you are, it's understandable why you're angry, do not make it about your opposing counsel, even when they're being really rude. And I'm not going to mention any names today, but there are a couple of defense lawyers that Adam and others who do med mal see a lot, and they are masters at pushing buttons and little jabs. And I tried a case with my good friend Laura Shamp, and we were up against 6 different defense firms, 6 different defendants. And the level of misogyny was unbelievable. And they would come over, it was all male lead counsel on the defense side, and they would come over to the table. They wouldn't talk to Laura, who's been working this case for years. They would try to avoid Laura and just try to direct talk to me. And it was like that scene in The Godfather. It's like, no. She's in charge of this. You talk to her. But that kind of button pushing. And to Laura's credit, she never responded to it. And I asked her how she kept so cool. And she's like, I don't care. She just kept her baseline, stayed focused on the case, and didn't let that kind of stuff come in. And it was pretty impressive. Other moral themes, profits over patients. I mean, it sounds tired to our ears. It doesn't to jurors. If the facts fit that framework, that's a very, very powerful frame. Years ago, I had a nursing home case, and one of my neighbors, our kids were friends, and we got to be pretty good friends, was in-house counsel for one of the major national nursing home chains. And I had my first nursing home case, and I was like, hey, it's not against your client. Would you mind having lunch with me? Let's make sure I'm on the right track and give me some help or some advice. And we went to lunch, and I said, what are the most powerful themes you've seen that really move a jury in these cases? And he goes, the same theme: profits over patients. It's always about staffing. It's always about the budget choices that we make, and that's where the defense attacks, and it's effective. So I think that has resonance. So I like to think of trials as moral verdicts that are disguised as legal ones. And the core moral questions that juries answer is, was this outcome preventable? I try to get away from the framework of everything's standard of care. was it preventable? Was this inevitable? Was it preventable? And defense lawyers really lean in heavily to, this was out of our hands. This was going to happen no matter what. Did the defendants take this seriously enough? One area to really explore is to try and get the contemporaneous messages, emails, text messages, mostly text messages from the providers. And that'll tell you kind of how they saw things in the moment, not after they got lawyered up. We always try to get they're the equivalent of 911 calls when a patient is transferred from one facility to another, or when ER doctor wants to consult with an outside consultant. Those communications are recorded. You want to get them because the way they talk and sound to each other is very different a lot of times than how they present in court and what they remember in court. So did they take it seriously? Did they act, or did they just wait around and just hope things would be okay? Were they proactive or were they reactive? Did they listen to the warnings from the other providers? I have had more doctors say they don't review nurses' notes because they're doctors. Why would they review nurses' notes? Well, the nurses' notes they're the ones in triage who are getting the information directly from the patient early, or from the patient's representative. And when jurors hear a doctor say, well, I didn't need to look at the nurse's notes because I was going to do my own evaluation or my own examination. Well, doctor, you're doing an examination later in time than the nurses did. And sometimes medical care or medical conditions change over time. So you're not examining the patient at the same time as the nurse. You're examining the patient later and the nurse earlier. So do you understand how there could be different information, that kind of thing? And that's a moral point, and it goes to pride and ego, and it does not sit well with jurors. Do they protect somebody who's vulnerable? This is a big one. You got to be careful with it. But the little girl who was discharged, another case of mine. I'll move to a different case where a young woman came in, little 15-year-old girl with a distended abdomen, hadn't had a bowel movement in 3 weeks. At the ER, the doctor confirmed she had a bowel obstruction or had a impaction. Couldn't remove it digitally, tried, couldn't do it. Her pain went from a 2 out of 10 when she got there to a 10 out of 10. They sent this little girl home with a 10 out of 10, tachycardia, high heart rate, and a confirmed bowel obstruction, distended, firm abdomen. They sent her home. And a young African-American girl who was on Medicaid. And this doctor sent her home. And predictably, 2 days later, her colon blew up at the cecum, which is the high part of the large intestine. And she got septic. They had to take out her entire colon to try to save her life. Were unsuccessful. She went into cardiac arrest and she died. And if you don't think that it's going to resonate in a DeKalb County jury, how this young girl was treated, how her family was treated, and I will ask the question at some point in a way that's appropriate for the moment, I hope, that would this have happened if to somebody else? Would it have happened to somebody who looks like me? Would it happen to my child? Why was this little girl sent home? Who sends anybody home where their pain has gone from 2 out of 10 to 10 out of 10? And those are moral questions. And I won't answer them, but I'll raise the question rhetorically, and the jury will hopefully answer in their verdict. Do they own responsibility? They push it away. The morality, the moral choices don't end or don't begin and end with the treatment. The moral choices continue through the trial. And we bring that up, that the doctors continue to make these choices to refuse accountability, to not acknowledge the plain facts, and their duty to their patient continues beyond just when they're under their care at the hospital. Their duty continues through depositions, through trial, and if they're not going to be honest and show the respect in court, then you need to get through to them. Was the response appropriate once the danger appeared? So I'm going to talk about some of the defenses I hear a lot. I know Adam hears these. I know Natanya, anybody who does medical malpractice hears these defenses. And there's they can resonate if they're not responded to appropriately. The known complication, this was a known complication, a known risk, things happen. Medicine is as much of an art as it is a science. I've heard that one before. And this was a judgment call. Robin, you ever heard of that defense where a doctor says, this was a judgment call all the time? I mean, that's their favorite one. Well, there's a thing called good judgment and bad judgment. And then of course the medicine is hard. We'll talk about that. But we'll talk about the judgment call. Yeah, it's a judgment call when you're had 6 martinis at the lawyer's club and you're deciding whether you want to drive back to your home in Sandy Springs. I mean, that's a judgment call. Sure it is. It's a judgment call when you're driving through the countryside and you see a train coming at the crossing and you think you can make it if you just go a little bit faster. I mean, that's a judgment call. And I'll use examples like that with the jury. These are all judgment calls. But would we tolerate that? Would we tolerate a pilot getting onto a Delta airline jet and in their judgment thinking that since they've only had a few drinks, they'll be okay to fly? Of course not. Would we tolerate a doctor making a judgment to send a little girl home when he knows she's in 10 out of 10 pain and she has an obstruction in her bowel? That's a judgment call, but it's horrific judgment. And it's your job as jurors to speak to that, whether that judgment is acceptable in our community and whether you are going to allow that judgment in this community, those kinds of approaches. So the known complication, this is sort of a misdirection defense. They try to say, well, it's a known complication. And then sometimes you get pulled into fighting. Well, is it a known complication? And you're talking all about this complication. It's really not the complication as much as the response to the complication that matters. And yes, there are complications. Infection happens, dehiscence or sutures can rupture. I mean, things can happen. Yes, but it's the response that matters and that needs to be examined. So you want to concede the complication, but shift the moral focus. Okay, well, doctor, going into this procedure, did you realize that this was a potential complication or this was a potential complication? Yes, 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 yes. So since you realized that going in that these things could happen, you would agree that the right thing to do, the standard of care, but the right thing to do is to be on alert for these things that could happen. Well, yes. And it's no excuse to say, well, it's just a complication. Your job is to manage those complications and to respond to it. And that's what, taking care of a patient, and I love the analogy of an airline because it works on a lot of different levels. And this particularly works during a surgical situation. And say, well, doctor, caring for a patient in surgery is sort of like an airline pilot. There are 3 parts to it. There's the preparation for takeoff. That's the preoperative phase where you make sure the patient's vitals are good, their medications are appropriate for the doing, and you try to make it as safe as possible going into the procedure. Just like a pilot goes through a checklist, just like a pilot makes sure that they're haven't been drinking for 24 hours or more. There's that part. Then there's the surgery, which is the flight. And your job is to get the patient safely through that flight, because there's no place where a human being is more vulnerable than when they are sitting in an aluminum tube back on 42D and a pilot's flying. You have absolutely no control over anything related to that flight. Just like a patient under general anesthesia, they are completely dependent on you. They've placed all their trust in you. But then there's also a third part, and the third part is to make sure once the plane lands that the patient safely gets through the landing, safely off the aircraft and on their way. And that's the post-surgical part, the PACU, the post-anesthesia area. And they'll agree with all that. And then you put it in terms that the jury can really relate to. It's like, well, yeah, okay, they've landed, but if there's the jetway is not working properly or the door's jammed, the bad things that can happen. And your job, doctor, is to see the patient through all of those things and shift the moral focus. So when there is a problem, like a complication, your moral responsibility, and I'll talk like that in trial, not so much in depositions because it just creates a hailstorm of objections, but in trial, I'll talk about that. Your responsibility under the standard of care is to do this. Your moral responsibility is to do this. The patient expects you to do this. The patient trusts you to do this, and try to frame it in the moral language. So it's not about how the case started, it's about how they responded when it worsened. And since you know this complication is foreseeable, you have a moral responsibility to be on the lookout for it and to respond to it if it presents itself. The known risk is another one. Yes, it's sort of like a known complication, but the risk of a procedure, of course, and it requires knowing what the precautions are to minimize those risks. I talked about judgment call, and this is, I think, the most effective one I've seen defense lawyers raise. And I tried a case, I tried the same case 4 times. Anybody ever tried a case 4 times? It's a joy. You really get to know that case. But I tried it 4 times. And the first time I tried the case was against John Peters. I know a lot of folks know John Peters, former judge. And he did something I'd never seen done. It was very effective, unfortunately. He had my expert on the stand, and John has this sort of solidly disarming demeanor. And he says, doctor, doctors, there's a lot of doctors disagree and have different opinions about things. That's normal, isn't it? And to ask in that kind of voice that my expert felt like he couldn't say no. You're like, well, yeah, people have difference of opinions, and you're here to talk about your opinions, right? And Dr. Johnson on my side, he's got his opinions, right? And people just have disagreements of opinions, and then he spends 15 minutes, it seemed like, talking about disagreements of opinions. And by the end of it, I was kind of agreeing with him. Maybe we should all go home. It was just a big difference of opinion. But my expert, and this is on me, I hadn't prepared my expert as well as I should have on that point. I do now. But what he should have said is, no, I completely disagree. There are some things where there can be a difference of opinion. There are other areas where there is no difference of opinion, no reasonable difference. There's no basis for, there's no difference of opinion that a surgeon has to scrub in before surgery, or that a surgeon cannot reuse a scalpel from one patient to the next. There is zero disagreement. And then bring it back to our case, and there is zero disagreement that if a patient has a tumor with high-risk features, the patient must be told about it, and the patient must be advised to at least get a consult for radiation oncology. So that little trap that John set, which fortunately that case ended up in a mistrial because we learned that they had hidden a record from us, and that cleared a mistrial. Then we tried it a second time on the limited issue of whether that was fraudulent concealment as to told the statute. We won that issue. We tried it a third time. They brought a new judge in, one of the senior judges, won't mention her name, but didn't go well, got a defense verdict, got it reversed on a new trial motion, tried it a 4th time, and the 4th time was the charm, and we got a good verdict this past December. I'll talk about that case in a minute. Yeah.
On the judgment call issue, you may want to take a clip from ESPN, today's Sports Center.
Okay.
Major League Baseball this year, they have, if you tap your helmet, you can question whether it was a ball or a strike because they have the box. There was a pitch, and it was in the Milwaukee-Tampa Bay game last night, and it was way outside the strike zone. It was high. The guy tapped his helmet. They reviewed it. They reversed it. The umpire, and you never see this from an umpire, and you certainly never see it from a defendant, as he was stepping back behind the plate, you can read his lips, and he said, "That wasn't even close." How many times have you had a defendant say that in their closing argument?
Right. I know I'm supposed to repeat the question, but I'm not going to try to repeat all that. Yeah, I mean, you make a couple of really good points. I mean, if there's an opportunity to bring a judgment call example from the real world into the courtroom, that can be very effective. I mean, I was thinking about, the UConn Duke game. I mean, there was a judgment. I know Robin was loving that because Duke did the same thing to Kentucky back in '92, I think. But that last second shot, it was a judgment call to throw the ball,
Right.
Really bad judgment. And the guy should just held on to it. No way the game could be lost at that point. But yeah, I think those are good examples. But it's not freedom, it's responsibility within limits. And judgment has to be informed with data, with evidence. It can't just be a doctor's after the fact rationale for why they made bad choices. So you want to distinguish between good judgment and bad judgment informed by moral choice. And talk more about that. And I've used the example of a car racing across a train track as a bad call. And this is a framework I use, which I think is very effective when you have credible competing experts credibly advancing what they regard as the standard of care. And how do you break the tie? And I think this question works well. I'll ask the jury in closing, I'll say, when you decide which version of the standard of care is the correct one, ask yourselves, which proposed standard of care best protects the patients or best protects the doctors from responsibility? And always the standard of care we're advancing is the one that protects patients. A doctor comes in, a consult comes in to see a patient under these circumstances. A doctor orders this test when a patient is leaking out abnormally large volumes of chyle fluid, for example. And that lands because it's true, and it resonates. And the standard of care that's offered by the defense is always one of excuse and forgiveness and sort of accommodation, and it's not one that is meant to help a patient. So the complexity, we get this a lot. There was a defense lawyer years ago who was very effective in videotaping surgeries and then bringing the videotapes in and basically arguing, look how complicated this is. I mean, who could get this right? And that can be effective. So you got to be mindful of that. But the idea that medicine is hard, well, that's why you go to school, and that's why you study and pay attention. And but there are different ways to combat it. And if it was easy, I wouldn't need to go see a doctor. I go see somebody else. But because it's complex, just like flying a plane is complex. Flying these big jets with all the radar and flight patterns, all that kind of stuff. Yeah, these things are hard. And we don't have any choice ourselves but to place our trust in you. And we expect you to know what to do. And this ties into another moral theme that I'll use a lot, which is know your limits. And that's one that really resonates with jurors. And doctors will admit it. Doctor, you agree that no practitioner, no doctor can know everything. No person can know everything in whatever the field might be. I'm a lawyer. There's no way I could ever know all the law that's out there. But part of your responsibility to your patient and part of your moral responsibility is to be honest with yourself and know what you know and know what you don't know. And if medicine gets hard, and this is an area that's complicated and an area that is challenging or might be beyond your scope, it's your responsibility to know that and to ask for help. And we certainly have to do it as lawyers. If we don't know something, we've got to ask for help and figure it out. In this case, you didn't ask for help. In this case, you didn't call the consuls. In this case, the hospital provides a whole list of available consults for you to call. And all you have to do is tell the nurse or the staff to get somebody on the phone. You didn't do that. It can be an effective rebuttal to that. So 3 trials. I'm mindful of my time, so I'll try to be efficient. 3 trials in the past year. The first one was actually the Jenkins. He was a little bit out of order, but this is the case of Glenda Yarborough as the surviving spouse of Ron Yarborough. And this is a case Natanya and I tried together this past July. And everybody who's lived in Georgia for any length of time knows a Ron Yarborough. He would describe himself as a good old boy, loves to fish, loves to hunt. You can see his hat. He does nothing more important than Georgia football in the fall to him. Family, all that, of course, but he loves Georgia football. And like a lot of people his age, he was a career letter carrier, I think is the right way to say it. Worked at the post office and retired and was looking forward to spending his life, his retirement years with his beautiful family, his wife Glenda that he had been married to for almost, I think, over 50 years maybe, or close to, and children, 2 kids and their grandkids. So had all this expectation and things to look forward to in his life. And in this case, Ron had been under the care of a cardiologist for many years, had never had anything significant. He had been checked out. His tests were all fine, but not the best diet, probably too much good food, Southern food, and just a little bit of cholesterol issue he took medicine for. Pretty basic profile that probably fit 90% of our jurors, at least 90% of our male jurors. But he goes in to see his cardiologist, Dr. Friedland. He had been under his care for many years, 3 decades actually. Dr. Friedland practices in a large group, cardiovascular group of Georgia. He goes in to see his doctor, does all the physical work, listens to his heart, and Ron's doing great. No issues. His vitals are all good. No complaints of symptoms. They says, you know what, just to be safe, let's do what's called a CT calcium test. Show of hands, anybody know what a CT calcium is? Okay, yeah, a few hands. It's basically a CT of the heart, and you look at the heart blood vessels, and what you're looking for is if there's any gunk inside the vessels that might impede or impact blood flow. And you don't want to have impacted blood flow in your heart because your heart needs all that blood and the oxygen to work properly. So he orders this test, it's a simple test. If you pay out of pocket, it's like $120. Public service announcement, I'd recommend everybody get one. It's a cheap, easy test, and it'll let you know how your pipes are doing in your heart. They send Ron, he goes into the donut, gets the test, doesn't think there's any big deal, and the radiology report comes back maybe the next day, and the radiology report shows that he's got high numbers, and this is not a test that you want a high score on. It's not like the SAT or the LSAT. This is one you want a big fat 0. And he did not have that. He had a big number. He had a 469 in what's called the LAD, or the left anterior descending. It's affectionately known as the widowmaker artery, because you can imagine why. If it gets clogged up, it can be a really bad outcome. So he had a high number. His overall score was bad too, because he had buildup of plaque in his other arteries, some of his other arteries. And the radiology report told him what it meant, or stated what it meant, and said that a calcium score this high corresponds with extensive atherosclerotic plaque, and that there is a high likelihood of at least one significant coronary narrowing. My obsessive compulsive is annoying me. This got translated from Keynote into PowerPoint, but typically I'd have the text centered, but it doesn't matter. You can read it. So this was the result that came back. And just to kind of give you an idea, if you have 0, the pipe's clean, no buildup, think of the pipe in your kitchen or your bathroom upstairs, water flows through it fine, it gets clogged up with hair or whatever, it gets clogged, you get a big score like Ron did of over 400, at 469, you can see how much junk is in the pipes. And that's how we talk to the juries about it. With the jury about it, it's just, junk in the pipe. And you get your pipe clogged up in your upstairs bathroom, and the water's running, that's a real problem. And you turn the water off, of course, and you clear that pipe out. Well, you can't turn the water off or the blood off in your body. So you get a clogged up pipe. Just like in your bathroom, if the water's running, you can't turn the water off, really bad things are going to happen. Really bad things are going to happen in your body if that pipe gets turned off. And this was what Ron was facing, this with his high calcium score. So 4 days later, these reports get sent to cardiovascular group. They have their own internal text messaging. And this is maybe this is a takeaway that I hope will be useful in your practices, is in every case, just be thinking text messages, because everybody's texting. People don't really email anymore, I don't think, at least not as much. That's more formal now. Email used to be the informal, but everybody's texting. And I mean, how many people have been texting here during this presentation? I mean, people text, doctors text. And what I came to appreciate in this case is clinicians text within the practices, and they have systems set up to text. And you'd think, well, why not just talk to each other? And that's just not how the systems work anymore. And in this case, these are their internal text messages through their electronic record system. And this was, so the report came back to the group. Dr. Friedland reviewed the report, and this is Dr. Friedland's text message to his nurse, Susie, telling her what to do. And he says, call the patient with the test results, and here's what I want you to tell them. And he kind of lays it out and says, that if there are no cardiac symptoms, there's no need to do a stress test, which is put him up on the treadmill and get his heart rate up and take a look. So does nurse Susie Clark call like she was told, or does she get somebody else to call? And the answer is no. Instead, nobody in the group calls the patient, but instead she sends a letter. And this was a templated letter, form letter that they use when the results are all normal. And then they kind of pick and choose what to add in the letter. And in this letter sent to Ron, it says your recent coronary score was reviewed by Dr. Friedland. It showed no significant calcification in the arteries leading to the heart, and said that if you're not having any symptoms or problems, there's no need to do a stress test, and says no need to do a test this year. The defense actually argued that other than the word no, this letter was 100% accurate. I mean, the jury had a similar reaction. It's like, you got to be kidding. It's like, I mean, you know, there are plenty of examples of where one word can make a difference. You know, you have cancer, you don't have cancer, you are pregnant, you are not pregnant. And I had some fun making that point, but it's such an absurd defense, and I was sort of surprised they made it. But this was the moral failing of this hospital. Nobody had seen this letter. The doctor hadn't taken the time to review it. So if you're thinking back on the sort of the 7 deadly sins, you know, one of them is greed, right? So I argued that this was set up, and so this practice was set up in such a way as to maximize patient volume, you know, to maximize, you know, push people through the pipeline, you know, as quickly as possible. And you know, why didn't you take the time to, how long would it take you, Dr. Friedland, to look at this letter and to make sure it was 100% accurate? I mean, this was your patient for 30 years. I mean, if you're not going to take the time to take care of that patient, you know, what does that say? You know, why didn't you do that? And then he pushed back and said, well, if I reviewed every letter, I would never see patients or something like that. And that didn't sit well. It's like, that's your responsibility to take care of patients. And if you can't take care of your patients the way they need to be taken care of, you know, you need to have fewer patients. You maybe refer out to other practice groups or add more doctors if you want to do that. But it had a lot of moral components to it. First of all, the nurse not doing what the doctor said, the doctor not reviewing the letter, but this is what happened. And Ron thought his heart was fine and his test was fine, and it was not. So now he's got these ticking time bombs in his chest, and he doesn't know about it. He's going about life just, you know, thinking things are fine. 6 months later, Ron has stomach problem, goes to the ED. ED takes a look at his stomach. He's got a mass in his stomach. It's not obstructing his bowel, but it's there, and they recommend a colonoscopy. And the colonoscopy comes back, and it shows that this mass is likely not cancer because they do a little bit of a biopsy, but it could be, and it needs to come out. And it's an elective procedure. It's not blocking anything, but it's there, and you don't want to keep it there. So the doctor sends Ron to see this colorectal surgeon, Dr. Venkatesh. And, you know, the one thing surgeons love more than anything in the world is to cut. I mean, it's like the hammer and the nail. And the world, you know, to the hammer world, everything looks like a nail. To a surgeon, I'm being a little facetious, but they lean toward surgery because they see how surgery works with their patients. And that's what Dr. Venkatesh recommended. He said, you need surgery. And he did a history. Ron said, they asked him how his heart was doing. He said, oh, my heart's fine. I'm under the care of a cardiologist, no problem. And so Dr. Venkatesh accepted that and did not send Ron for cardiac clearance, or did not even pick up the phone to call the cardiologist and say, hey, I've got your patient here. I'm about to undertake major surgery. How's his heart doing? You know, rather than rely on the word or the representation of the patient, he never bothered to call the doctor. That brought in the moral components of laziness, of sloth. You know, why not call? I mean, everybody calls nowadays. You've got your cell phone with you probably 24/7 within arm's reach. Why not or at least have the nurse call and say, hey, we're thinking about this surgery. And there's no good answer to that, but he insisted that he didn't need to call and that it was reasonable to rely on his patient. So fast forward, surgery, as you can imagine, you probably have already predicted, surgery went fine, but during the days of the recovery, Ron started throwing off enzymes, which happens when heart tissue dies and they go into the bloodstream, and it means that it can mean you're having a heart attack, and that's what it meant in Ron's case. Now they sent Ron to do the testing they should have done in the first place, and they took a look at his LAD. This diagram is of the left anterior descending, and all that sort of marked up space is clot that they see in this coronary artery exam they did. And the area of the LAD, this part of the branch, 95% blocked. And if you recall, the specific part of the LAD is 469, and predictably, that what was known 6 months earlier from the CT calcium was reflected in this evaluation that was done after Ron's heart attack. Too little, too late. And this is a illustration that we had made by a really good company called Fox AE, and Cody Phillips, I think his name is, put this together. And on the right are the imaging study. That's the coronary artery evaluation where they put dye and they inject into it. But this is actually Ron's LAD, and this is what's cool about this illustration. As you can see, the little X or the square shows the place where the blockage was, 95%. And then on the diagram to the left, you can see how it corresponds to they call the proximal part of the LAD, or the part closest to the body. And that's a problem, because that's the difference between having a blockage in the Mississippi River, up in Illinois versus, down in Louisiana. The further north, further up, and then all the area that's affected downstream gets affected. So we have a 95% blockage, this little time bomb ticking up there at the top of Ron's heart. And then, so the jury can keep track of the language we have down at the bottom left anterior descending, so they can sort of keep track of what all these things are. But that wasn't the only blockage. This illustration, or this angiogram study, showed another blockage at what's called the ramus artery, and that was 90% blocked. That wasn't the last blockage. The third blockage, also 90%. This is a diagonal branch of the LAD further down. You can see it illustrated on the heart. A fourth blockage, 90% blockage. Each one of these blockages representing a ticking time bomb independent of the others. Any one of these could lead to heart attack. 90% blockage at the diagonal branch of the LAD. That's not the only one. There's a 50% blockage of the circumflex artery you can see here. And a sixth blockage at 90% also of the circumflex, further down the heart. So Ron's heart was blocked up more than what I would say now would be the Strait of Hormuz, maybe, but completely blocked up. Nothing, this is at risk of anything trying to get through. And as each one of these, when you get an opportunity where you can stack up violations or stack up dangers like this, it just has such a strong impact on the jury. I could feel the jury's response. And they saw this, and they're like, and all of this was preventable if only the doctor had brought Ron back in to take a look at his heart on the stress test. And then that would have led to this evaluation and all of this. And everybody agreed that this would have been present for during all the relevant periods of time. I turned this into a board. This became one of our maybe 3 anchor boards. I use a lot of PowerPoint or Keynote at different parts of the trial, but I always prefer to have like 3 or 4 anchor boards that I can just keep going back to, because you can imagine putting this board up on a tripod with a defense expert and is saying, doctor, this is accurate. This was what's shown in the study on this date. This was present when this study was done, right? And this would have likely been present 6 months earlier when Ron had his CT calcium, right? Number 2, right? Yes. Number 3, that was also present. That would have been visible. 4 would have been visible. 5 would have been visible. 6 would have been visible. All of this was possible. And if this had been appreciated and investigated by his doctors 6 months earlier, there certainly would have been a response. Medical treatment, medications, possible bypass, but this patient does not go to surgery for major abdominal surgery until he is safe to do so. And it was those kind of points really landed because the evidence supported it. Ron spent 36 days in the hospital. Looked like he was going to recover at different points, and then he would go back in the wrong direction. And eventually they had to put him on a ventilator, and his family was there surrounded by his grandchildren, and he passed away and died from his injuries. So the trial was about the 36 days that Ron had of pain and suffering. And I didn't hear all of Ashley's talk on bifurcation, but we're concerned obviously about what's going to happen with possible cap being reimposed on medical malpractice death cases. So I wasn't sure what the state of the law would be, but I don't think it's going to affect pain and suffering claims. We'll see. But we focused on pain and suffering, and the jury returned a verdict for $12 million for his pain and suffering, gave us his medical bills, and then $4.5 million for his wrongful death. And this was a case they had offered zero going into trial, and I think they offered $2 million during trial, something like that.
Can you repeat that again? I'm sorry. The numbers that you just gave us?
For the pain and suffering, and Natalia's going to fact check me here. I think it was $12 million for the pain and suffering, 1.7 for the medical bills, and 4.5 for the wrongful death, 4.6 for the wrongful death.
Thank you.
Yeah. So we put, we put the moral failing, too busy to care, prioritizing patient volume, those types of things. But the moral failing doesn't end, as I mentioned earlier, with the actual medical care at issue. It's how they responded when they learned of the outcome. Did they call the family to express their condolences? Did they go back into the record and start adding things to buttress their defense? We see that a lot. And where they, after a bad outcome, you'll get the audit trails and the version history reports, which are really important in medical cases, and see that the doctor is already working on their defense after a bad outcome. That doesn't sit well with jurors. Refusing to accept accountability, and then protecting their colleagues rather than their patient. So Ron didn't need everyone watching, but he needed someone to care enough to act. And that means making a phone call, reviewing a letter, from the nursing point of view, checking the letter to make sure it's accurate, those types of things. Okay, I don't know what's going on here. There we go. Let me catch up to it. So was it preventable? These are the core moral questions. Yes. Did they take this seriously enough? No. Did they act, or did they wait and hope? They just ignored his situation. They didn't listen to the warnings. They didn't make the phone call. They didn't protect somebody who had put all of his trust, and not just him placing his trust, but the trust of his family and his children and his grandchildren. A little bit, I come close on time here, so I'm going to finish up. And the moral frame, that judgment lives inside the rules, red flags limit discretion, and experience increases responsibility. So sometimes we'll get these doctors who will talk about, well, I've been doing this for 30, 35 years, 40 years. We'll turn that and say, well, you have been doing this a long time. And your patient, my client, realized that and came to you in part because of all of your experience. And experience gives you a higher moral responsibility to take care of your patient. You're not coming right out of medical school. You're not a PGY 3. You're a 40-year doctor. And that means that you have a greater responsibility, a moral responsibility to follow the standard of care. Would you agree, doctor? And constantly reminding juries that this is about a morality play. Real quickly on this other case, this is the one that we're going to retry. I'll just real briefly, I won't play that because that'll take a little while. But basically, this was this was a patient who had neck surgery, laminectomy surgery, developed a post-surgical hematoma, a large collection of fluid over the surgical site on the back of his neck. Went to see his surgeon on about 2 weeks after surgery. Everything looked good. He was not having any particular pain. Healing looked good. Patient gets home. After he gets home, he starts feeling extreme pain in his neck. So bad, they called an ambulance to take him to the hospital. Gets to the hospital, ER doctor calls the surgeon, says, hey, your patient's here, 10 out of 10 pain. His neck is swollen over the surgical site. What do you want to do? Surgeon says, give him pain medication. Don't see him tomorrow. Do not do any imaging studies, the surgeon says. He doesn't need any imaging. I saw him earlier today. He looked fine to me. Just make him comfortable. I'll come see him in the morning. Well, this is how Tim developed when this hematoma that was left unappreciated grew and grew and grew until it compressed his spinal cord and led him to be a quadriplegic. And the surgeon insists that he followed the standard of care. And there was no reason for him to come in because he had just seen the patient and he could use his judgment to determine that the patient was just fine. And obviously that case is proceeding. We've settled with the ER doctor, but the surgeon from Polaris, formerly with Polaris, and the radiologist who, interestingly, the ER doctor, when the surgeon said, don't do the evaluation, the ER doctor said, okay, hangs up, and then orders an imaging study. And I was like, that's the kind of ER doctor you want, right? Then the ER doctor orders the imaging study, radiologist reads it, and has testified, this was the largest hematoma I've ever seen in my career. Well, did you call it? Did you call the ER doctor and let him know? No, I didn't do that. I put it in the report, and I uploaded the report, so it was available. He could have looked at it. Well, he didn't look at it. And the ER doctor said that, well, if it was bad, I figured he would have called me. So, I mean, I'm laughing because it's just so horrible, this care. I mean, so all kinds of moral failing. I mean, the arrogance, the assumptions, the lack of communication, and then to continue to defend that even in the face of this horrible outcome to an absolutely wonderful man is immoral. And at its core, it is an immoral view of their role as physicians. And this is the case that ended up in a mistrial because of one juror who I believe really what was going on is I believe she just bonded in some sense with one of the doctors, because these are very charming doctors. You know Dr. Stoyer, Adam. I mean, he's a very, very impressive, very charming human. And he got through to this doctor, but hopefully we'll get a jury that sees it differently next time.
Hang the jury?
Huh?
That juror hang the jury?
She did. She did. 3 days of deliberation. 3 days deliberation. Yeah. It was what stands out. I'll just leave you with this because I'm out of time. But what stands out about that trial is y'all probably remember last year we had that weird snowstorm that came in and kind of shut things down for a couple of days. Well, the jury had been qualified for 2 weeks of trial, and with the snow days that pushed us off schedule, and it was clearly going to run into maybe Monday, maybe Tuesday of the next week. And the judge got all the jurors and the lawyers on a Zoom, fully expecting to declare a mistrial because of the weather and the delay. And she went through each juror, and she was almost it seemed to me a little bit that she was almost inviting them or giving them a clear path to get out. And each juror said that they're going to make it back. And one juror said, I'm not going to miss it, is what one juror said. And then, I was like, I could hear Rocky music in the background. These jurors are going to make it to court, but they wanted to finish the job. They wanted to see the rest of the story. They probably wanted to talk to each other. But there was one juror in particular, and she told the judge, she goes, Judge, I live on top of this hill, high driveway. She goes, I just looked outside. My driveway is completely iced over. And the judge almost let her and said, well, so that would probably make it unsafe for you to come to court on Monday. And she goes, oh no. She goes, I'll walk down the driveway. I've got a friend who's going to come pick me up. I've already arranged it. So it kind of restores your faith in humanity sometimes. But the last thing I would just leave you with, because I'm out of time, is consider your case as a moral vehicle. I like to tell juries that the reason we draw jurors from our community is because that makes them our neighbors. You know, everybody here lives in Fulton County or Cobb, whatever, and we're all neighbors. And we're here to decide a problem and to decide what the values that this community are going to accept and what they're not going to accept, what is right and what is wrong. And you are the folks who are going to decide that ultimately. And after you consider all the evidence, you're going to decide if this is the kind of care that we are going to accept in our community. And that framing, I think, has worked really well. So, if some questions.
Lloyd, great talk. What's the biggest challenge you face from SB 68?
The biggest challenge, it's not, I thought it'd be more challenging than it has been, frankly. I was concerned about not being able to speak about non-economic damages in jury selection, because that's always been a part of my jury selection, to talk about big numbers and people's comfort with big numbers. And I was concerned that that would be a bigger issue. I don't think it has been. I have a theory, completely unproven, unsupported by the data, but my theory is that when you start talking to the jury about their ability to return a verdict for a significant number, and we're going to ask you for a very significant number that will be supported by the evidence and that will respect what has been taken from our client. I always speak in terms of what's been taken, not and what they've, quote, lost. We're going to ask you to return us to a significant verdict. Is there a number in your head right now that you think is a number that beyond which you just can't go, no matter what the evidence is? And I've only, of course, had a couple of trials with this, but I believe that they imagine numbers bigger than I'm imagining. You know, just the way the world is and the huge numbers that are put out in the news all the time in different contexts. I think they're kind of surprised sometimes that I'm not asking for more than I am. So I haven't seen the negative effect on that. And I think, I don't know if this was talked about by Ashley earlier, but I think bifurcation is our friend in medical cases particularly.
Good.
Yeah. I think putting all that focus on the defendant's conduct and cabining off all the emotional component of damages, I think is to our advantage, because I think it lessens the discord in the jury's mind. Well, I don't know what's the right thing on the doctor, on the medicine. I don't know. You know, I feel bad for the family. I think it simplifies that and focuses them in a positive way. Any other questions? Well, thank you all very much.
Thanks, Lloyd. That was an incredible presentation. I wish we could have had more time to hear about those other two. I'm sure Lloyd would be glad to talk to you if you want to hear more about those. In fact, nowadays, a lot more of these bigger cases are available online through various companies. And I watched part of the Yarborough case, and something that I'll never forget is Lloyd spent, it must have been 10 minutes cross-examining the defendant doctor. And it was the same slide you saw, trying to get him to agree that more likely than not, this patient would have received medical care for those blockages. And this doctor tried everything he could do to not answer the question, but Lloyd was relentless. And eventually, despite objections and everything else, the doctor conceded that his own, which he should have, that his own patient would have received medical treatment for these blockages. And that patient was not a candidate for surgery. And I think that's just goes to the fortitude of being a good trial lawyer, not to give up on an answer that you know is the truth. We're going to take a 10-minute break. We'll come back around 10:55 and we'll restart. All right, let's get started. My fault for going a little over on the break. We'll give Natanya extra 5 minutes. Our next speaker is Natanya Brooks. I've had the pleasure of getting to know her over the last few years. And I think she has had a meteoric rise from starting her plaintiff's firm to now as a solo practitioner to now having 8 or 10 attorneys and dozens of staff. And she is just a devoted, incredible lawyer representing the rights of those that have been injured. And one of the things that I've realized is Natanya is incredibly gifted at telling the client's story and finding out how to present the damages part. Sometimes, you know, we all focus on liability so much, trying to win the liability. We just think the damages might tell, the story might tell itself. And I've learned from her that's not necessarily the case. You've got to find the way to tell your client's story. I contacted her before my last trial and really benefited from her guidance on how to portray what my client and his family had gone through. And so I asked Natanya to come talk to us. She was also involved in Lloyd's trial, or it was her case, I think. But I hope that you can learn as much as I did from her about how to tell your client's story. Natanya Brooks.
Thanks, Rob. I am excited to be here today to talk about damages. I am going to talk about the trial that Lloyd just talked about. He focused on liability, I focus on damages, but my goal today is to give 13 tips that you can use in any of your cases. So he already talked about the case a little bit, the verdict. There was apportionment. This is the verdict form. So the jury ended up needing to look at two different doctors. And one really interesting thing that we did that I'd never done before was to file a Rule 22 motion that allowed us to have our own videographer present at the trial. So Taylor, who's sitting right up here, she was able to video this entire trial for our firm so that we could go back and watch it. We used the video when we were getting ready for closing, because sometimes you forget what actually came in on the witnesses. You get a little bit confused. You don't go exactly by your outline. So we used our own video throughout trial when we prepared for closing. And so what I was able to do for today is to actually find clips, real clips from our trial to show you guys. So instead of saying I did this and that, I can just play it, you can see, and then we can talk about it. There was a little bit of argument over the Rule 22, and we did agree that the defense could also have our video. So anything that we did, any video that we got, we shared with the defense. So here are the 13 different topics that I'm going to go through. I'll go through them one by one with an example from the trial and then some discussion so that everyone knows how to do it in your case. The first one is short testimony. These were the 6 damages witnesses that I handled. And as you can see, none of them were over 30 minutes and 2 of them were only 4 minutes. It takes a lot for an attorney to go up and do a 4-minute direct. You know, it takes a lot, right? Damages witnesses takes a lot of prep. And I remember when I was doing mock trial in law school and we were trying to get points for the competition, we always said, we don't know what's going to happen on cross. Closing is going to be hard, but every single person should get a 10 out of 10 on a direct. That's the only thing you can completely prepare for, and you need to do it. And you do it by spending time with your witness, a lot of time. So I met with these witnesses at their houses, every single one of them, at their houses, every single one of them, at my office, multiple times to prepare them. And here is what I would give them. So we would go through what their testimony was going to be. Like one of the witnesses was very nervous about what she was going to say. And so this is actually what I handed her. I am not writing a whole bunch of stuff. I do not want the witnesses to memorize a bunch of stuff, but I want them to know the specific stories that we're going to talk about. So you can see here that I have some quotes, a certain quote that I wanted her to make sure she said. And then each, like there's a story about the yard, but I want her to talk about when he removed a tree. You know, we're going to talk about when it was raining and the van broke down. Rick called Ronnie. So I want the witnesses to know the specific stories that they're going to talk about. We do not want to talk about anything general. General, oh, he's a nice guy. No one remembers that. But the story that when her husband's van broke down, that Ron came out in the rain and picked him up and brought his son and drove the van back, that's what the jury remembers. And you can help your clients, you can help your damages witnesses, but what I do is bullet points. So this is actually what I used when I walked up to direct my witness, and this is what I had given her to prep. All right, so write into specific stories, not general statements. You want all the eyes to be on your damages witness. It doesn't matter what I'm saying. I don't care. I'm not trying to be the center of attention. I don't need the jury to look at me. My goal is to kind of, sink into the background. And I'm going to say something general. Like here I said something like, did Ron care about relationships? But it doesn't matter what you're saying as the attorney. Your witness needs to know this is where they talk about the story of what Ron did for Christmas. So this is how it works when it's working well.
What relationships, how different are other people in his life, very important. I remember some years back when my husband and I got in the car and, we were given the one we were gonna be fixing out for our younger son in Nashville, whose car, the air conditioning didn't work. Well, it was around Christmas time, and he was coming home. And so, we were just all scrambling, trying to figure out how can we get him here from Nashville and not have two cars to, have to get back home. Bonnie immediately spoke up and said, oh, I can go get him. I'll drive up that morning and pick him up and we'll be back to Mama's by Christmas Eve, that night for Christmas Eve. So he made 10-hour round trip to go pick up his nephew, but he looked at it as an opportunity to spend time with him one-on-one.
So you could have heard that one story and know that this guy was a great guy. Just, he wasn't planning on it, raise his hand as the person who would go on Christmas Eve and drive 10 hours to make sure that the nephew was there with the family. And if you didn't hear anything else from this witness, we got what we needed. When you just have bullet points and you prep the witnesses and you don't put all the pressure on yourself to ask the right question, then you can really listen. And when you really listen, you want to loop. So looping is when the witness says something and then you decide what it is that was important that they said, and then you say it again. And the only way you can do that is if you are present in the moment and you're listening. And the jury picks up on that. The jury knows if you're just looking down at a piece of paper and you don't care. The jury can pick up, oh, you're looping. You listen to them and you pulled out what mattered and what you wanted to talk about. So if you haven't looped before, then here's an example.
So over those 28 years, what type of things would you do together?
So she said a lot of stuff, but what I wanted to point out is they'd been friends for 28 years. This is a person that cares about long-term relationships, has long-term relationships, is a meaningful friend and part of our community. So that's what I looped. And you can only do that if you're listening and you're present in the trial. And the jury sees that. Okay, next I want to talk about entering evidence with damages witnesses. So I typically try, if I'm putting up a witness and I have 6 exhibits, I have some videos, I have some pictures, I try to enter them all in at the same time so that I'm not spending the entire direct talking about authenticating a picture. The jury doesn't care about that. So what I've done before is I've put them all in at the same time. But what I did in this trial that I've never done that was super effective is I actually did that without the jury even in the room. So I told the judge, Your Honor, I have a bunch of videos that are coming in on this witness. I have a bunch of pictures before the jury comes in so that we don't waste time, so that we're not scrambling around to authenticate. Can we just do it now? And so the judge said, okay, we can go ahead and put it on the record. We discussed with defense counsel. I had sent defense counsel all the pictures and videos for this witness ahead of time. And then, of course, before this, I walked over to their table, made sure, hey, this again is what I'm going to do. And then on the record, when the jury was out, the judge, we went through, okay, this is going to be 26, 27, 28, and we all agreed on everything. Then we brought the jury in, then put the witness up on the stand, and you can see at that point, I don't even have to do anything. The evidence is already in. And it's so much smoother. And so as you can see here, I go right into the video and it becomes emotional right away. So if we're messing around on authentication, you're not going to have anything emotional that we can get into. So here's how it goes when you do all that in advance.
I have 2 videos that I want to put up. So the first one, and just for the record, this is 28H, and you can go ahead and play it.
Yards of birds and hang nests out of it. Is that good, bro?
So what kind of pop was he? What does this video show you about his involvement and engagement And he was fine, he just, spoiled them and let him get away with anything, they wanted to shave his head, but okay.
So, I mean, the witness was clearly emotional about it, and we were able to get right into the emotional core of the testimony without messing around with exhibits and foundation. All right, so another thing that I typically hadn't done with damages witnesses was to talk about liability defenses. But in this case, our client, he had brittle bone disease. And so the defense was making a big deal about, well, you know, maybe the surgery went wrong because his bones were brittle and he was so brittle and he would have just broken apart. Or maybe his life expectancy wouldn't have been long anyway. He wouldn't have made it because of this horrible brittle bone disease. They're making a big deal about it. And so we thought that when they put up their case, they were going to talk about this disease that he had and how he was basically, you know, on death's doorstep. But what we found out through talking with the witnesses is that a whole bunch of people in their family had it. So I had his daughter talk about how she had it and how her son had it and how he still played baseball and he was able to slide. And so here is what I did with his sister, asking questions about their mom, who both had it, and her life expectancy.
And this is hereditary, right? It runs in your family. And your mom has it as well? And did it, how old did your mom live to be? 84. Okay, and did it have any effect on her life expectancy? No.
So Ron died at 64, and his mom, who had the exact same disease, she died at 84. So it became clear then, when we were only arguing he had 10 years left anyway, that the brittle bone disease did not affect his life expectancy. But we got that out on a damages witness. We didn't have to call an expert or a doctor to say that, because we wanted all of our doctor testimony focused on the heart and the gut, and to not have to bring someone in for us on the brittle bone disease. So this was an easy way to go ahead and hit that, and it was effective. And I don't know for sure, but they really didn't go after this in the defense case, but I think because it was handled with all these witnesses and the jury didn't seem to care or think it was a big deal, so they didn't harp on it. All right, value of life questions. This was a wrongful death case. So what we tried to work in were some questions that reminded the jury, your job is to put a number on the value of this man's life. And you can actually roll that into your questions on direct. So here's how it sounds. It's very simple, but we just want to remember to do that because it helps the jury know what they're supposed to be thinking about and what they're supposed to do in this trial.
The jury has been asked to put a value on your dad's life. And so would you understand if you can start just as a child, what it was like to grow up with him as your dad?
So it's the same question I would ask, you know, what was it like growing up with him as your dad? But instead, I just said, you know, you're here because the jury has to put a value on your dad's life, or that's reminding, okay, the jury needs to perk up and this is their job and this is what they need to be thinking about. So it's a good way to do it. And then here's another example. It had been 6 years since he had died. So when we're talking about the value of his life, I also wanted to know, what has he missed in these 6 years? That also factors into the value of his life. So that was another thing I wanted to make sure I got into my question.
Tell us, like 6 years not having, what he's missed out on. Georgia Tech, and I know you would have something to say about that. Definitely got hurtful about.
So, I mean, we're getting the same, we're going to ask the question. We want to know what he missed out on, but the point is that we're going to say he missed the last 6 years, and that's going to be something else that we're talking about in closing. So to plug it into our question is important, and another way to remind the jury about what their job is and what they should be doing. Okay, taking your jury to the moment. I'm going to show you 2 examples of when I really wanted to get present, like kind of go back in time or move up in time in another one. And it's so simple. All we're saying is just take me to the hospital.
That's all we're saying. Take me to the hospital. He just had the surgery. Now what's going on? But we have to remember to say that. Take me there. We want the jury to go there. We want the jury to imagine it. We're about to put up pictures. So it's simple, but we just have to remember to take the jury to the moment and let them know where we're going.
Take you to the hospital. So I know we have the surgery and, tell us kind of the aftermath of the surgery, what started going on.
And so that's what I use. I use the words, take us here, take us there, take us on the beach trip. And then you're going to allow the witness to say, well, I walked in and I remember that day because I was doing hair and then I got a call from my mom and I left early. So I'm trying to get the witness to get more present. So that's the language that I use to do that. And then this example, I'd done a lot of prep with this witness. She was very, very good. And she did a great impression of her dad. And my goal was to almost feel like her dad was in the courtroom, like the jury was meeting her dad. And so she knew she forgot to talk about this. And so I said, what else do you need to add? She knew the story that I wanted. But she actually kind of role reversed into her dad, became her dad, and was talking to the jury as her dad using hand signals. And it was so effective, we drew an objection, which it was fine. But the goal is to actually have your witness become present. And here she actually brought her father, who was no longer with us, to the courtroom.
If there was anything else that, your dad would like us to talk about and that you'd like to share with the jury. He was just, he had the chance. He was just like you guys, like everybody. If you was in an elevator with this word, he was jury, he would probably be talking, he should like chat about the big and so.
So, you could see he'd be talking to all of you on the jury. He'd be saying stuff when he wasn't supposed to. He'd be leaning over and whispering. And the jury, you can't see the jury. Obviously, we couldn't video the jury, but they were loving it. I mean, they were smiling. They felt like, oh my gosh, they're meeting this man right now. And then the defense counsel, she objected golden rule violation, which of course is not a golden rule violation. I'm not even talking to the jury to tell them to put themselves in someone else's shoes, but that's what it felt like. It felt like, wow, this is working. There's got to be something wrong with this. And there wasn't, and it was fine. But it worked. The jury felt like they met Ron. All right, so using demonstratives, we typically think, or at least I typically think, that like an expert should use a demonstrative. You have an expert come up and walk down like in front of the jury and show everyone what a pen is and what each piece of it is, and we use an expert to do that. But actually we can use our damages witnesses to do that too. So when I'm meeting with damages witnesses, I'm saying like, is there something that we can bring to court? Is there any, you have to ask because they're not going to come up with this. So when I'm asking his daughter and saying, is there a thing that you could show the jury that reminds you of him or something special? It could be anything, right? It could be like a rock. It could be a bracelet. And so what she had was a collage that she made him in the hospital. And she put all these pictures on it. She's like, I made him this to cheer him up. Oh my gosh, this is perfect. You can't script that, right? So I'm like, where is this collage? Get the collage. And then what I did was I took a picture of the collage and then I turned that picture over as evidence while we're working up the case. So it was produced as a picture. But then at trial, I brought the actual board with me. And so when she was up on the stand, I showed the picture, it was in evidence. And then I just went and I grabbed the board and I said, Your Honor, I'd like her to come down off of the stand and to talk to the jury about each one of these pictures. The judge was not happy with that because, the judge doesn't want anyone up and coming down. The judge wants to keep control of her courtroom, and she was a fantastic judge. She's like, oh my gosh, they're going to get out of control pretty quickly. So she said, no, I just want, you never know how this is going to go, right? But she said, no, I just want her to point to the overhead picture. But because we had prepped, And because my client knew this is super important and super effective, we argued a little bit with the judge. And I said, Your Honor, but she needs to hold the board. And then my client said, well, what if I just stand here? So she knew what the goal was. And so the judge finally let her just stand and hold the board. And you'll see it's so much more effective when you're holding something and describing something. She immediately gets emotional, and she's, when you stand up, you're engaging versus when you're just sitting there and your energy is kind of low. So you can kind of see how we went back and forth with the judge. We didn't give up. And then you can see how effective it is once she starts talking about the pictures and holding the collage.
It's 29F, and I have the actual collage here in for it, which is you wrote a lot of things on it, very helpful to explain it so that we can come down off the stand and what example is that going on. If she can talk through what she has on the board for the board. Can you stay on the break? Okay, can you sit here and talk? If you need to hold it or just point her to feel a consent. I could just stand up right here, maybe something, whatever. So this, since I know that he was scared, loved one left the hospital on time to get on the shower stuff, and so I stayed with him several days before the surgery was gonna happen, and he was telling me that he was scared. He told me that he did not want to die. Nothing he wanted to do. I like thinking I could die. And he wanted to all the time. And I said, what do you want to do? Let's just focus on what we're gonna do when we get through this. And so I made him this for Father's Day, because he's in the hospital for Father's Day, and that's just focus away. So I encourage him and have him focus on the positive and just don't be scared. We're gonna get through this. We'll be back to how we always were. So this is just a picture of him on his boat earlier. This is my youngest son, Oscar, on his first birthday. It became a tradition somehow that every first birthday of my kids, actually I did this at my first birthday so that we could think that my kids, that they would all, like with the smash cake, they would see him by. So let's take care of that. If he's getting by his birthday cake.
So you can see that she just kind of takes over when she has this collage. And this is what happens when damages witness has something that brings back a lot of memories. They're able to talk about it and they're engaging with the jury. And it's a lot better than you see in the background. The collage is still up on the screen. I mean, if she was talking about it up on the screen, it's just not going to be emotional and the jury's not going to connect to it. So it really makes a difference if you can find something that your damages witness can talk about and hold in their hand. All right, so I wanted to talk about just like all the emotions in the trial, especially it's a wrongful death case and you sometimes, it's a serious case and you feel like I can't laugh, I can't have other types of emotions because this is so serious. And I don't want anyone to ever think that I am not a serious advocate, I'm not taking this seriously. But if you are always serious, then a jury is not going to connect with you. Like we need to have all the emotions. And so we chose this picture that we put up on purpose because Ron was funny. He was active. He was hamming around in this picture. He was dancing on the beach. And so we wanted, it's also easier. It's nice for the jury. You know, they're sad the whole time. It is a sad case, but you want to find little times when the jury can laugh, and then you want to laugh with the jury. That's normal. If everyone in the audience was laughing and I sat here and looked serious, that would be odd. So it is okay to laugh with the jury. You want to become part of the jury. You guys are joking about the same things. It's okay. So it seems like a small thing, but don't hold yourself back if there's something that the jury and you can laugh about together. That's good. Okay, so this witness was on a camping trip and had been out of town, but because he cared and he wanted to be at this trial, he left the camping trip, him and his wife, and they drove hours to get to the trial. And a lot of times we don't even get that out in the testimony. We just stick with our normal testimony. We don't know when they're going to get called in. So they got called in, they drove a long way. And I thought, I want the jury to know this because the jury is also doing the same thing. They're also having to wake up. They're having to, not be able to do things with their kids. They're having to miss out on stuff to get there. So we want to show them that we're in the same boat and we're also struggling to get here, but we're here because it's important. So I wanted to draw that testimony out of the witness. And I think it's a good idea if you do have a witness that's really gone out of their way to get to the trial, then let them talk about it.
We're thinking and, right on Highway Road. And, we're there through this on.
Well, how is it important for you to drive and to be here right now?
This family, this family, like, a brother, sister, to us, and that was the most important thing.
Next, I want to talk about graphic pictures. So a lot of these cases, we have graphic pictures. I've seen it done in opening where you say, look, I'm going to put some pictures up. You don't have to look at them if you don't want to. I understand, but I want to warn you. But when you're directing a witness, I can't talk to the jury. I can't say that or I would get in trouble. So I just came up with a way to ask the judge what to do. And the judge is like, what is this lady asking me? And then we kind of just put up the pictures, but the point was I wanted the jury to know that I was thinking about them. That was the only thing that mattered. I wanted the jury to know. I wanted to give them a heads up before I put up a picture so that they knew I was thinking about them and I didn't want them to be startled when I was about to put up something that was graphic.
Your Honor, I have some pictures from the hospital, but I don't know, let the jury know that they don't have to look if they don't want to, but we want them to talk about them, so. Can you tell us what's going on in this picture?
Because you see the picture come up and that is something you don't just want to put up without saying something, but you always want to be thinking about the jury. There's not the perfect way to do it. That's okay. All right, contrasting before and after. So in this clip, the son was talking about seeing his dad in the hospital. So it was really sad. He was talking about, he saw his foot, it looked foreign. It hadn't looked like this. And so he went through all the details, which is what we would normally all do. But the thing that I added in that I thought was effective and that we can all easily do is I said, when was the last time you had seen his toes before this? Because I knew it was at the beach. And we had already put in those fun beach pictures. We had talked about his dad joking around, meeting people on the beach. So I knew that was the answer. And so when you have such a sharp contrast, it's not like we're talking about this person who looks horrible who had been in the hospital. We're talking about the person who looks horrible who the week ago had been at the beach. And so that more drastic contrast helps make your damages points.
Not, but it's hard to look at again, but.
You guys seen this, but.
The beach. In the sand, yeah.
And that's actually when he got emotional, when he thought, oh, I saw his toes in the sand. All right, and my last tip, this is something that happened natural. We want to be thinking about it though, is when I started the trial and I watched back all these videos and we have to do this. Like we need to look back at what we did and how we can be better, or what mistakes we made or what things we want to do different. So as I'm watching these back, at first I would ask questions and say, can you tell the jury this and that? I'd be asking my damages witnesses, the jury needs to know the value of his life. Can you tell the jury what your dad used to do? But then and you have to earn this, and it has to be authentic. But I noticed that on my last witness, I was saying, can you tell us? And I was saying, we want to know. So I had felt like I became on team jury, like we're all a team. You know, our group was all together. We wanted to know the same thing. So my words changed and the energy changed. You know, it's like we're all wanting to know this. Can you tell us versus tell the jury? They need to know this.
You want to get to know your dad first. So start building up as you did with the your dad. Tell us what that was like.
So that has to be earned. I don't think you should just jump into the trial and start acting like you're best friends with the jury. But when you do a good job, and like here, we had been going a week and this was witness number 6. You know, at that point, I did truly feel like we're all trying to get to the same conclusion here. We're trying to get to understand your dad, and we're all together. And that's when you start realizing like this trial is going well. We're doing what we need to do here. And that is my final tip. Questions? Anyone? Yes.
I have a question about what you do with a witness that you've prepped, you thought that they were going to be able to keep it together, and then for some reason they're not able to keep it together on the stand. So like my last trial, my plaintiff, he was so, you know, just emotionally fraught by the time we got to his direct, because he had heard the defense make all these arguments about how he had caused this rear end collision, which was obviously untrue. So he had performed great in the practice, was really solid. And then he gets on the stand and he's just like emotional explosion, right? Like crying, very upset. Like, what do you do in that kind of moment other than just like taking a break? Is there anything that you've seen that can kind of like bring them back around to the training and what you did before?
Yeah. So that's happened to me, and it really tanks the case. It really does. The client cannot go there. The problem is you don't know if they're going to or not. So what I swear by now, and this has never happened to me since I started doing it, but I started bringing in, like in this case, I flew in a therapist to prep my clients because I knew how emotional this is going to be. I knew there's a high likelihood that this is going to cause a lot of tears and is going to be so emotional. And we were very worried about that. So I'm not doing like a normal prep or even a great prep that I'm doing. I'm actually bringing in a licensed therapist who specializes in witness prep. And I mean, we are doing an entire day of super deep emotional work. And since I've been doing that, and that's Rob referenced his trial, and I told him that same thing, you need to call one of these therapists because this is going to be super emotional. And once you have, and I just tell the clients, like, there's going to be a lot of emotions at trial. So we never want trial to be more emotional than what we're prepping. So we're going all the way in, and the clients do not like it. They do not, like, they say, please don't make me ever do that again. But ever since I started doing that at trial, they're like, oh, this is nothing. Because we've spent an entire day going into their childhood, going into their relationships. Like, I mean, they're bawling, crying, they're getting it out. But you can't do that yourself. And that's what I tell them. I say, I'm bringing in somebody who is like licensed to do this. And that would be my tip, because when it starts happening in trial, it goes out of control. So I would bring in when you know it's emotional. And I even do it like on a small car wreck case from now on, because that happened to me in what I thought was a small car wreck case. So every case that I'm going to try, I bring in a therapist to work with the witnesses before they go up. Other questions? Thank you.
Tanya, that was great. Thank you. And she's exactly right. She suggested that I do that with our witnesses in this wrongful death case that we tried. And I'll have to be honest, I thought it was going to be hokey. I thought it was going to be weird, and it was, but it was incredibly effective. I don't think most of us probably don't realize how much we keep bottled up, and your clients certainly are the same way. And when they have experienced a traumatic event, it is incredibly helpful for them to have someone walk them through it. We did a lot of reverse roles, and you could just physically watch the emotion and all this stuff that they didn't even know was inside of them come out. And to be a part of that helped me learn how to tell their story in a concise way to the jury. And I believe, as Ashley asked, it helped them to learn to get that out. And so it didn't come out on the stand. And I think we used about 6 damages witnesses in our damages portion. And I think it was incredibly helpful. Okay, our next speaker is Adam Malone. I do not need any notes to introduce Adam. I told you how long I had known Lloyd, but I have known Adam much longer, since we were teenagers in college at North Georgia Military School. Adam came in and he was new to the school. I think he was a sophomore, and he was trying to make friends and fit in. And I can't remember the exact. I think you came up to me and said, "Can you teach me how to talk to girls?" No. Little did I know that years later, after I had gone to law school, worked as a med mal defense attorney, and then thought that I could go out on my own. There's a lot that you really don't know when you're a young lawyer, and even when you're even if you've been doing it all these years. But I certainly failed miserably as a solo practitioner, and I wound up getting a job as an associate at Malone Law to work with the legendary Tommy Malone and Adam. And I asked him, "Will you teach me how to be a plaintiff's lawyer?" And it took, I'm a slow learner. It took 10 years working under Tommy and Adam. And everything I do every day is a result of what you guys taught me, the process of intake, evaluating a case, meeting with the clients, choosing the right case, making sure you believe in your clients, and prepare. Probably the most important thing that Adam taught me is prepare every case as if you're going to trial. And you got to have that mentality. Your staff has that. You can't just say it. You got to live it. And because of that, most of these cases resolve, but the ones that don't, usually the defendants have to pay a price. But I am eternally grateful to Malone Law, and especially my friend Adam Malone. He has mastered the craft of being a trial lawyer in catastrophic injury, medical malpractice cases, gone all over Georgia and even other states, and achieved incredible verdicts. He had another great verdict last year, and I asked him to come talk to us about it and share some of that wisdom. Adam Malone.
Thank you, Rob. And good morning, everybody. I'm glad to be here. You put together a great program. And since you shared that very personal question that I asked you when we first met, Rob's nickname in college was Rocket Rob Register, and everybody thought it was because he could run fast, but he was quite a ladies' man. And so he developed that nickname. There you go, right back at you. So as Rob mentioned, I had the privilege of representing my good friend Tommy Mason in a lawsuit that he filed against Georgia Neurosurgical Institute in Macon, Georgia, in Bibb County, and a neurosurgeon by the name of Dr. Richard Rowe. And we tried this case last June. Took 1 week, and we were able to obtain a successful verdict that I'm going to talk to you about. And I might be able to, as we go through some of the things that I learned in this trial and how it unfolded, share with you some of the other things I've learned over the last 26 years of handling these types of cases and trying these types of cases. The title of this talk is a little different than I think is on your printout. I changed it because I remembered that Scott Bailey told the members of the jury that Dr. Rowe was not only the expert of the experts in this case, because he had more training than any of the experts that will be coming to court to help us with these issues than any expert on either side. He had more training. than most, if not all, neurosurgeons in the country when dealing with a particular type of brain tumor. And on top of that, had more experience. And so I realized at that moment that I might be in Bibb County, Georgia, suing the best brain tumor surgeon in America. So let me tell you a little bit more about the defendants in the case. So Georgia Neurosurgical, excuse me, Georgia Neurosurgical Institute for a very long time was the only neurosurgical practice in all of Bibb County. It's been there for 75 years, started in 1953. One of the founding members is still a part of the practice, Dr. Joe Sam Robinson, that it seemed like everybody in the jury pool either knew or knew of him. They have numerous partners. And Dr. Rowe, this is Georgia Neurosurgical Practice and their logo, and Dr. Richard Rowe had been with that practice his entire professional career for more than 40 years, and had been a part of that community. And all of the members of that practice are very involved in community endeavors and sponsor things, and are to the extent that a physician practice can be beloved in a community, I think this one probably is. And a lot of people knew Dr. Rowe or knew of Dr. Rowe. Dr. Rowe, in addition to his impressive medical training and his experience with, I told you, a particular type of brain tumor. It's called a meningioma. And most meningiomas are slow growing, and they, a lot of times you don't know what causes them. And many of them are non-cancerous, and it depends on what grade it is as to whether it will become cancer or whether it will come back if you take it. And we're going to talk a little bit about meningioma and stuff like that. But Dr. Rowe had been sued prior to this case 5 other times, and all 5 times he had gone to trial, and in every trial it had been a defense verdict. And so not only was he an expert in brain tumors and the medicine in the case, but he's a pretty well experienced testifier and very comfortable, I suspect, in courtroom and talking to juries. And so what's this case about? Tommy Mason was the father of Ben Mason. Ben Mason was 35 years old, not married, worked in an auto parts store, and didn't have any kids, and developed symptoms that were concerning enough on a Friday of the Memorial Day weekend. And so he was taken to the emergency room at the medical center there in Macon, after his brother and his dad had observed that he was slurring his speech and dragging his right foot while they were helping to move Aunt Jenny out of her home to help her move to a new home. And they just knew something was wrong. So I told you there was slurring of speech, there was weakness on one side. Some of you might be thinking, well, that sounds neurological, it could be a stroke. So they didn't know that. They just knew this wasn't normal and he needs to go to the emergency room. So his dad drives him to the emergency room, and he is evaluated there. They get a CT scan, and they see a large mass in the deep brain near the brain stem. And that leads to an MRI, which confirms the presence of a brain tumor. And he is admitted on that day to the hospital. A neurosurgeon is consulted from this particular practice, and his name is Dr. Gregorian, who's now no longer with that practice and up here at Kenneth Stone. Last I saw him. as a defendant in a case I handled last year. But that's who saw him first. And Dr. Gregorian told him that this was probably inoperable, but that their practice was privileged to have as a part of it Dr. Richard Rowe, who was not on call and would not be back until next Wednesday. And that he would need to remain in the hospital until Dr. Rowe could come see him, because Dr. Rowe is their tumor specialist. And so Ben has just gotten this information. As you might imagine, it's kind of scary to hear that. His father was concerned. Aunt Jenny was up there by this time. His brother had come, and his brother's sister, who actually worked at the hospital. And they're all very worried, but they're all also very anxious to hear from the man, the expert with tumors. So each day goes by, and Ben had been having headaches, and they started giving him medicine and steroids, and his headaches were getting better, and Ben was feeling a little bit better, but everybody knew he still had this big brain tumor, and something was going to have to be done about it, or they were waiting to hear about what the options were as to what could be done about it, if anything. Eventually Wednesday morning comes, and they had been told that Dr. Rowe rounds every morning at 7 a.m. So he would be by there on Wednesday morning to see Ben, and it would be early in the morning, close to 7, because he's always there at that time, and that's when he does his rounds. So Ben, of course, wasn't going anywhere. He was already there, but the rest of the family, Tommy, his dad, Aunt Jenny, and Misha, his brother's sister, were all there by 6 a.m. And so when Dr. Rowe, they're all there waiting for Dr. Rowe. Dr. Rowe enters the room, introduces himself, and Ben's, of course, in the bed, and Tommy's over here on this side right next to him where he can reach out and hold his hand. And Aunt Jenny is right beside Tommy, and he's just standing over here, and the doorway is where I'm standing. And so Dr. Rowe comes in. Hi, I'm Dr. Richard Rowe. I'm here to see you, Ben, and shakes everybody's hands. And then he walks over to him and does a little brief physical exam. And then there's a screen over on this side of the room where he says, I want to show you this brain tumor and talk to you about what my plan is. And so that's what he does. And so you'll see in a few minutes this brain tumor, and Dr. Rowe talks about how it is operable. Well, that is good news to them, since the last they had heard from Dr. Gregorian was it was probably inoperable. And of course, they want to know, well, what is the plan about how you're going to operate? And Dr. Rowe then explains that, and he says it's a very difficult operation because the location of the tumor, it's deep in the brain near the brain stem. So I'm going to need a few days to plan for it. And we're going to schedule this for next Tuesday. This is Wednesday, so we're going to schedule it for next Tuesday. And let me stop right there. So if you have a brain tumor in the location where this one was, it can compress the aqueducts within the brain that are connected to the ventricles, and the ventricles are where brain fluid is met. And brain fluid is very important because, and the free flow of brain fluid is very important because it brings nutrients to the brain tissue and it removes waste, and it also provides balance and a cushion to protect us. So if we didn't have brain fluid, just the fact of walking upstairs or downstairs, our brain would be jarred against the jagged edges of the inside of our skull, causing brain damage. So the reason that doesn't happen is because we have brain fluid that surrounds and bathes our brain and protects us. And a tumor in this location can block the aqueduct and make it where the fluid can't flow out. And your ventricles make about a Coke can size of fluid every single day. And so if it gets trapped in there and it can't get out, then that can create a risk of increasing what they call intracranial pressure, where the brain literally can be squeezed from the inside out, ultimately with brain tissue nowhere to go in a confined space except out the base of the skull through the hole in where the spinal cord comes out. And that's called brain herniation, and that'll either kill you or cause permanent severe brain damage. So if you've got a condition like this and there's blocked fluid, the standard of care universally is you must be admitted and remain in the hospital. You must be monitored closely for any progression of any neurologic symptoms, and you must be treated immediately. And the treatment, thank goodness, other than removing the tumor, so like in this case, there was no criticism for not taking the patient immediately to the operating room, because it was a difficult surgery. It did need to be planned carefully. But if something happens between the moment you make the decision for surgery and the day that you can perform it from increasing pressure, then you simply provide an alternate route for the fluid to get out by placing a drain. This is a bedside procedure. Doesn't have to be in the operating room. You use a local anesthetic to numb the skin tissue, because the brain doesn't have any sensory ability. And the drain is placed through the skull and into the ventricle, and now the pressure is suddenly relieved and the patient is protected. So Dr. Rowe discharged the patient, sent him home, and said, be back here next Tuesday. And unfortunately, Ben herniated his brain on Monday before the scheduled surgery on Tuesday, and survived in a coma for 4 months until he ultimately passed away. And so we filed this lawsuit. And like I said, I've been doing this for a long time. And if I was brand new at this, I would be thinking, well, this is a case to which there is no legitimate defense. They should just settle it. And because everybody should agree, based on what I just told you, if you got a tumor like this and it's blocking the fluid, that everybody knows you can't send the last thing you can do is send the patient home. In fact, you can't ever do that. That is an absolute no-no. And that's what Dr. Rowe did. So what in the world could the defense be? We don't find that out until the deposition is taken. And of course, I think it's going well. I didn't take the deposition. Another lawyer did. And as I'm reading the transcript of the deposition, I'm realizing that, well, this deposition is going well, because he's agreeing with all the basic principles and agrees that the standard of care requires a patient remain in the hospital. So then you might imagine the next question that has to be asked after that, well, doctor, how in the world did the patient wind up at home? Well, I told him he needed to stay in the hospital, and he told me that he was not going to stay. And well, tell me about that conversation. He says, well, I explained to him the situation with the tumor, its location, the blocked fluid, and that if he goes home, bad things could happen before he would have an opportunity to get back here, and there'd be nothing I could do to help him at home, and he really needed to stay here. And when you told him that, doctor, what did he say in response? Well, he said, I'm not staying. And what did you say? Well, I said, in that case, because I'm not the police, I can't force a patient to stay in the hospital against their will. I made an agreement with him that if he insisted on going home, that he would promise me that if anything changed or anything got worse, he would come running right back down here. And had he done that, then this wouldn't have happened. So you will agree that had he been in the hospital and never sent home, that there would have been changes that those with trained eyes and ears would have seen or heard in time to place a drain and prevent the herniation and prevent his death from this brain tumor and the blocked fluid. And he said, I agree. So folks, this is the only case in my entire career where both sides agreed on the medicine. Everybody agreed as to what the standard of care required. Everybody agreed that had the patient received the benefit of that standard of care, then this outcome would have been dramatically different. It wouldn't have happened. And so, so the case becomes one. I really like what we heard from Lloyd earlier today about cases having a moral imperative. In this case, as I read that transcript, I remember feeling angry, really angry. And as I think about it in this moment right now, I'm feeling a little bit angry because while I'm sure Dr. Richard Rowe is a good man and did not want this outcome for this patient, I suspect, being as expert as he is and as well-trained as he is and as respected as he is, and knowing what happened here, that it would be nearly impossible for him to accept, he offered this patient the option of going home without telling him, you've got a ticking time bomb in your head and you can't go home. So what does he have to say to live with himself? Got to be the patient's fault. Can't be mine. And you know what? I suspect a lot of doctors, maybe him, get away with making up stories about what happened in an exchange between the doctor and the patient when the patient's dead and can't come to court and dispute it. And so that made me really angry, because I called Tommy Mason after that deposition and I said, why didn't you tell me that Dr. Rowe had told Ben to stay in the hospital? And he said, what are you talking about? I said, well, here's what he's testified to. He said, I was right there in the room, Adam. I'm the one that took him to the hospital. And we were scared to death over the 4 days that passed between the time we heard about this brain tumor and the day we met who we thought was going to be his savior with all the answers. And he said that Ben could go home. And I said, well, who else was in the room? Because you're the plaintiff. Well, Aunt Jenny was there and Misha was there. And I said, well, we got to talk to Aunt Jenny and Misha. And so the lawyer that was working on the case with us went out and met with Aunt Jenny. And this is kind of funny. It's not funny, but it's kind of funny. So Tommy's, at that time, he's about 73 years old, and Aunt Jenny's 70 years old. And the lawyer's meeting with Aunt Jenny in her house, and they're just country, simple folks dealing with a sophisticated, world-renowned expert. And he tells her, here's what the doctor has testified to under oath. And she said, he didn't say that. I can promise you he didn't say that, because I'd have been all up over Ben telling him, you ain't going nowhere. And she goes, you know what, come to think of it, let me look. I think I recorded that conversation on my cell phone. And if you'll give me a minute, I'll look and see if I can't find it. And he said, you got to be kidding. He said, no, I knew that when he came in, he was going to be talking about all that medicine stuff. And there's other members of our family that are going to be asking me questions, and I wasn't going to be able to repeat any of that. So as soon as he walked in the room, I just hit record. And when he left the room, I turned it off. And he said, well, we're going to have to hear that. And she found it. And I'm going to let you hear a little bit of it in just a minute. And so the recording does not reveal anything consistent with Dr. Rowe's sworn testimony. And so I wrote a letter to Scott Bailey, who I have a lot of respect for and I know is a very fine defense lawyer, where I said things in it that I hadn't said before about a physician or a defendant in any of my cases. To paraphrase, I had said, it looks like there may be the commission of perjury in this sworn testimony, and if you'd like to have an opportunity to resolve the case, you can do it within 2 weeks or something like that. And I got a really nasty letter back in response to that, that accused Aunt Jenny of having modified, and I sent the recording to them. And that they accused Aunt Jenny of having modified the recording. Now, Aunt Jenny, bless her heart, you know, of course, I called her and I said, they saying you modified this recording. She said, what? Let me at them people. You got to be. Now, Aunt Jenny can barely work her iPhone. And I knew that we're going to try this case. And I love to try cases. And I've tried cases before where the strategy was blame the patient, or the defense be what the patient is saying is not true. And I've tried cases before where my father and I tried a brain damaged baby case in Columbus a while back, where a C-section should have been performed because the strips were becoming concerning, and everybody kept the mom in the dark. And then after the baby was born brain damaged, the nurse, and this is before electronic medical records were so prevalent, but the nurse had gone back in and put in entries that mother was told about concerning signs and that she had refused the offer of a C-section. We tried that case with that kind of defense, and it did not work out well. You know, when they make up stuff that's morally offensive and they've got no real evidence of it, it can blow up all over the defense. And maybe it works sometimes. I just hadn't seen it work. The next case I'm going to try in Cobb County in July, the same kind of issue. The defense is what the parents are saying they said, they never said. And if you step back and you take off your competitive armor of just wanting to win at all costs, and you really think about the reality of what was happening in the moment, you could not reach the conclusion that some of these things I see on the defense side happen. You know, you just couldn't. So I've told you the whole story and how cerebrospinal fluid works, and there's an animation right there. Let me just show you. This is the drain I'm talking about. So those hollow things, those are the lateral ventricles where the fluid is made, and there's a tumor behind it. I'm not sure if I could put my finger on it, you could see it, but it's blocking the flow of fluid and it's made the ventricles blow up. And if that's not treated, we know physiologically the brain's not going to stop producing fluid. It's going to get worse. Lloyd talked about proving the preventability of things. I have used many times as a theme in my cases, ladies and gentlemen, this case is as simple as POP. It was preventable, it was obvious, and it was predictable. And then I organized my entire opening around those three words. And it makes delivery of the opening very simple and easy, and it keeps juries focused on what you are required to prove. So let's see. So warning signs. So after you have imaging of a tumor and it's in an area that may be blocking the flow, you need to look at other features of the film. So what you're looking at here is a normal brain. And do you see these white areas? Okay, those are the ventricles, and those are normal ventricles. So they're relatively small. Now this is Ben's brain, and you see a shadow, a ball right there. That's the tumor in the deep brain pressing on the brainstem, and the white areas are the ventricles that are filled with brain fluid. And then you can see the shadow or the halos around the ventricles. Do you see that? The grayish white area? Well, the fancy medical term for that is called transependymal edema. Well, all that is something very serious. That means that the pressure is so high within the ventricles that it is literally spraying the fluid through the ventricle walls and into the brain tissue. So this is a herniation waiting to happen. And this is the picture that Dr. Rowe was looking at when he was talking with Ben and his family on that morning of May the 30th, that Wednesday. And he never mentioned anything about symptomatic obstructive hydrocephalus. That's the condition that this tumor caused with the increasing pressure and the blocked flow of brain fluid. So this was an image that I showed to the jury in opening, that what he had at the time that Dr. Rowe offered him the option of going home was a ticking time bomb in his head. Standard of care is to admit, monitor, and treat, AMT. Discharge is never an option, and I've told you what happened in this case. This is the view of the film that he was showing Ben and the family, and you can see that tennis ball sized tumor in the deep part of Ben's brain, and he was explaining how he was going to get to it and what he was going to do. That was the substance of the conversation. You got a tumor. He did say it's blocking fluid, but he didn't say anything about what could happen from the black fluid. He did say that it would be a difficult procedure, but he could get to it. It was going to take some planning, and he explained his approach. These are other images of the same, of Ben's brain, intended to show the degree of the transependymal flow, or where the fluid's being squeezed through the ventricle walls. And so, as I told the jury after getting to this point in the opening, why are we here? Well, it's because Dr. Rowe says Ben refused his medical advice. So let's talk about what the evidence is going to show. You're going to hear from 4 neurosurgeons in this case and 1 neurologist. We're going to bring you Dr. Christopher Kobe and Dr. Van Buren Lemons. And they're going to bring you Dr. Rob Parrish, and Dr. Rowe is going to testify on his own behalf. They're all neurosurgeons. Dr. Andrew Lassman is being brought to you by the defense. He's a neurologist. He's a brain doctor and treats patients who have had tumors. And they're bringing him to tell you that this tumor would have recurred because it was a grade 2/3 meningioma, and that he only had 5 years of life expectancy as a 35-year-old young man. And we didn't have, probably true. So we didn't have a neurologist to dispute that. So what is the standard of care when a patient has a life-threatening condition and says, well, I'm not staying? What is a reasonably careful doctor supposed to do? Well, you can ask yourself, and as a matter of common sense, what do you think a doctor should do? Well, it was fun to ask Dr. Rowe on cross-examination, when I asked him to give us his version of this conversation. Well, Dr. Rowe, when this young man that you see is taking his own life in his hands by telling you he just doesn't want to stay in the hospital, did you turn to his father and say, would you come over here and talk to your crazy son and help me explain to him that he can't leave? He said, no. They were sitting right there. They heard what I said. Well, did you talk to Aunt Jenny or the sister? Well, let me ask you this, Dr. Rowe. Did you go out in the hallway and think maybe there's some problem with my ability to communicate clearly with these people? There's clearly something wrong with either them or me, because no reasonable person would hear what I just said and say, well, I ain't staying. Did you grab another doctor or a nurse or somebody else to come in the room to help you, or repeat what you had already said so they're not hearing it just from you? No, I didn't do that either. Well, you wrote a note about your encounter. Well, yes, I did. Well, I read your note and I missed it if you put it in there. Let's pull it up and put it here. Where did you describe this interaction you had with the patient? He refused your medical advice. Did you document that anywhere? No, I didn't. Because when he said he wasn't staying, he and I had an agreement that he would come back if things got worse. So I didn't need to put that in the medical record. Oh, okay. Well, the hospital's not a defendant in this case, Dr. Rowe, but we did send some requests to the hospital, and we've gotten their policy on patients leaving against medical advice. What does the acronym AMA stand for? Against medical advice. And you're familiar with the policy? Well, I'm sure they have one. Well, are you saying you're not familiar with it? But because perhaps you're not, let's take a look at it. If a patient is refusing medical advice, then there are certain things you have to do. One is to document it. Two is to get somebody else to come talk to the patient. And three is to have the patient sign an AMA form. And here's what it looks like. And we had that, and it was blank. Did you avail yourself of any of these tools? No, I didn't. So Dr. Rob Parrish, interestingly, a neurosurgeon from Texas, was brought by the defense to adopt this narrative that they were pushing to this Cobb County jury. And what they didn't know, so we thoroughly investigate all the defense experts. We thoroughly investigate all our own. And my paralegal, Dee Coleman, that's been with us since before I was a lawyer, reads all their prior testimony. Well, Dr. Parrish, unknown to the defense lawyers, a few years before had been retained in almost the exact same case, but this time for the plaintiff. And in that case, where the defendant claimed that the patient left against medical advice, it was Dr. Parrish's sworn testimony that the standard of care in those circumstances required that the defendant request help from the family members, other medical providers, even go get the chaplain to come talk to the patient. And even in his case, went and got the hospital lawyer to come in and talk to the patient, document the refusal in the chart. And interestingly, if a patient leaves a hospital against medical advice, there's no discharge. There's no discharge summary. In this case, there was a discharge summary. He was discharged. He was discharged by the hospitalist who we brought in our case to testify. And of course, he didn't want to throw shade on any of his colleagues. He has to practice in that local community, but thank goodness he was willing to tell the truth. And what he said is, I vaguely remember this patient, but I don't remember the details. But what I can tell you is if somebody had told me, I would have expected somebody to tell me this is a patient refusing medical advice. And I can tell you nobody did, because if they did, I would not have discharged him. I would have made him sign this form. So as a last resort, you have him sign this form right here. And it was interesting to have a discussion with all the experts who had had experience with this type of form, that nearly all of them, or all of them, had said, when I get to this place, this is where I see patients change their mind, because it says, I'm taking my life in my own hands and I am relinquishing any responsibility that, or my ability to hold the hospital responsible for anything. And it's something about those words being presented after all the other steps have been taken that make patients change their mind. Ben was never given that. Why was he never given any of this? Because he never was told you need to stay in the hospital. So what did he really say? This is a 10-minute recording from Aunt Jenny, but I'm only going to play, how much time do I have? Am I done?
Like 5 minutes.
Okay, I'm going to play you a brief part of it, and then I'll get to wrapping up. Can you turn it up? So Dr. Rose just walked in the room. Can y'all hear that?
Put a lot of pressure on things. I don't think if I'm anywhere today that come out. It's a large difference. Here's the next one. Yeah, and probably look for him and going beside him. That's the way to get to it. And to the left side and
Here it is.
don't have to pay him. Okay.
So there you go. He offered him the opportunity to go home. And of course, who wants to stay in the hospital when the doctor says you don't have to stay here, you can go home? So they had a two-pronged approach to their defense. One was that, well, let me just show you. So there's the quote. He didn't admit him to the ICU. He was not monitored by professionals. Instead, he was sent home to monitor himself with a golf ball pressing on his brainstem and a head full of fluid. And they didn't treat him. And it was agreed that had he been admitted, monitored, treated, this wouldn't have happened. These are all the people who could not sponsor the defense that Dr. Rowe was offering at this trial, including Dr. Rowe's own recorded voice. So Ben refused medical advice is just not true. This is the only case I've ever tried where I felt like in order to win, I had to prove that the defendant was a liar. And that is extremely difficult to do. And nobody wants to believe the doctor's a liar. I don't want to have to prove it either. But I think we did. So the second part of the defense is, well, hold on a second. I did everything right before Aunt Jenny hit record. And they tried to sell that. She hit record at least 10 minutes after I got in the room. I had already explained to him the need for him to stay in the hospital. Well, I'm not going to, I don't have the time, but the jury, we took it with the jury to play the recording again. After Aunt Jenny, of course, had testified that she hit record as soon as he came in because she wanted to get all of the substance of what he had to say to her. There would have been, it made no sense for her to wait until after he explained things and then start recording when he goes over to an image that the recording can't capture. So if I played it again, you'd hear there's silence because he's about to walk in the room, and then this is when he goes over to the side of the bed and he puts his hands on him, and that might have happened before she hit record. But when he says, "Now I want to talk to you about what we're going to do," she hits record. So that was not believable. The next part of their defense was, well, even though we sent him home, because he had this obstruction, we know that he had to have gotten worse over the time frame that he was at home, and it's his fault because Dr. Rowe clearly told him on that report and he should have come running back down here. Well, he was with his father in his boyhood bedroom the entire time, with his father and his aunt and other family members constantly checking on him, and he didn't get better and he didn't get worse the whole time. So the defense theme was, this is a case of mutual trust, and that patients are entitled to trust their physicians, but physicians have to be able to trust their patients to to live up to their end of an agreement. And so, that's what we heard. Now, on June the 4th, the day before the scheduled surgery, they knew the next day they were going to go in for brain surgery and that there would be some period of time of hospitalization and recovery. And they weren't sure what the outcome would be, but Ben's a 35-year-old adult with obligations. And so the plan was, Dad, you're going to take me to the bank and I'm going to sign a power of attorney so that you can handle all my financial affairs when I go into the hospital tomorrow. Well, Tommy Mason puts Ben in the truck. He's still having trouble walking, and Aunt Jenny gets in the car and the brother meets him over at the bank because they're going to go out as a family and have lunch, you know, as a group day before this surgery. While Ben's at the surgery, pressure suddenly increases and he starts having a progression of his neurologic symptoms to the point he's vomiting all over himself. So here's the 911, and this is Aunt Jenny's voice.
We have a brain tumor patient at 4511 Forsyth Road. I think she needs an ambulance. It's quite an emergency.
45, what's going on with him?
He is supposed to be having a brain tumor removed tomorrow morning, and they said if he showed any illness or signs of additional weakness or vomiting, to get him to the hospital immediately, and he is barking all over the place.
So that's the first time he ever had a change. And we know that because they called 911 when that happened. So that was the evidence in the case. They did exactly what they were told to do. And then this is Dr. Rowe's note after Ben gets to the hospital. And you'll see in a minute, that call is made at like 11:15 a.m. And Dr. Rowe doesn't come to see him until 2:30 or 2:45. And by that time, his brain is herniated and it's too late. But here's what Dr. Rowe says. I saw the patient emergently in the emergency room today. The patient's family had called and stated he was being brought to the ER because of headache and vomiting. The patient reportedly had not complained of any headaches until today when he did not feel well. Now get this. This is a doctor who I think realizes I never should have sent this patient home. So I'm going to start covering my tracks because look at the next sentence. He told his father that he was not feeling well and his father was going to bring him to the emergency room. However, Ben asked his father if he could only stop by the bank on the way to the ER. And the patient had an episode of emesis in the bank and the EMTs were called. Now, step back. Got a brain tumor, pressing on the brainstem. They all know that. They're supposed to have surgery the next day. Can you imagine Ben not feeling well and having some problems that they all were told, if something changes, you need to come back down here. So go get in the car. I'm going to take you to the ER because we're scared to death. And on the way, Ben says, oh, hang on a second. I need to go to the bank. And then everybody agrees on the way to the ER to just stop at the bank for a little bit. Unbelievable. Absolutely unbelievable. 12:13 911 called, 12:16 EMS on the scene, 12:28 is being transported, and that's when that call was. After Aunt Jenny got off the phone with 911, she called Dr. Rowe's office and said, we're on the way. And they couldn't dispute it because he documented the patient's family called and said, we're coming. Well, that's what time that happened. And then he arrives at the ER at 12:41. Over an hour and 14 minutes later, he then has a seizure. That's when his brain herniated. Dr. Rowe knew he was coming to the ER by 12:28. And by 1:55, he still had not come to see him in the ER. And it takes 10 minutes to put in this drain. 10 minutes. At 2:35, he's at the bedside. The patient at that time is posturing with his pupils dilated and his brain is already herniated. At 2:45, he places the drain. 10 minutes after he's at his bedside. It's too late. Dr. Rose, I called him for cross in my case. They put him back on the witness stand. And when he got back on the witness stand, his story had evolved some more. So that gave me some more stuff to talk about in closing argument. And I had a big time talking about this notion of mutual trust. because there was a huge betrayal of trust to start with. And then this lawsuit position to blame the patient, gave me a lot of opportunity to talk about trust and what we as a society are entitled to expect from our healthcare providers when it comes to trusting them as they're treating us and through the treatment and even afterwards. So and then of course, well, Ben was going to die anyway. And so therefore you should give us a discount on the value of his life because he would have had a shortened life expectancy. Well, guess what? If things had gone as they should have, he would have been told, this tumor is likely to come back. You may have limited time. Well, what do we all know when we're told we have limited time? Doesn't scarcity create value? I don't know. I was able to talk about many moments in my life when I knew I was coming to the end of something that was really good. It was the last year that was better than all the prior years that preceded it. My senior year of high school, and you can think of 1,000 examples to give to explain how scarcity creates value. And the jury had heard that Ben loved music, and he loved all kinds of music. He loved country music. He loved pop music. He loved hip hop music. He loved, and that covered everybody on the jury, which was a good thing. But this whole thing about you only had 5 years. And one of the country artists that the jury had heard that Ben was one of his favorite was Tim McGraw. And I don't know if you like country music or not, and I'm not a huge fan, but I do know who Tim McGraw is, and I'm familiar with this song, Live Like You Were Dying. And so I know that Ben was familiar with this song, and I'll just end with this. Just because sometimes artists can say things better than we can. He said, I was in my early 40s with a lot of life before me when a moment came that stopped me on a dime. I spent most of the next days looking at the x-rays, talking about the options and talking about sweet times. I asked him when it sank in that this might really be the real end. How hard does it hit you when you get that kind of news? Man, what you do? And he said, I went skydiving. I went Rocky Mountain climbing. I went 2.7 seconds on a bull named Fu Manchu, and I loved deeper, and I spoke sweeter, and I gave forgiveness that I'd been denying. And he said, someday I hope you get the chance to live like you were dying. And don't you know that's how Ben would have lived every second of every moment of every minute of every hour of the rest of whatever time he had left if he had been given the opportunity to get that kind of news. So what is that worth? And that gave me a good platform to talk about the damages in the case. And so I had some trouble with, there were some difficult moments with the way the trial judge wanted things to be done. And I don't have time now to tell you, and it's kind of started in voir dire and it kind of went all the way through. We do think we got the fairest jury possible. We think we got a fair trial. This is the verdict form that I submitted. You notice that there's enough room for the jury to write whatever number they wanted to give us in the first two blanks for the estate and the death claim. It doesn't take up the whole page, but it's about half of it. The defense didn't propose a different one. They did have their own verdict form, but the line was about the same. Well, the judge did her own. And so she gave me about that much space for the jury to write their number in this verdict form. I know you can't see it, but the three lines at the bottom are where the numbers are to be written. And so the jury was sent out with this verdict form, and they come back. It's Friday night at 5 o'clock when they're sent out. Not the time I want the jury going out in a medical malpractice case, but it's the way things happen. And then they cut the air conditioning off, so it got really hot in June. And by about 7:30, the judge comes out and she says, I'm thinking about telling them they can go home and come back Monday, when the knock came, that they had a verdict. And so, they had been sent out there with this verdict form and a pencil. And they come in and they get in the jury box, and then the verdict is handed to the bailiff, who hands it to the judge, who hands it to the clerk to read it. And I'm not going to read you the whole thing, but when they got to the money, they find in favor of the plaintiff, and then they get to the money, and it says, $5 for the wrongful death of Ben Mason, $1 for the estate and conscious pain and suffering. And as the clerk's reading that, the forelady jumps up and she goes, "No, that's wrong. That's wrong." And so the judge says, "What? What?" She goes, "We didn't have enough room. I need to fix that." And so thank God she gave him a pencil. So she erased it right there in the courtroom and wrote 5 million and 1 million. And that was the end of the case. So thank you for the opportunity to speak with you.
All right, we're gonna get started again. Everyone come back in.
Nice to meet you.
Our next speaker is Mawuli Davis. If you have not read about him, you should. He is a widely recognized leader in civil rights. He is a tremendous trial lawyer. He and Rob Bozeman have created a powerhouse law firm, and they represent numerous types of cases. But Mawuli has done civil rights cases. He's done sexual assault cases. He's had at least 3 trials in the last year. And I know he had a tremendous verdict in a sexual assault trial. But at the heart of it is a lawyer that truly cared for folks that are being taken advantage of. And he has a track record of justice for clients like that that's unparalleled. And I have not had an opportunity. I had a case with him years ago, but I have not had an opportunity to really get to know him. But I want to, because I've admired him from a distance and all the things that you've accomplished with your career. And I reached out to him because I wanted him to come. I wanted to hear from him and learn all the ways that he has been so successful in these types of cases. So I'm excited to hear from Mawuli Davis. Come on up.
I'm grateful to be here. I started most of my trials were criminal defense trials. So I tried murders, armed robbery, RICO cases, and then made a transition to doing civil rights, personal injury, traffic trailer. And so I start with this. Before they call your number. That's my father, Bill Davis. We played with the Harlem Globetrotters for 18 years. And he would say to me, I walked around, I've been getting in front of this microphone as I was a young, following behind my dad. When your father is a professional athlete, you want to be just like him. And I realized, unfortunately, I would not get his height. He was 6'6". And so, but this resonated with me. And I think you all being here is an indication that you're here to be prepared. And I think that that's important in our profession. And so I had my quick story, my opportunity, where I was at Carver Hawkeye Arena and I was a freshman, 18 years old, and had not played a single minute in any game. And we were in our 10th game of the season. And we were playing the University of Iowa when they had B.J. Armstrong, who played with the Chicago Bulls, Roy Marble, great team. I thought this would be a good lead-in since some of you all are watching the Final Four. And here I am, and hadn't played a minute, but on the bus ride over, the coach that recruited me whispers, he says, "Mel, we might call your number." And I was like, oh, wow, my number. I'm sitting at the end of the bench. And as I'm sitting there, we're getting hammered. When I say hammered, they are #1 in the country for a reason. And we were the Navy team without David Robinson. All right. So put that into context. Those of you all know we went from David Robinson playing Duke, losing to Duke, to me coming and a couple of other freshmen, and we're getting hammered. And they called my number. And when they called my number, I froze, but I went in and I had been preparing and I was ready. And we still lost by 50 points. So even though I was ready, it did not change the outcome. But what I learned and what I attempt to apply and what I hope we will consider as professionals is that we will respect the fundamentals, that we respect the rules and the discipline required to perform. This is John B. McClendon, the legend, who was my father's coach. In fact, his team, 1957, 58, and 59, they were the first college team to three-peat. They were, in fact, the first team to three-peat in basketball. McClendon was actually learned the game from the founder of the game, James Naismith. So it's just a great history, but what it reminds us is that our work is built upon the shoulders of those who have come before us and have done this the right way. And so I was so excited to hear and listen to each of the presenters before me. That's why I got here early, to hear about how the profession continues as trial attorneys. And so I think about my role and I think about Justice Benham, and he would have this story where he talked about the three professions. And many of you all heard Justice Benham talk about those three professions, and the law being one of them, and our role in healing the community. And so it resonated with me when I was at the Urban Life building, and before Georgia State got this nice fancy building, and Rob Bozeman and I were sitting there, and we get to hear Justice Benham, and he talks about that, and it resonated that we are here to heal the community. And that's how I see the work that we do. I've never done any defense work. I hope that the defense folks in the room can see themselves in that same light, but that's the role that we get to play, right? Doctors do one thing, clergy do another, but we get to heal community. And then of course, I think of Mr. Sampson, having never practiced with him, but just watched him over the years before he made transition, and the way that he approached with such a level of professionalism and was honored by this very section a few bar years ago. And so it's on that I begin my framework. So in my preparation, I read a lot. In fact, at the end, I'll tell you that most of the time that I spent preparing for that game at Carver Hawkeye Arena was normally alone in the gym. So this is very different from me, to be in a space. Normally I'm reading. I'm reading every day. Every morning I've made a commitment to read something every day. I watch the trial guides, 5-minute little tip. If you all are familiar with that, if you're not, I'll be glad to share it with you. But these are three of the books that I'm kind of framing this conversation on that I think are helpful. First, setting the rules of the road. I mean, that's an oldie but a goodie. But I think for us, our case was not a very complicated case. We had 2 women, and I'll tell you how we ended up representing both of these women. They did not know each other. One went in on January the 9th to get a massage and was assaulted. The next day she came back to report it, and she had reported it the night of to the owner. The owner still let the unlicensed, untrained man come in the next day and give another woman a massage in the same private room. And what we found was that this, and I learned all of this, right? And my law partner, Harold Spence, talks about law. We learn law all the time. So, I know you may have an expertise in one area, but I didn't know anything about this industry until we got this case. And so what we learned was that you have to have a license. And there's a reason that you have to have a license. It makes sense. You need a license if you're going to be with disrobed, predominantly women in a private room, you would think that the person would have to have a license. And so we started with that rule. So we made that rule, and I'll talk a little bit about my co-counsel in this trial, Krisna Jones, who is now retiring from practicing, but is a great mediator. We looked at the rule and we laid the rule out and we put it front and center. And the rule says it is unlawful, right? So now we're talking about unlawful. We're talking about a crime. It's unlawful for anyone to put themselves out as a massage therapist if they're not licensed. And so why is that? Because it is to protect vulnerable people. And so these two women, they go in, this unlicensed, untrained man has them in his private room, and he begins to touch them in a sexual way that they did not consent to. And they made clear, no, don't do this. What you're doing is wrong. And so they reported to the police, Atlanta Police Department, and we have sued Atlanta on a number of occasions of different things, but they reported to the police, and the police really don't do anything. They interview him, they ask him a couple of questions, and then that was really it. They didn't even send it over to the solicitor's office for the solicitor to review it. But the part that really resonated with me, Natalia's her presentation about how you humanize. We had to take the jury into the room. So we went over, we were able to get a ruling to have an inspection. So we did a video walkthrough of the place, and we were able to go into that room. And when you go into that room and you think if it's me, if it's my wife, if it's my sister, what I want in this little private room that you see on the screen, what I want a unlicensed, untrained man in this room with my disrobed loved one, because they're physically vulnerable. And so we're able to do our research and have an investigator find this unlicensed, untrained man who was in this private room. And the way he was hired was that he was delivering furniture, and his wife was working for this spa, and it was during the pandemic, they couldn't hire anybody. And so they hired him to start doing massages so that they could keep making money. That one of those seven sins, right, was greed. Greed. They would keep opening the doors and putting citizens in harm's way so that they could make money. And so we lifted that up as one of the themes of the profit over people and the profit over public safety, so that we could broaden it. And it's not just the individual women, but it was about public safety. And so we kept building this phraseology throughout the course of the trial. Unlicensed, untrained man, not massage therapist. He couldn't be a massage therapist because he wasn't licensed. So we just called him a man, right? And then we were able to get his mugshot from another case, which we'll be filing suit on April 7th. He was involved in with another spot. And so why do we use this language? And I use a lot Keith Mitnick's piece. I really enjoy reading his pieces, very common sense oriented. I know that it's been largely framed around accident cases, but I think it's applicable across the board. But it helps us create visual imagery when you are able to have that language, and it continues to undergird what our issue is. If they don't put an unlicensed, untrained man in a private room, our women are not victimized. And so how do we approach it? Oddly, we start, and this was a decision that Krisna Jones made, we start with the expert to lay out what are the rules and the regulations in this industry and why, because most people don't know. in most of our cases, we will start with the defendant, put the defendant on cross. But in this instance, we thought, no, we need to set it out, make it crystal clear. Here's what the law is. Here's why it exists. In addition to the law, what does it take to get a license? How many hours do you think that it would, of training that it would take for you to get a license? 100 hours? Anybody? 200? 500 hours. It's crazy. I mean, it is intense, right? And they go through a whole process. And so they try to say, well, the license is just, and we had to ask our expert, and our expert, let me get to her, was Adrienne Price. So she was the executive director, but we call her in because she's the one that is over the license. And so we call her, she has to come remote. She was ill, so she comes in via Zoom, but she lays it all out. She's our first witness, and Krisna does, it was pretty methodical, and the jurors hung in there. Because our concern is that when you present a witness like that to get everything started, that they just glaze over and you lose them right out the box. But they stayed tapped in because they understood the seriousness of what was being alleged. And so she walked us through what the training was. And then finally, we were able to have her enter the document that showed that the man who performed this sexual battery against our client was in fact, didn't have a license. So that's the document. So we enter that into evidence and we say, you did a search on this particular individual. And you search this name, and this name. Yes. And what did you find? That he was not licensed. Has he ever been licensed? No. So if he's not licensed, he hasn't gone through your training. No. And did you have a document that you provided that shows that you did this search? Yes. And you provided that to us. And then we introduced that into evidence. And so that shut down any question of whether or not he was licensed. I want to go back really quickly. So that's Krisna. And so we did expert first, and then we went straight into the defense on our cross-examination. And we just almost went from where we had gone with the expert. We asked the defense, the owner, because he didn't show up. We could never get him served. He doesn't show up. So we're trying the case against the owner of the spa, and the spa is the business. And as we cross her, and we have to have an interpreter, as we cross her, she's just going through and saying, didn't have a license. Can't deny that, right? You have a license. You know that whoever performs full body massages have to have a license. And just that kind of, you can imagine that went on for a good while, but it was made clear. But I want to go to my part of the trial. And I focus most of my practice on selecting juries. So I do that in all of our cases. I get to, try a few cases a year. Some of them are these kind, most of them are collision cases. And so I really want that group formation as early on as you can. And so just like you all came here, you didn't have to. Some people chose to either watch it virtually, or others chose not to sign up at all, but you chose to be here. You answered the summons. That's how I'm addressing our jury. You answered the summons. You were summoned and you came. And so we start speaking in hero language. And so we want to lead the jury to a place where we explain what's about to happen, because they're in this unfamiliar territory. Because we start making assumptions. If you try enough cases, you just think you come in and sometimes you forget. Everybody, all of these jurors, they've never had this experience. And so we act initially as a guide. But we, at the end of that voir dire, of my opening, I always say that you're gonna be the most powerful 12 people in the state of Georgia about this particular issue. You have all the power. The judge is going to hand this case over to you and you will have all the power. And then you'll have to decide what you do with that power. But it's all leading towards empowering them to go and be the heroes for justice that you need them to be. And I think 12 voices, 12 heroes, one voice is a great, it's a thin book. You can get it read in a weekend. And so I'd encourage those who haven't to take a look at it. So a little bit about Krishna that was very helpful was she's also a registered nurse. So Krishna has her mindset of rules and regulations really helped kind of ground what we were doing. And the way that she approached the case with Adrian Price through all of the documentation, through all of the training that is required, and for us to be able to lay that out in order. And these were the admissions that we were able to get, and I was able to introduce during my closing, was that she knew she was responsible for anyone who did massages in her business. She has to answer absolutely yes to that. She knew that doing full body massages needed a license. She knew that Frank, that was the name that he went by, that was his alias. She knew that Frank did not have a license. Yes. She hired him anyway to make money when she was busy. Yes. And oddly enough, during the deposition, she admitted that if she were in another financial pinch, she would hire him back, even after knowing all that she knew. We got that on we were like, I was like, what? Oh, yeah. She booked Frank. So the way it worked was on the evening of January 9th, he did a massage, he did the assault. It's reported to her. He's on the schedule again for the afternoon of January 10th. She lets him come back. He does another massage. He does it to another woman. They just so happen to bump into each other because she's coming out. The police are over there. And so she comes out. She's like, why are the police here? And she says, it just happened to me. So they go in, talk to the guy, and they don't arrest him. They just let him go. And so that's a big part of our case as well, is that justice is full justice. So she didn't receive, neither of the women received justice in our criminal justice system. But you have the power. This is a separate system. You have the power with a separate burden of proof. You have the power. You know, a separate opportunity. You have the power. You see the theme is you have the power now to deliver justice and be heroes for justice. And so these were the things that happened and how this kind of came together with, it put them on note, it put her on notice after the January 9th assault that he should not have been in there January 10th. And so I prepared each of the witnesses, and I couldn't agree more about the time that you need to spend with your witnesses and just sitting with them. And so we talked for hours, just trying to figure out, first, why would you go to get a massage? What tranquility, what were you trying to feel from what? And they talked about being mothers, they talked about being homemakers. One was a single mom and the stress of running her own business, and she just needed a break. Then we talked about, well, what experience had you previously had with massages? How did you know that this was going awry? What felt different about this? And so we talked for a long time. And then, of course, the most difficult question in these cases and what haunts many of our clients is why they didn't get up and start yelling and screaming and that, you know. that is something that is deeply, deeply personal. And that is usually what the counseling seeks to address, that they didn't speak up for themselves in that moment. Even reporting it the night of or the day of, right there. And they explained they felt in that room. And when you see that picture of him doing this, you know, we use that picture as that they felt they needed to get out to safety. They also, both of them, tipped him just robotically. And so that was, they were trying to say, well, you tipped him and you got, you know, sexually assaulted. Why would you tip? And we had to help them explain. They wanted to get out, do whatever they could as quickly as they could to get out and get to safety. And so that's another part of the conversation that you have to have with your client way before they testify. But this is, I really like telling the winning story. I think this is a great piece that Jesse Wilson uses. Then we talked about the damages part of this. And they talked about their lack of trust, their inability to be intimate, the counseling they received. We didn't do a lot of medical testimony. It was just them telling their story and how it impacted. And we made clear how much was the massage. I don't think I can do this now, but this became our anchor, $60 massage. So if it's $60 and we use the mortality table, both of one was 36, the other one was maybe 40. And we essentially said $60 a day for the next 30 years. You see how we got to 13 million with the punitives. Our role with the jurors were to tell, you know, again, give them the rule. We have a community and we have to enforce the rule for the community. We have to protect our community. And it is moral. I think that is an important part of not just saying that, you know, it's black and white and this happened. It's the morality of someone deciding to put their economic interest over the safety of the public. And then my theme that I always will come back to is that justice always needs a hero. That justice doesn't happen in a vacuum, that people decide to step up and stand for justice and for what is right. And that is the opportunity that you have in this moment. You've heard all of the witnesses, you've had a chance to hear from them directly, and now you have this case and you have the power. And we lifted up this issue too. They kept using, and I think it's important that you listen closely throughout the course of all of the trial. But the owner kept using the phrase store, right? And that's how it was translated. And we made it clear, no, they didn't come to a store for a transaction. They came to a spa for tranquility. And that really resonated with the jurors, is that, you know, clearly she being the owner was just making this a transactional effort and just say, you come here, we get your money, and you go about your business. And we had to try to nail that down. And so we told the jury at the end that we chose you because we trust you. We trust that you will arrive at the right conclusion and do what's fair. And when we laid out the numbers, even when we later on asked for the punitive damages, they were, in some ways, they thought that we should have asked for more. But our clients knew that, you know, we didn't want to exaggerate anything. The way the verdict came back was each of the entities that we sued were, we had the owner and we had the spa. And so they did $2 million something for each, for the owner and the spa, even though they were essentially the same. And then the punitives, and then it was two. So each lady got about they were awarded about $6 million. Obviously, the punitives were reduced and we couldn't, they were capped and we couldn't get all of those. But that is really how we laid out the case. And again, this is the late Kobe Bryant. You're getting ready right now. We're all getting ready right now for when our numbers call. When the judge's clerk tells you if you don't have their case specially set, you are number 6 and you are up. You're getting ready right now. Some of that is preparation when it's just you in your office, late night. This is where I learned. Luella Park is on the south side of Chicago where I grew up. And that was where I would go by myself and just shoot until I left for the Naval Academy to play there. And sometimes some of this is just you being in the dark by yourself, figuring it out, putting in the time, and knowing that your number is going to be called and that you're preparing every day like your number could be called tomorrow. I know we feel like we have a lot more control over calendars nowadays, but just stay ready. And the profession, I mentioned to one of my friends in the back that this is a profession. We have to continue to hold it as a profession. Some of the things that my law partner Rob and I see sometimes deeply disturbing. This isn't a hustle. This isn't a game. This is people trusting us with their lives, with the most intimate secrets of what had happened to them and how they felt. And then you are convincing them to then take that in front of 12 strangers and help them tell their story. What an honor. What a honor to be trusted in that way by other human beings in the state of Georgia and around the country. So I'm open for questions. Yes.
What happened to the Atlanta Police Department?
Nothing. So the question was, what happened with the Atlanta Police Department? Nothing happened with the Atlanta Police Department. I'll tell you what the ripple effect of. This happens in January. And in February, the same guy just goes from this spot to another spot in DeKalb County in Dunwoody. He does the same thing. And so on April 7th, we'll be suing that spa and their owner and their managers because the police reports were out there. And we say that if they had done any at all background check, one, he still was unlicensed, he was still untrained, and he was still allowed to be in a private room with our current client. So it just shows, sometimes what we do is to try to stop additional harm in our community. We have to stop them.
The defendant have insurance coverage to
Nope.
for sexual assault?
Nope.
Where are you on?
We're trying to collect. File bankruptcy, going through the whole, everything. That part has, it's almost like they feel re-victimized because they hadn't been heard for all of these, this was over a 4-year period. They had not been heard. They didn't feel like the police took them serious, anybody. Then this jury finally, the jurors came out afterwards and we asked, as we all do, can we talk to you all? So they said, we want to hug your client. And so they came out hugging the clients and, and then they talked to us about the way the case went, how they thought, what they thought was effective and the challenges. Some of the defense was really weird. One of the things that they tried to allege was that they were in cahoots. because they could not understand how these two women could bump into each other. And so we had to debunk this issue. And it was literally, she sees the police and she's coming out and she reports right away. And so that was one of their, they were trying to frame this guy. Obviously, him not being there was, he didn't speak for himself. Yes.
I sue car dealers for a living, and this is a weird question, but I had a woman who was arrested based on a lie from a car dealer, and she had to have her body cavities searched at the jail when she was arrested falsely. And how do you argue to females on the jury what the value of that is? How did you argue the value of the damages for whatever happened to your clients?
Yeah, it's a great question. And I'd love to talk to you afterwards as well, because we have dealt with a couple of those cases where the car dealers will falsely report a car stolen because they want it back or some crazy stuff. What we did was we really let our clients talk about what's different now for them. And they were both in counseling about what happened and they didn't stay in counseling. I just want to be clear about that. But it never left them. They continued to think about it, and they admit they shared that they went to counseling. It got manageable, but neither of them ever went back to get another massage ever. Neither one of them ended the relationship that she was in. And she ends up now, she's engaged. And one of the things that I like from, I think it's Jesse Wilson, he talks about being a victor and not a victim, right? And that all of our clients are so resilient. Like when you have a client, I'm not explaining that they should have laid down and stayed down. What we're showing is that they were harmed. They have been fighting through this, but it doesn't mean that they are not unaffected, and that's the way we try to lay it out, that it still is impacting them, even though they found the courage to keep pressing forward. Don't penalize them for being courageous.
How do you ask the jury for a number? How do you say this digital penetration is worth this or whatever?
We didn't do it as a, we didn't break it down in that way. We talked about what was taken from them was their sense of safety, their ability to go somewhere and experience a level of tranquility that was taken. Now, value it in that way. So we didn't break it down to the physical assault. It was what is happening has taken something that can never be restored. And it may get better, but it never goes away. Yes.
How many days did you try the case in?
4 days. 4 days. So we started and they came, it wasn't long, and we were intentional about trying to keep it short. And I can be notoriously long during jury selection, but I'm working on that to try to keep it short and focus in on people who believe rules are important. We were looking for that group of folks.
And then how'd you decide to try the two ladies together versus two separate cases?
Yeah, we just thought that it would be powerful. And there was obviously the concern for the first one was what notice did they have about him? And we leaned hard on the fact that he was unlicensed. It's just, that's negligence per se. And we ran with that. And we thought trying them together would be very powerful for them to see how this was a system failure. And that's the other piece. I think I heard one of the other presenters earlier. How do we frame what's happening as a system failure? And the system, the management, the owners should protect. They have a duty to protect the public, and they failed in that way. and seeing both of them made it clear this wasn't a one-off. All right. Well, I appreciate it. It's been an honor and look forward to seeing you all in court somewhere.
As I expected, I would follow Mawuli into battle any day. What a great presentation, and I applaud your continued work to help folks like your clients. Our next speaker is Jimmy Rice. Jimmy has a firm, Rice, McGowan, and Brandt, and for over 30 years, he's been achieving some of the biggest verdicts and settlements in Georgia. He's widely regarded as a premier trial lawyer, and he could speak on those, but in particular, I wanted to ask Jimmy to talk about a trial he had last year under our new bifurcation statute. And I think it was in the early stages, and maybe his trial court had not had experience with it. But I think some of the rulings in his case didn't go his way, but he was able to adapt to it. I think it can be a warning to us when we start trying more and more of these bifurcation statutes on what you need to do in advance to educate the judge, to try to get the court on the right path. It's my understanding in his case, and I won't steal his thunder, but the judge wouldn't let him talk about injuries. And I think that's a misunderstanding of the law. You have to talk about injuries in the liability phase. That's in the statute. You can't talk about damages, but there's a big difference between damages and injury. And borrowing from some of the better lawyers that I know, I've gotten a brief that we file in advance to kind of prepare the judge for that. And in our last trial, it wasn't a problem. We were able to talk about the injuries, just not the pain and the suffering or the value or things like that. That's for the second phase. But Jimmy, come on up, and I look forward to hearing about how you handled all those issues.
Thank you, Rob. My name again is Jimmy Rice, and I appreciate everybody being here today. I wish I had a great trial story. I do, but it's not nearly as good as Adams and Natanya and some other folks. Adams should really be a movie. That was an incredible trial and outcome. I have something a little less interesting, but still I think very important. And like Rob said, we're going to talk about bifurcation. Under 51-12-15, it goes from A1 to 3. And Rob is correct. We tried our case in the fall of last year when bifurcation was still new to many judges and been interpreted many different ways. Informal opinions indicate at this point, almost all judges, I'd say about 80% of the folks I spoke to, said when bifurcations are filed, they're typically done, as Rob said now, with duty, breach, and proximate cause to address the injuries. And the second phase, dealing strictly with the damages, which is obviously much shorter. But it's still very important, as Rob mentioned, to be prepared for judges like the one we had, who was an excellent judge, who tried to get it right. I think he got it wrong. And as Rob mentioned, to adapt to those rulings in different areas. So what I'm going to do today is go through a little bit of our trial in terms of the procedural aspects of it, how we adapted to it, and how to argue your case. It's not something that you want to start a trial not knowing which way a judge is going to go on the bifurcation issue for a lot of different reasons. So procedurally, it's very simple. It's available to either the plaintiff or the defendant. Some of the things we can talk about later are when the plaintiff, should agree to the bifurcation, when a plaintiff wants to keep it and stipulate to $150,000. There's some cases that's probably the right thing to do. It's available only to those cases involving personal injuries and wrongful death. And the only requirement is it has to be done prior to the entry of the pretrial order. For older cases, the statute went into effect April of last year. But even on older cases, the judge can use his or her discretion to go ahead and enter a bifurcation order, even if the pretrial order had been entered prior to that time. The last thing is, if neither party enters bifurcation or requests bifurcation, the only thing that happens is it's tried as it would prior to April of last year, with everything done at the same time. Two exceptions. Both of those exceptions from a procedural standpoint are fairly straightforward. One is it involves sexual cases. There are a lot of what a lot of us do, which is negligent security. Either where a minor or the plaintiff has been sexually assaulted for some reason. You can move for bifurcation. It's important to note that's something you have to do by motion. You can't just tell the judge you don't agree with it. You have to actually move and state the reasons why. It's discretionary with the court, but it'd be hard to believe that many trial courts would use their discretions to force someone who's been sexually assaulted to testify twice, being the liability phase and then again on the damages phase. The other reason that you can set aside or move to set aside the bifurcation request is if there's a stipulation that the amount of controversy is less than $150,000, basically akin to the $75,000 remand rule in federal court. And the reason this could be very important to a lot of plaintiffs' lawyers is we all have cases that we say, I'd love to get $100,000 from a jury, but it's unlikely to happen. And so it's very important to set your ego aside. And when you go to court and you've got a case where you got a very nice client, he got hit, he went to the emergency room, he went to his family doctor sent him to the orthopedist sent him to physical therapy, back to the orthopedist and maybe an MRI. And he's got about $17,000 in medical bills. You've got great property damage and you're a fairly good venue. Your case at trial, depending on what happens, is probably worth somewhere between $35,000 and $55,000. There's no reason for you, setting aside if there's any punitive issues, there's absolutely no reason for you to go in there and turn a $50,000 case into a $20,000 case by asking for $500,000, insult the jury and tick them off at you. All you have to do is agree that it's $150,000 or less. That's I think the wise, learned thing to do. But that's your other option. The other option is, again, on the sexual assault part, and the only burden is to show that it's going to likely to cause psychological or emotional distress. What we addressed in our case, and we're on the wrong end of it, is when these cases, or when the talk of tort reform first came out last year, late 24 and into 25, a lot of it was they're going to bifurcate cases. And what the knee-jerk reaction is, and even when we tried our case last year, a lot of trial courts' knee-jerk reaction is bifurcation simply means in the first phase, you're only going to talk about fault, duty, and breach. The second phase, you're going to talk about the injuries, proximate cause, and you're also going to talk about the damages. And when you read the statute closer than some of the judges did or do, you'll find that's, as Rob mentioned, probably a very incorrect interpretation of what it is. And so when you read the statute itself, actually brought a copy, it's clear, and it's important to be clear, because it all goes 1, 2, and 3. Section 1 is phase 1, section 2 is phase 3. Section 3 goes to trifurcation when it involves either the amount of punitive damages or attorney's fees and expenses. So when you look at phase 1, it's actually broken into 2 parts. The first part says the trier of fact shall determine the fault of each defendant, which is what most of us expected when they first began discussing bifurcation in the legislature. Who caused the accident? Who was the proximate cause of the incident itself? But then the statute, more importantly, as noted here, it goes on to have a second part, the connector word, and any defendant is at fault for the plaintiff's injuries or wrongful death. So it really has 2 elements to section 1. First, you have to show who's at fault for the incident. And second, the connector and says if the trier of facts the defendant is at fault for the plaintiff's injuries or wrongful death. That's proximate cause. So you can't comply with phase 1 unless you show fault for the incident. And the second phase is proximate cause. You then go on to see further in the statute, it talks about determination of the total amount of damages. Again, this is still in section 1. Section 1 emphasizes that section 2, which is phase 2, is simply trying to determine the compensatory damages to the case. So Dave Krugler sent me some cases that are great. And so thank you, Dave. The most relevant one, I believe, is Zaldivar versus Prickett, and that deals with the apportionment statute under 51-1233. And in Zaldivar, the Supreme Court had to look at what fault means and what it means in terms of the apportionment statute. And when you read Zaldivar, the Supreme Court says that fault requires a determination that relates to proximate cause of plaintiff's injuries. And even when you read 51-1233, it says the same thing, that you have to determine not just the fault of the incident, but you also have to determine the fault of the injury sustained as a result of that incident. You can also point out to the court things like Black's Law Dictionary. There's lots of different things to look at. The other thing that's really important about the statute itself is that when you look at the second portion of that statute, element 2, It says in the second phase, the trier of fact shall determine compensatory damages to be awarded to the plaintiff. It says it'll be limited to that. Because the first part says defendant, if the defendant is at fault for the plaintiff's injuries as determined in the first phase. So the second element of 51-12-15 reinforces the first element. In the paper that's attached, you'll see a lot of different, I don't think it's on here. No. You'll see a lot of different topics that nice sound bites from the Georgia Supreme Court that we always hear about. The legislature meant what they said what they meant, and meant what they said. Talks about the interpretation of the common use of words and things of that nature. All these things are really important to point out. And what we did in our brief to the trial court in our case was that it would have been an easy fix, because appellate courts really don't look at the legislative history. They just look at the text that's contained. And here, what we put in our brief, which didn't work, how easy it would have been to simply take out that and replace it with the incident. They actually could have stopped before the word and they would have been fine. But they didn't do that. They probably didn't do it for a number of reasons, including that in terms of due process, voir dire would have been virtually impossible. But all this is important, and we even attached that, I said, to let the court know how it could have happened and how it could have been replaced much easier. But all these things are critically important for you to bring up, not on the morning of trial. A lot of us have tried a ton of cases, and we all run into the judges that do not like motions in limine on the morning of trial. And the older judges still like to only get motions in limine on the morning of trial. But one of the worst things you can do is have a very smart judge rush through the arguments in this case and make a very hasty decision on what they're going to do. And it impacted our case a great deal. We could not discuss anything regarding our client Heather's surgery that she had, her medical care, anything that dealt with proximate cause that I think would have had a favorable influence on the jury. Instead, she was up for 10 minutes talking about the collision itself. One of the ways that we discussed as a result of that ruling, and like Rob said, kind of adapting to that ruling, was during voir dire. I believe voir dire is probably the most important, well, one of the top 2 or 3 most important parts of any trial. And voir dire is important because that's your opportunity to let the jury get to know you on a more personal level and get to know your client somewhat on a personal level. And so if you're stuck in a situation with voir dire, we know at the end of the case, the defendant, despite any motion in limine, which I'd recommend you, the motion in limine that you file to try to get the defendant from being able to state on phase 1, well, and it happens a lot. If you check, 50-50, if you check for the defendant, your work here is done. The case is concluded. We can all go home. And in the jury's mind, they might be thinking, well, it's Wednesday. Otherwise, I don't know how much longer I could be here. Maybe Friday, maybe Monday. These guys talk a lot, right? So you're going to file a motion in limine on that. The judge will probably give some leeway to the defendant, just like we give some leeway to you to be able to say why you're bifurcated in this case because of the defendant's decision. But in this case, voir dire is the tactic or the strategy that we all should employ to let the jury know what's going to happen. And when you do voir dire, I think it's important to let the jury know as much as you can about the damages. A lot of it gets so caught up, especially if you're dealing with a tractor trailer collision or a motor vehicle collision, to ask people about, have they been in a car wreck before, things like that. But if you ask more pointed questions that they know could only be about your client, has anyone here had a 3-level fusion? Has anyone here incurred over $400,000 in medical bills as a result of a collision? Does anyone here know anybody whose lives have been destroyed as a result of shooting, sexual assault, anything like that? You want to ask these questions not only for the purpose of picking your jury, but keeping your jury. Because when the defendant's lawyer stands up and says, you know what, we could all go home if it's a defense verdict, but if not, we'll come back tomorrow. You want the jury interested in your damages. You want them to know what's coming down the next day that they get to hear about. And if your damages are significant enough, it's going to be something that they're going to want to help your client. If he or she is a nice person, they're going to want to help your client. They're going to want to hear phase 2. And so a lot of us get caught up in the immediacy of phase one and getting by liability, that we totally ignore the situation in phase two. And that's important to keep in mind. When I was a very, very young trial lawyer, I lost my case and I didn't want to lose 2 in a row. So it was up in Gwinnett County. It was just a car wreck case. And I didn't ask for a number, which I think is a huge mistake, because all I wanted to do was win and get something, get kind of back on the horse. And so the jury came back and they gave a plaintiff's verdict, and it was a modest plaintiff's verdict. And I said, well, why didn't you give more? And they said, well, you didn't give us a number. You didn't ask for anything. We would have done whatever you asked for, but you didn't ask for anything. And so it was important to learn in that case that unless you ask, unless you tell them, even in voir dire, you're very limited. Like we talked about earlier today, you're limited in what you can tell them in voir dire. You're limited in a lot of aspects in closing arguments these days. But there's nothing wrong with asking if anyone has any opposition to a significant verdict or a 7-figure verdict, or anyone that couldn't properly award a verdict that may range and we feel is valued at 7 figures. There's absolutely no prohibition against that. Let the jury know what's coming down the pipe so they know they're interested and want to help your client. And when you think this through, think about the opposite. If you're going in there and you decided that you're going to swing for the fences and ask for $300,000 on a soft tissue case where your client has $15,000 in bills and has made a full recovery and hasn't seen a doctor in a year but plays church softball, that's probably your fault. And when you think about it, now you're stuck, instead of being able to say, who's had $300,000 in medical bills? Who's had a 3-level fusion? You're asking questions about who sees a chiropractor? How do you like your chiropractor? Is he a good chiropractor? And when you go in there and ask questions like that, you're giving the jury absolutely no incentive to want to stay around for phase two. And that should be a strong consideration for all of us when we decide whether or not to stipulate to a value of $150,000 or less. So in our case, what the judge said is we're not going to talk about anything but fault in terms of duty and breach in the first phase. And so what we had to do is a lot of what, not knowing that, because the motion in limine he wanted that morning, he was a senior judge, but a lot of that caused a lot of need to do a lot of things very quickly. And that's why I always recommend, if at all possible, file your motion in limine on bifurcation and get an order from the court on bifurcation. And this is more from a practical aspect, because there's nothing more difficult than being at your office or house at 10 o'clock at night, and you're talking with your videographer or tech, and you're trying to redact this and redact 2 sentences and 1 line and 2 words. And all of that changes if things change as far as you're trying to case all the way with proximate cause and damages in phase 2 versus the whole, everything but damages. So it's important there. It's going to be important to think about in terms of your witnesses, whether you've got before and after witnesses. And some may have knowledge not only on damages, but some have knowledge on proximate cause and whether these were pre-existing issues. Same thing with medical records, which can be very difficult to redact. And what's a pre-existing injury and how that affects proximate cause and how it affects damages. And there's going to be some carryover. And there's going to be some discretionary decisions by the court that you need to have addressed, because juries know when there's a delay, they know it doesn't take them long to figure out who's the problem lawyer. And you don't want to be that person. And the judge knows who's the problem lawyer too. And you will know, you'll feel the wrath of that, especially if it happens twice. But it doesn't take long, as we know, for jurors to figure it out. So all those things are important from a practical aspect, so you can line up your evidence properly. So I can't emphasize enough the importance of voir dire and picking your jury and giving them what's coming down so they know what's happening and they know it's important to you. Once you get the evidence and you start your case, Leighton Moore provided me with a preliminary instruction. And I like preliminary, well, I don't like them, but I like this preliminary instruction because it talks about, it's in the handout, but it talks about what bifurcation is and allows all of us in our opening to talk about what bifurcation is as well. And so it's important that you're able to discuss that with the jury so you can give them a foundation for what's going to come later in the case. There are a lot of, I put in here, advantages to it. So we all know picking a jury and you've got your colleagues and maybe a consultant or somebody there with you, and you're not always right. And sometimes you're horribly wrong. And it's important as the trial goes by, we all make our own observations. And we see, I'm of the personal belief that if you're the first one coming in or the last one coming in, you're often going to be the foreperson. Sometimes you see little fractions of people meet. Sometimes you'll find what I call the sleeper, right? They don't care. They're just there getting their $25. And then you've got your note taker. All those things are going to be more important with bifurcation than they were before. And the reason that's true is when you have two tries at opening statements. So when we tried our case, we did not feel, just looking at people's faces and their body language, we did not feel that phase one was going as well as we would like. It's sometimes hard to read people and hard to read their emotions, the laughs when you try to make a laugh happen. And so what we did is we changed our strategy and switched it around based upon who we knew, and we were correct, was going to be the foreperson. And we did the same thing in closing arguments. The foreperson turned out to be the CEO of a tech company. And so when you think about a tech company, you think of logic, you think of people who like formulas and numbers and math and how things work. They're not always, touchy-feely type people. And so in the closing arguments, I relied heavily on logic, relied heavily on the jury instructions and to follow those instructions. So we had a second bite at the apple, both in opening, and we had a second bite of the apple as it relates to the closing arguments with the jury, and it paid off very well. The same thing with the note taker. In opening statements on the second phase, you can speak directly to them. Can't speak directly to them. You can look at them as you're talking and ask them about certain things that they're going to write notes down. We like to bait stamp a lot of our documents if we submit medical records. So in the second closing, if you're the note taker, you can look straight at the note taker and tell them, when you guys look at bait stamp 295, you're going to see this. When you look at bait stamp 312, you're going to find this. And the note taker takes it down, and then you inform who's likely going to be the foreperson. Rely on these people that take good notes. You want to be polite, you can begin to ignore people the sleepers and folks like that. You're also going to have to address other people, the eye roller, the people that you can tell possibly don't like you, or your client or your case, and you can address those as well. But it gives you a second bite at all of those different things. And again, that's going to be very important to your case. The last couple of things to remember are when you do closing arguments is to be prepared for what the defendant's going to say. And you can use, I think some people call it judo lawyering, where you take what they say and you turn it back. Of course, they want you to say that. Of course, they want you to go home. They're inviting you to do that. They're inviting you to ignore your obligations and duty. They're inviting you to ignore the damages my client suffered as a result of these things. And you want to turn all of that against them throughout the case. The last couple of things are stealing the clothes. There is an issue in a case where there was evidence in phase one, but there was no evidence in phase two. And the defense raised the argument, since they didn't put up evidence in phase two, they're entitled to the closing argument in phase two. And the trial court denied that. And it's important to know that we don't have two separate trials, right? That's not what bifurcation is. Bifurcation is one trial divided into two different parts, two different phases. And in your paperwork, there's a case that talks about that. But you should never allow them to steal the clothes, nor would they ever be given an opportunity to steal the clothes. The last thing is the third part of the bifurcation statute talks about trifurcation. And trifurcation would also require you to file a motion, and most defendants do this now, just like they do when they file an answer. It's just a request or movement for bifurcation. And so with trifurcation, the third part would be coming on the second phase, just like we do if you've tried punitive damages cases. So when you try a punitive damages case, the jury comes back and they award compensatory damages, and then they check yes or no. something to the effect of, did the acts of the defendant rise to the level of willful or wanton or drinking and driving or, hitting and run such that you believe punitive damages are warranted? If they check yes, under the trifurcation statute, then you move on to the third phase, where they decide the damages. The other aspect that the statute talks about is trifurcation during the third phase includes both liability and attorney's fees and expenses when you're dealing with things such as 13,611. What's important about that from a pragmatic point of view is they changed the law last year under the offer of judgment statute that preempts or prohibits you from getting attorney's fees under 91168 and 13,611. So it's important from a pragmatic point of view, if you are successful in receiving a verdict that's 25% higher more than your offer of settlement, that it's important on whether you want to roll the dice and ask for attorney's fees, knowing at the end of the day, you're only going to recover one or the other. And you may say, well, I'll just take whichever one's higher, but you also need to know when you filed that offer of settlement, what percentage of your attorney's fees are going to be accounted for in that. And of course, you need to know your judge. We had a trial 2 years ago involving punitive damages, and the verdict was just over $1 million. And when we moved for attorney's fees, the judge couldn't believe that anybody earned 40%. And she wanted to do everything by the hour. And it turned into quite a mess. And in any event, she was very nice, very kind judge. And she ended up entering a judgment and awarded us, I think, a little over $100,000 in attorney's fees. But that was something that I didn't know the judge. And the jury had awarded us attorney's fees, and opposing counsel Bill Calsert entered the bill that passed that we couldn't do that anymore. So those are things that from a practical standpoint, you need to keep in mind. So to sum it up, it's a procedural aspect. You need to always be aware of when the defendant does it. You also need to be aware of if you want to do it, which is very rare if you're the plaintiff that you would want to do anything like this, but there are circumstances you may consider it. And most importantly, if you're the plaintiff's lawyer and you're trying these cases that involve car wrecks, we all have them, you really need to get some consideration to agreeing that your case is worth less than $150,000 or stipulating to an amount less than that. Juries appreciate brevity. These cases last a lot longer when you have 2 openings, you have 2 closings, not simply because they're longer, but because you get the breaks. There's always the straggler that comes in. Anybody seen Mr. Smith? Bailiff, can you go find Mr. Smith? Here comes Mr. Smith. Back to sleep, Mr. Smith. So those are things that you really need to keep in mind, because jurors like brevity. They like quick trials, especially in smaller cases. So that's a recap on the bifurcation statute. I'm happy to try to answer any questions that you have.
What did your judge say to the jury, if you remember, in terms of how was the jury made aware that there may or may not be a second phase?
He told them that on the first phase, the only thing we're going to talk about, he was very dogmatic about it. The only thing we're going to talk about is duty and breach. He did not, he went over in the jury instructions, comparative and contributory negligence. And all that was fine, Rob. The problem I had was on the second phase, because again, I go back to, this is one trial divided up into 2 phases. And so I wanted to explain to the jury, just like we do in any premises case, whatever percentage of fault, if any, you find, it's going to reduce the verdict by this amount. And the judge said, absolutely not. And when you look at A2, there is a little bit of support for that the only evidence you can present and the only argument you can have is about that issue, which is damages. But what I argued to the judges, that's not what happens in trial. The jury needs to be aware of that. And actually, when they came back, there was some comparative negligence. And when we spoke with the jury, they wanted the client to walk, as they often do, walk away with a certain amount and they didn't get to use backwards math. So I think it achieved perhaps the result he wanted. But it was very frustrating not to be able to talk about that with the jury.
I think we need to make a push to have the jury educated, in this portion of it, how that number is gonna come out.
Absolutely. And that's the first time in a lot of trials that I've ever had a judge do that. And I think it had to do with, I spoke with Naveen in my area, and there's no current appellate appeals involving it. And I'm not sure how it would even get there or how you would determine what's appealable in terms of discretion. But as of now, there's no appeals, and it's difficult to assess, but it certainly makes your job more difficult when you're dealing with a comparative negligence issue. Try to explain how that could impact the verdict to a jury for sure.
Questions?
Thank you, everybody.
Thank you, Jimmy. That was very helpful. We had we had the bifurcation issue in our trial, and I was fortunate enough to get ahead of it with our judge. She ruled the correct way in that we could talk about injuries, but she also realized that it would be somewhat prejudicial to tell the jury that they could go home, if they find for the defendant or if they check. So she deliberately prohibited either side from making any type of remarks to make the jury feel like they could go home sooner. But interestingly, one of the defense attorneys, after I'd called my expert and they cross-examined my expert, and the judge said, "May this witness be excused," this defense attorney stood up and said, "Your Honor, we would like to reserve the right to call the expert in the second phase," knowing that he was not going to call my expert in his case, but he just wanted to get out in the second phase to the jury. I thought that was a little scrupulous, but anyway, we're going to take a break. Let's come back in 15 minutes and we'll have two more really good speakers, and that'll wrap up the day.
I think you can call a motion limiting to prevent this state. They fine for us, we go home.
I forget how I styled it, but we have a very long. Get okay.
Yeah. Just watch Zoom live, and if there's a hearing going on. It's all you.
Yes. What did you hear?
Watch the-
Is the mic still on?
I went out of
Sure about it. She's while I was so living today.
So the,
There are some things that I see in life that I just can't comprehend. Like just this past week, they had a special 60 Minutes that I saw about this 12-year-old girl that was a prodigy. She could play the piano unbelievably and the violin, and she wrote a symphony that I think it was the symphony orchestra put on, and she was the star of it. It just blows my mind that a person can have that much ability. And Matt, in the field of law, has always amazed me at the amount of work that the success he's had, the amount of work that he puts out, the trials that he has. He has won verdicts in trucking cases, construction cases, dram shop cases, wrongful death cases, product liability, and I'm probably missing several other types of verdicts. But he's just the man of all talents when it comes to taking a case, understanding it, presenting it to a jury, and obtaining verdicts for his clients. 6, 7, 8-figure verdicts. And this past $70 million verdict, and he's going to talk about that in some of his other trials. But I will never be able to comprehend how you get all of that done, and so often, year after year. His track record is just unbelievable, and I'm so glad to have Matt come and speak. Matt Cook.
All right, that was a very nice and probably undeserved introduction. First of all, I want to thank Rob and the folks helping put this on. This is a lot of work, but it's very helpful to all of us to know what's going on in the courtroom and in the law out there, because I've been practicing 27 years and things change as we go forward. And you've got to continue to learn, continue to be relevant. And it's hard to do. Number two, congratulations to Rob on his recent med-mal verdict. It's a great result in a tough venue. Number one thing I'll say about Rob, though, is this. He was a year ahead of me at Mercer. I didn't know him that well. But every time that I call him some tricky issue in my case that I want to discuss, or I need an expert, he is always happy to pick up the phone, spend as much time as you need, and to boot, the advice is helpful. So unlike my advice to my kids, it's always helpful when I get it from Rob. So I'm going to talk to you. He called me and asked me to talk to you about some of the verdicts I've had. Our firm has started 10 trials in the last 2.5 years, and we've tried 7 of those to verdicts. We've had a couple of mistrials and settlement along the way, but we've tried several cases here in the last couple of years, and I'm going to try to share some of the lessons that I've learned along the way. So first case I'll tell you about is a case that we had. I don't know how to advance this. Technology is not my strong suit. Talking about my success, my wife says I'm kind of like Seabiscuit, a little short-legged and run sideways, but if I get up to speed, I do okay. I don't know. Anyway, I'm going to just tell you a little bit about the case spending time, and we'll get this PowerPoint one. So last April, we had a trial down in Albany, Georgia, represented a exceptional, young, beautiful, personality plus young lady named Jessica Powell, who at 26 years old had the world by the tail. But she was diagnosed when she was 26, living up here in Atlanta, working her first job out of college with a condition called Addison's disease. That's a condition that John F. Kennedy had. And Addison's disease is a situation where, let me try it before you go. All right.
Here we go.
Thank you. So Addison's is a adrenal dysfunction. Your adrenal glands make cortisol. Cortisol controls your blood pressure. And if you don't make adequate amounts of cortisol, you can't maintain your blood pressure. The fix is fairly simple, though. You take a daily supplement of hydrocortisone, sometimes prednisone, and you should be fine. It's a lifelong disease. You have to take your medication regularly. And it's managed, though, more like an art than a science, kind of like diabetes. So when you get sick, or if you're female and you have a menstrual cycle, your body has higher physiological demands for cortisol, so you need to take a little more. If you're retaining too much water, then you maybe take a little less. So Jessica was diagnosed when she was 26 years old. She had moved back to her hometown of Camilla, Georgia, down in southwest Georgia, below Albany. She's working at a pretrial, or not pretrial, my God, we've done too many cases, at a preschool. And there's a rip-roaring GI bug that comes to the school, is prone to happen with kindergartners, and she picks up the bug. And she starts vomiting. She's feeling very sick, and so she stays at home the first day. Her mom, who's also a teacher, goes to school, comes home to check on her the next day at lunch. And she finds Jessica has thrown up all over the house, and she's wandered from room to room, and Jessica's not making a lot of sense. And when your cortisol drops and your blood pressure drops, sort of like diabetes, you can become confused and that sort of thing. And she hears Jessica fall, runs into the bathroom. She finds her collapsed by the toilet. Her lips are turning blue. She's barely breathing. Her mom's scared to death. She grabs an emergency stress dose of hormones, gives it to Jessica, and calls 911. 911 shows up in 3 minutes at the house, and Jessica has no heartbeat. She's in full cardiac arrest. They put the paddles to her, shock her back to a rhythm, get her in the ambulance, head to the little hospital there in Camilla, and she has 2 more cardiac arrests on the way. So what happens is you've gone into shock. When you lose your blood pressure, you've gone into shock. And there's three things that control your blood pressure. One is your heart has to be working, so it's got to be pumping good. Two, you got to have enough fluid in the system, in your vessels, blood and water, to create a pressure inside your system. And number three, you have to have tone in your vessels. When you go into shock, your vessels dilate, and so you lose pressure. So the treatment is make sure they've got a heartbeat. Number two, make sure you've got them volume loaded. So you load them up with saline. You're giving them as many fluids as you can. Number three, you want to restore tone to those vessels. So you give something called vasoconstrictors or vasopressors. These are very powerful drugs. And what they do is they squeeze down the vessels in your legs, your feet, your hands, your fingers, your arms, and they drive all that blood to your liver, your kidneys, your heart, your brain to try to preserve your life. Now, vasopressors are very powerful medicines, and you only give enough to achieve the result you want, and you got to get them off of the pressors as soon as you can. Because what you're doing essentially is applying a chemical tourniquet to the patient, like putting a rubber band on a puppy's tail. And when you put a rubber band on a puppy's tail, if you don't take it off soon enough, the puppy's tail will fall off. And if you put a tourniquet on somebody's leg, and like a chemical tourniquet like these act as, you've got about a 6-hour window before tissue starts to die in your legs. And so Jessica arrives at the little hospital. They start her on 2 of these vasoconstrictors. They ship her up to Albany, to Phoebe Putney Memorial Hospital, and pray that you never have a family member that has to stop there. But she arrives at the ER. Her blood pressure's 50/30. She's on 2 vasopressors. She's had 3 heart attacks. Critical care comes out. And I believe they assumed that Jessica was going to die. And so they gave her a 3rd vasopressor called vasopressin. And these medications, like any medication really, have very strict tolerances. And the doctors write instructions on how they're to be administered. And on this one, the instruction was 0.04 units per minute to a blood pressure of 95, and then titrate down, bring it down every 10 to 15 minutes when she gets that blood pressure. So the instruction of the nurse is the dose, 0.04 units a minute, and check on her every 10 to 15 minutes. And as soon as she gets a good blood pressure, get her off or bring her down. So this is why when you hear that Georgia high school students finish last in math every year in the country, you should be panicked because units and CCs and 0.04 and 0.1 are a big difference. So the nurses start her not at 0.04 units a minute, but at 0.1 units per minute, 2.5 times the max dose of this medication. And her blood pressure comes up within a couple hours. And they don't make one single downward titration of her vasopressin for 48 hours. So on Sunday, she's a totally different person. She's doing a whole lot better. And they come to give her a bath and they pull back the sheets and her left foot is turning black because it's had no blood flow. Nobody's checked on her. And the medicine's still running at 2.5 times. Now you hear these stories about what this doctor did or failed to do, or what the nurses did or failed to do. And I heard Adam's presentation, and it was excellent. But I was wondering why did Dr. Rowe send the guy home? Why didn't he engage in that? And of course, you'll never get that from the defendant. But in our case, what we learned was, and what we believe, is the nurses would often dose in cc's, and the doctors often write in units. And it turns out that 6 cc's is 0.04 units a minute, what was ordered. But 6 units, if you type that in, is 2.5 times the max dose. So we believe they keyed it in as units rather than cc's, and that was the problem they had. So on Sunday, her foot's turned black and everybody in the hospital is nervous. This is a case that came in to me from Jay Powell, who was a lawyer down there. He served in our legislature. He had been my local counsel in a trucking case I tried in Mitchell County many years before. And the case came to me 5 weeks before the statute ran. Why? Because the family just couldn't deal with their daughter who lost both legs above the knees as a result of this. They knew everybody involved. They knew the doctors. The mom had taught one of the vascular doctors. So it's a big ordeal to undertake a medical malpractice case. And they had no idea if there was an error or not. So on Sunday, her foot's turned black. The critical care doctor calls a vascular surgeon to consult, thinking maybe she has a clot, but that wouldn't explain why both legs are not getting good pulses. The doctor comes in, a guy named Dr. Morgan, who's a local down there, well-known, and he looks at her, and within 2 hours of him being there, this medicine that they would later say was necessary at this rate to save her life for all this time was taken from 0.1 to 0 in 2 hours. Of course, the defense was, had we not given it to her and had we not kept her on it all this time, she would have died. And it was just a coincidence that we took it off when her foot turned black. That was the position. And so what Dr. Morgan didn't do, it was a series of errors, as often happens in medical malpractice cases. He didn't contemplate what happens when we take this medicine off and all the blood comes rushing back to Jessica's feet and legs. And he used an analogy in the case. It says, you know, in North Georgia, we have to deal with this. You leave home, your pipes freeze, and they're froze solid, and pipes are cracked, but it's ice in there. So you don't get any water in the floor. You just got cracked pipes everywhere. It's kind of what happened when Jessica was clamped down. Her vessels were being destroyed, but she didn't have any blood flow. What happens though, when things start to thaw and the blood comes back, it starts to pour out and leak out of the vessels. And then you start to swell. And inside your calves, just like in your forearms and your feet, your muscles are covered in fascia, or a very tough silver looking coating that will not let the muscles really swell. So you bleed, they swell, they compress back on themselves because they can't expand. Then they bleed more, they swell more, they compress more. So it's a vicious cycle called compartment syndrome. And a compartment syndrome is something that you have to watch out for. Anytime you've had a lack of blood flow to your legs for a prolonged period of time, it's well known that there's a reperfusion injury that can happen. People that go in with a clot, if that's been in there 7 or 8 hours, they take that clot out, the doctor will watch for a compartment syndrome. It's a very easy thing to fix. You do a fasciotomy, you just slit the leg or the muscle, let it swell, and then sew it up when it's done. Well, Dr. Morgan, unbeknownst to the jury, unfortunately, had other things on his plate that day. He saw her. He didn't think about the reperfusion syndrome. They took the medicine off. He was busy carrying his dad to check him in at the federal penitentiary a couple hours away, who had been convicted of Medicare fraud down there. And so he left her in the hands of his PA. And over the next 12 to 14 hours, not only was Jessica's left foot turning black and blue, but both of her feet turned black and blue, and she ended up having both legs amputated above the knees. She's ultimately shipped to Emory. One of Jay, her dad's friends, called him to the side. One of the doctors said, "Jay, you need to get her the hell out of here." So they shipped her to Emory, but it's too late. Loses her legs, wakes up, 0 injuries, except no legs. So had she been properly managed, there'd be no injury and no consequence. So we get the case 5 weeks before the statute, and Shane Lazenby's a friend of mine, and we've had cases together. I was getting ready for a trial, and I said, "Shane, we got to figure something out. You know, you want to work on this with me?" So we had 45 pages of records out of like 4,000. That's all she had. And nobody had told her what had happened. We had no clue, nowhere to start. But I told Shane, I said, you don't go to the hospital at 28 years old and come out with no legs unless somebody screwed up. And I've done a lot of medical cases. I know a lot of medical terms, but I'll tell you what I know about medical cases is you cannot credibly review a case without having the right expert in the case. You can read all the terms you want, but if you don't have a medical degree, the truth is you can't really figure out the medicine unless you've had that case before. All you can tell is, do we have a bad injury? And does it seem like it shouldn't happen? So we sent it out to an ICU guy. And he comes back, I don't see anything wrong here. I mean, it's just one of these things that happen. You can lose fingers and toes. And I told Shane, I said, no, this guy, he didn't give it a good effort. I can just tell. You know, you can just read these people. And, you know, the burden is heavy in a case like this. The statute's bearing down on me. This is a lawyer's daughter, a good person with a tremendous injury. And I believe there's an error. But it's really stressful to be in that situation. So we ended up sending it out to 2 more ICU docs, and I get a call on a Saturday from one of them. He's at the park with his 9-year-old son reviewing the records. He's like, guys, I think I know what happened. They just overdosed her. They've given her 2.5 times the max dose of the meds. I'm like, wow, okay. And then we get a vascular guy who talks about the reperfusion injury. So we filed the case. We're off to the races. So you think a clear medication error is going to be, let's settle this case, let's do the right thing and move on. But there is no pancake thin enough that the defense cannot, medical insurers cannot come up with something to talk about. And so for the next 7 years, we were in a fight of our life, and we had experts fall apart. We had new theories come up. They disclosed 15 experts. And regardless of what the science said and what the medicine said, they can find somebody with really great resumes, really well-heeled experts from Harvard and Stanford, you know, and can come in and talk with their, you know, pleasant accents and keep everybody calm and say, nothing to see here, folks. You know, I do it all the time. You know, they did a good job, life over limb. We saved her life. You know, hell, she ought to write us a thank you note. I can't believe she has sued us. You know, it was only 2 legs that she lost. And, you know, so that's what you're dealing with. But what you got to stick to, one, you got to know the medicine yourself at a very deep level. On that specific little bitty area of medicine, you need to know it as well as the doctors. Because one of the problems that doctors have are hubris. And they're used to going into the OR or the ER or wherever they are and writing some orders and walking out and say, you know, like Steve Austin says, is that way because I said it is. And that's what they're used to doing. But when they get faced with articles and literature, they have a real problem. And half of them won't prepare by reading all the depositions in the case. So you can score some little points. But now, how do you dumb all this down and make it really simple and digestible for the jury? Because the number one thing you face is there really are no rules that you can find in medicine. Your expert will use the language that these are the rules, these are the stop signs, these are the warning flags. This is what you always have to do. But every paper you get will say clinician judgment because they've been washed by legal counsel. You know, this does not set the standard of care. This is a consensus opinion, but it doesn't set the standard of care. So you have to frame it up as clearly as you can. And what I do in these cases is I tell the jury in opening, you know, we've worked hard to limit the amount of time that you're going to be here. We're not going to call 4 witnesses when 1 will do. But I'm going to take a little longer in opening than I normally would so that you understand the context of the evidence. And in my opening, I lay out the whole case, including the defenses that I know is coming. I never get out over my skis. I never say anything that I don't have a piece of paper 100% prove what I've just told them. But I lay it out because of the ideal of primacy and clarity. They hear you first, and they understand the case the way you've laid it out. So our case was overdosed, and that killed her left foot, and she was overlooked, appealing to themes that people in life have to deal with. Nobody wants to be overlooked. Nobody wants to be ignored. Nobody wants to be mistreated. A lot of times I'll say in trial, adding insult to injury is not just a cliche. It's a rule that we should live by. You can injure somebody, but the answer is, or the next thing you do is important. Do you insult them and lie to them and cover up, or do you get out and apologize? And so it's kind of the way we set the case up, and we had to divide the liability, we felt like, or the damages between her left foot, which was on critical care, and the remainder of her left leg and her right leg on the vascular surgeon. Now, we had sued the nurses because there was a clear error. They violated the order and they didn't follow up. So one of the lessons I've learned, one of the things I'd share with you in medical malpractice cases is be sure you've sued everybody that has responsibility. And when you get into the case, they cannot help themselves but to circle the wagons. They won't blame one another. And so, and they're not going to settle your case early. So that's a pipe dream if you think that's going to happen. That rarely, I've had it happen one time. Find out the insurance, send the demand letter, let them make their decision, and then you've got bad faith and move on. And don't get emotionally invested in the cancer of settlement thinking this case is going to settle. When you get into these cases, you're going to try the case about 90% of the time, in my experience. You're going to try the case. So don't think you can just take a swing or, file a case and you don't have to do anything. So one of the lessons I'd tell you is lock all the experts and all the defendants into they have no blame on the co-defendants. Because some of them will get weak-kneed right before trial and settle with you, and you'll have an empty chair. But then they're sitting there, they cannot blame the former defendant. They'll want them on the verdict form and all that stuff, but you can really drive that home. And if you keep your experts segregated, you don't call your experts that were criticizing the nurses if that's who you've settled with. And that's what we did in this case. We settled with a hospital. So we had to pivot and we had to focus on the doctors. And I said two doctors, or when you boil it down, doctors have two things that they have to do at the job. Number one is write orders, figure out what's wrong and come up with a treatment plan. That's what they got to do. But they don't just get to write orders and throw them out and walk out and go fishing or go take their daddy to the federal penitentiary. They have to check back and see if the treatment they've come up with is working. And so what had happened was the nurses had messed up the order. They hadn't properly checked on her, but the doc had come back within 6 hours and then another 12 hours and another 12 hours. Another 6 hours. So he had multiple opportunities to see if what he had ordered and what was being done was helping this lady who's in the critical care unit of Phoebe Putney. Critical care is where you're supposed to be checked on every 15 minutes. It's the highest level of care. You're paying the maximum dollars to be in the CCU. You ought to be watched closer than anybody in the hospital. And so that was our case. Write orders and follow up, and they didn't follow up. Now, there was a consensus document out there on surviving sepsis. That's what she had, was septic shock. And essentially, it said give the lowest dose needed to achieve the blood pressure you needed for the shortest amount of time. And when you don't do that, the number one risk of not doing that is this. So that's the way I set up opening for the jury. These drugs are super dangerous. If you don't watch them very closely, you'll cut off the blood flow to somebody's leg and you're on a clock. 6 hours. 6 hours. That's your window. If you don't do that, this is what happens. So this is the way the jury sees the medicine. So they have become experts in opening statement on what's going on, what should go on. And now it's for the defense to answer all the questions. And these cases, to some extent, are like taking a slip and fall deposition. I'm sure all of y'all have done that. Every little admission matters in a slip and fall. Where were you looking? What shoes were you wearing? Did you see the rug? Could you see it? Why didn't you see the water in the floor or whatever? And a lot of times those cases, you're in or out on summary judgment based on one little admission, one slip of the tongue. And medical cases are that way too, because these doctors are bright and they're well prepared when you go to take their deposition. So you have to listen to their answers, and decide, am I going to follow up and try to, continue down this road, or do I have enough to live on? And I'm thinking about what I'm going to do at trial. They're not going to get out on summary judgment probably in a medical malpractice case, but I'm trying to think about what we're going to do at trial and what can I live with. So one little admission in our case was from the ICU doctor that he checked her legs after they had turned off the vasopressin, and she could still wiggle her toes on her right foot. Well, the vascular guy's testimony was no, both legs were totally 110% dead when I saw her on Sunday. That was his defense. Well, of course, you can't wiggle your toes and your feet if you're 100% dead, your legs are. So we had to live on that. So I get in cross, and the doctor that I have on cross, he's a really bright guy, and Dave Nelson was defending him. And it was kind of funny at trial. Dave would ask him a question, and he would just run on way beyond what the practiced answer was. And Dave was getting so frustrated, and he says, "You're like my dad, Dr. Ungarino, I know you know a lot, but please just answer what I'm asking you." He's having to get on to his own doctor. So I get up there on cross, and he's made some huge admissions that were problems for him. And I jump him about the wiggling her toes several hours after Dr. Morgan's left. He says, "Oh, that was on page 177 of my deposition." I said, "Wow, you've been thinking about that one a lot, ain't you? Because you know where I'm going." Let's talk about page 177. And his argument was it was a mistake, a slip of the tongue. Matt Cook tricked him, all that stuff. I was like, "I tricked you?" I was like, "Doctor, you're a critical care medicine. You're a pulmonologist. How did I trick you? Yeah, I'm from Rayburn County. I can't trick you." And I said, "But here's the deal. You had an opportunity to review it. You didn't make any changes on the errata. We've been pending 3 years since your deposition. You didn't think Jessica Powell had deserved at least that you would go ahead and tell her that? Why didn't you supplement your discovery responses? You want to treat her fairly, don't you? She at least deserves to be treated fairly. Why'd you sit on this revelation for 3.5 years? You just like coming to trial? What are they going to say to that? I don't know. That's my lawyer. Okay. We'll deal with that. So we get through the case, and we appeal essentially to these feelings that nobody wants. I remember reading a story about the man who died, the loneliest person on the face of the earth, died in a prison that there were no other prisoners. And that's where Jessica was, unconscious, nobody to watch for her. All of her fate was in the doctors and the nurses' hands. And people had better things to do and weren't paying attention. So I told you about the defenses. They saved her life. My response in closing was, when they saved her life? When they shipped her to Emory. Because if they hadn't got her out of there when they did, there'd be nothing left of her. No rules apply and no standards apply. And I said the only rules that apply and the only people that set the standards are the jury. People who are human lie detectors. That's what I set up in voir dire. Essentially you're a human lie detector. How many of you judge credibility here? I say, anybody work as a teacher where you got 2 little kids running up and you got to pick who's telling the right story? Anybody work in HR? I set all that up so that they understand somebody's a liar in the courtroom. You know, I don't call people liars typically, but that's the suggestion, because that's what it's all about. It's a truth-telling contest. And that's why my credibility is so important. And you demonstrate credibility by A, never telling a lie. If you make a mistake, you admit it. You demonstrate credibility by knowing the record, knowing the facts, knowing the evidence better than anybody else, because they're going to pick a side, and all these cases are close. They're going to pick somebody on one side or the other to believe at the end of the day. And that's the way it always shapes up. They blamed her for not taking her medicine consistently. Jessica would take it about every other day and had done it for 2 years without incident. So that's the way it works. And what was lost? All the things that make us Americans, all the things that make us human. It's very simple. Her future, her freedom, her independence, her security. She had got, you don't think about it. There's no self-serve gas stations anywhere. You're in a wheelchair, no legs. She has to pull up. She carries her wheelchair in her front floorboard, pulls it out across her dress. Her car radios broke all to pieces, sets it out, pulls it up, gets the cushion, snaps another wheel on it, gets her sliding board, moves over into the wheelchair, has to wheel around. Half the pumps are too high for her to get her card in. Now she's got to go in, get gas, little things like that. She had a flat tire, had to pull off on the side of the road. You can't get a wheelchair out on a grassy median. The one self-serve place in Camilla had a guy down there, and he gave her the creeps. He started saying some things that made her uncomfortable. So that was out. Try to get up a ramp at your house. She didn't have an electric wheelchair because she didn't want one, because that gives up her fitness. She's got to wait till she's older to get an electric wheelchair. Well, you can't hold a bag of groceries in one hand and roll a wheelchair because you'll turn in a circle. You can't hold an umbrella in your hand. She lives in Camilla, Georgia, which is like the size of my pinky. So you go to Walmart and you run into a guy you ain't seen since high school. Hey, Jessica. This is awkward. She's sitting in a wheelchair. How do you have that conversation? What happened to you? She didn't want to become an object of public interest in Camilla. But that's what they put her through. And I told the jury after we watched the day in the life video, which was really moving, I would recommend those to you. Get them early in your case. I've had clients die. Don't dilly-dally. Get your day in the life video done. And the jury leaned forward watching that video. And Jessica, although she'd been Personality Plus in college and after school, had really become sort of a hermit. She was the oldest of 3 girls. Her fiance dumped her after this incident. Both of her younger sisters got married before she did. Well, she's not married now. Both of the younger sisters had kids. Jessica don't have kids. Those things shouldn't really happen. And the cruelty of the defense, when you have no defense, is to put you on trial and let everybody see all the personal things that you've been trying to cover up for a long time. Getting out of the bed, getting yourself onto the toilet, having to talk about personal things. And then they want to get up there and ask about sex, date, stupid stuff. So the jury will take care of them in that. So really, what did we have in that case? We had a great client, tried to make it simple. I'll tell you, we had hundreds and hundreds of thousands of dollars, $900,000 in expenses in that case. And that's why I say don't take these cases unless you're ready to go to trial, and don't take them if you don't have a good case and you don't know what you're doing, because you can make some real mistakes and it can be hurtful. Tell you a little quick story about the case. We get down there in September to try it, September of 24. and have a huge courtroom. Audio's terrible. Can't really talk to the jurors. Some of them in the back can't hear me that well, that sort of thing. And of course, the doctors bring all these people up there with them that I've never seen in the case. They know more about it than, or know less about it than the jurors who have just come in. And they've got this one guy up there hanging around, and it's a 2-day voir dire. And my clients say, hey, we saw that guy talking to one of the jurors, some of the jurors outside during the break today. All right, we'll have to take it up. So I asked Greg Taylor. I said, hey, man, you know, my client saw your guy talking to some of the jurors outside. Who is that guy? Oh, he works for Dr. Morgan. Dr. Morgan, he's up here because, you know, in case the office calls, he can run something back and forth and handle that for Dr. Morgan. So, all right, well, we got to take it up with the judge. So get him up there and ask him, did you talk to some of the jurors yesterday? Yeah. What'd you talk about? Oh, well, I talked to Coach Smith. What'd you talk to him about? Well, he's my old high school basketball coach, and he's got a good player over there this year, and I was asking about that, really. Okay, and the judge did not like us for whatever reason. She was very loyal to her local folks. Well, gentlemen, y'all ain't from around here. Y'all don't know Coach Smith. He's a local celebrity. He played pro ball, and so a lot of people know him, like talk to him. Anything else? We need to get the jury back in there and finish this voir dire. Well, Judge, we sure would like to talk to Coach Smith. All right. Bring him in. So we say, Coach Smith, understand you talked to somebody up here associated with the party yesterday. I didn't do much talking. They talked to me. Okay. Well, what'd they say to you? Well, this guy here said that he was his good friend, Dr. Morgan. He's up here to support him because your client sued the hospital and got millions and millions of dollars from the hospital and is still suing Dr. Morgan. Okay, thank you. I'm like, holy shit, somebody's going to jail now. And they're going to remember me in Albany. And so she says, bring that gentleman back in here. So you work for Dr. Morgan? No, I don't. Greg Talley says, Judge, I'm sorry. I thought he worked for Dr. Morgan. He's just a friend, Thank you. And let me ask him questions, she says. So she said, did you talk to Coach Smith? Did you tell him anything about her settling with the hospital? Because all that was subject to a motion in limine. And no, Judge, I didn't. Just talk about basketball. Okay. I'm like, well, this is sweet. And so she lets him out, and she's like, all right, well, I guess we'll put Coach Smith off. I said, Judge, we have a mistrial. He's out there talking to people and bunching the voir dire panel. We can't do that. And she was not going to grant it until the defense agreed to it for whatever reason. And so she grants the mistrial. I said, now, Judge, we'd like everybody's cell phones and emails, preserved, because we may have to have a motion inquiry about this. What are you suggesting, Mr. Cook? I said, well, nothing, just that everybody needs to save everything until we can figure out how this could happen. Nobody should know about that confidential settlement or whatever. I'm not going to do that, Mr. Cook. No, we're not going to do that. So we had to pack up $50,000-$60,000 sent, cancel all the hotel rooms, send the experts back home, come back and try it in April. And that's the way things can work. I've never seen anything like that in 27 years doing it. I'm getting short on time. I'll run through a couple of these just to try to hit the high points. Had a truck wreck case we tried over here in DeKalb County. Been through 3 lawyers, nobody could figure it out. Tractor trailer and SUV had gotten tangled up on I-85 at 4 a.m. in the morning, spun our folks out. Our lady gets out of the car, gets hit and killed. And both the drivers said I was not changing lanes at all. So the specialized reconstruction team out of Gwinnett couldn't figure it out. So I get all the pictures, go through it, and you can see, I don't know if you can see how well, but during the collision, this tractor trailer, the back end, the tires had actually ridden up on the back of the lift gate, pushed it down in the road and spun it out. So I said, well, I know how the two were at one point positioned. and we had this gouge mark here in the road in the center of the lane. And this SUV had a ball hitch on it, and there's a tire mark. So I said, well, if we can set a replica SUV on top of that and set the tractor trailer on it, I'll know who was in what lane and all that when they got tangled up. So that worked out. We did a drawing and come up with that. And that was our case. So we try it in the cab. And the lawyer in opening, this was covered on court TV. He gets up and he has this fantastic theory that he hadn't vetted with his accident recon. Demonstrates that the SUV had gone down the road on the right rear tire, pirouetting. And so in his opening, he wants to demonstrate this. And that was his argument. And so, of course, we all laughed about that. And I couldn't help. I was like, I'm going to use this. I'm going to figure this out. Well, we get to closing. It's been pretty hot and heavy. And I said to the jury, I said, you know what? I've been trying to think long and hard. What could I say nice about Mr. Bardak? And I said, I finally have come up with it. And I said, it's that he would have made a better ballet dancer than an accident recon, you know, and the jury loved that. But you know, what I try to do in these cases is just, as everybody said, be credible. Don't over try your case. Like Jimmy said, I had a 2-mile-per-hour wreck, literally downloaded 2 mile per hour, no visible damage, herniated disc in Forsyth County. That's not the case you want to try. They got 4 experts on the other side, and I didn't have any. And we just went in there and we tried it. I had gotten 3.7 million for a 4-mile-per-hour wreck. So I thought, well, 2 miles, I'll get 1.3, you know, it seems to make sense, but we got $750,000. But what they did by giving me 4 experts was just give me somebody to cross-exam, you know? And I told the jury from the beginning, this ain't a federal case, literally and figuratively. We're in state court and we're not going to make it out to be more than it is, you know? And the voir dire is key in that. So picking up on what Jimmy said about asking specific things. How many of you have had a car wreck? How many of you got a pop disc, torn, herniated, slip disc, whatever words you want to use? Somebody's got one or they've got somebody. Lifelong problems? Oh yeah, for sure. You familiar with the epidural steroid injections, the RFAs? Yeah, take a needle like this, stick it down in your back right there. That do any good, you know? Anybody had to go to surgery? Anybody had to make a claim? And then I say, oh, you settled it with the adjuster. They'll say that. Anybody have to go all the way to a jury trial to get your claim adjusted like we're doing here, you know? And so, and then the way I insulate our doctors in those cases and take on biomedical experts that say you can't get a herniated disc at 2 miles per hour is I say, how many of you defer to your treating doctor on why you got some kind of disease or you got some kind of injury? How many of you trust your treating physician? And once they say that, you've got them locked in. As long as you haven't used some terrible, you know, doctor that you shouldn't be using, you got a credible doctor who, you know, has no connection to you and just treated the patient. Tried a case up in Hall County, got 7.6 in a dog attack. It was a pit bull, shocker, that attacked our client. And Ronnie Holtze was in this case with me. And the first instinct was, let's talk about how bad pit bulls are. Let's talk about all the stats. You know, they kill more people than any other breed of dog and all that. But that's a political football. And I said, no, can't do that. We decided no. The issue is personal responsibility because that's what they like to hear in Hall County, you know, personal responsibility. And people like to think they're smarter than everybody else, especially white males. They will rationalize the hell out of how they would never get rear-ended by anybody because they would leave earlier or they would be watching in their mirror, et cetera, et cetera. And so the way we handled voir dire, you know, is how many of you have pit bulls? And sure enough, 2 or 3 of them either had them or had them. And how many of you think some of them would be dangerous and some are little teddy? Yeah, I agree with that. And how many of you believe the duty is on the owner to figure out what you've got? You have a killer or a teddy bear? And they all agree with that. So you focus on the human, not the dog, you know? And this personal responsibility and irrationality is really what drives these cases, because that's what lawsuits are all about. If we're going to impose liability, somebody failed to do what we expect everybody that we live with in society to do. That's all it is, right? In a negligence case, it's just act reasonably. And so we tried that case. One point I'll share with you about that, I sort of did so we sued Mama. It was the 40-year-old son's pit bull that he left with Mama. He moved into the basement and brought his baggage with him, she said, including her dog. And he dumped it on Mama. Again, a personal responsibility issue. So how do I deal with a 73-year-old lady who's sort of been dumped on by her son? Well, I just looked at the facts. You own the house, ma'am, yes. You have a right to say what comes in your house, yeah. You have a duty if somebody's doing something dangerous in your house or keeping dangerous things in your basement. Don't you have a duty to the rest of the world, even though you love your son, to let everybody else know or take steps to make sure nobody else gets hurt? It's kind of how these, like this recent criminal trial with the daddy that gave his son the machine gun or the gun that killed people. So people get that. They can't dodge that. The way I did the damages in that case is Our Lady, I'll wrap up with this. Our Lady was attacked for about a minute and a half, and she fought for her life. The dog knocked her down, grabbed her arm, held on and shook it so long until a chunk of meat ripped out. Then he grabs her by the throat. She gets this arm up there. He's shaking that, pulls out a chunk of meat there, gets her leg, rips out of her Achilles tendon and her leg. And she finally is able to shove herself on her butt back through the threshold of the door into the foyer and kicks the door shut with her other foot. So the dog's outside. Mama is out there squealing and yelling at the dog and trying to get it off of her and can't handle it. And so then there's about a 6-minute delay before EMS gets there. She's got an arterial injury. She's spurting blood. She thinks she's going to bleed to death. She finally gets to the ER. They hold pressure, get the blood stopped, take her into trauma surgery. Don't know if she'll walk again. Don't know what she's going to look like. She looks like a pincushion, you know, all scarred up, ripped up, comes home in a wheelchair. Husband has to take her to the bathroom, take care of all of her private stuff, change her wound vacs, 8 surgeries later, you know, is she going to be able to walk? She's an athlete, et cetera, et cetera. And so when damages came along, I wanted to talk about them rather than doing a per diem or in a, you know, some of these ways you hear about. And I've done per diem arguments many times. So I sort of segmented it. And I said, I don't want you to imagine Stacy as she is now, healed up and knowing she's going to live. I want you to imagine her the first minute and a half that she's fighting for her life. Because Stacy don't know the outcome when the dog's got her down. She don't know that she's going to be in a courtroom a year and a half later, able to walk and do some things that she used to. All she knows is she may die right there in the threshold. So you got to give an amount of money for that. Now, when she got that door kicked closed, she had to worry about is she going to bleed to death? Is she ever going to make it through this little 6 or 7 minutes till the EMS gets there? So you got to give an award of money for that. And then you got to give an award of money up until the time she comes out of surgery for what's going to be left of me? What's my husband going to think of me? Are the kids that I teach going to make fun of me? You know, I like to wear skirts. Can I ever do that again? You know, all the things that go through your mind, you know, and you put these people in the shoes there if you can and make it real. I'll wrap it up. I'm not going to go into, I'll tell you this last thing. We had a FTCA case against the U.S. government for a guy they killed over here at the VA. And we ended up catching the U.S. Attorney's Office hiding evidence and an investigation, and we got them sanctioned. And I told the folks at my office, I said, boys, we're going to be getting calls at the front desk from Russia and China. I said, because we just done something Xi Jinping and Vladimir Putin's been trying to do for 40 years. Let's get the United States sanctioned. And they ain't been able to do it. So anyway, well, thank y'all.
Thank you, Mr. Drew Calling. You should have been a comedian. I mean,
Wittiest in high school.
I believe it. Well, that was very informative, interesting, and just goes to show that if you want to lose a lot of money fast, dabble in med mal. It's tough business, and like you said, you got to take those cases believing that you're going to go to trial, and committed to that. And the experts, there's nothing more important than having good quality experts to make sure you have a case, and ones that you can trust are going to spend the time on files. Thanks, Matt. We have one final speaker, and this is the one that I think I might learn the most from, because I am terrible at modern computer stuff. In 95, when I went to law school, email and the internet was in its infancy. I got my first email address when I went to work at a defense firm. Windows was not even out yet. We had blue screens with just white text, and Windows came out, I think, that year. At least that's the first time I'd ever seen it. And so the internet was in its infancy. We were still researching in books, Westlaw, and it was another company at the time, LexisNexis, yeah. They were the new online research tool, and even professors were, skeptical of those. But I did learn to master the internet and email. Good Lord, I feel like an email farmer some days. You cut them down and they grow right back up. But what I have not taken the time to learn is this whole new field of AI. And from what I hear, it is revolutionary, and it is a game changer in many areas of our world, and especially in the practice of law. Matt Wetherington is a tremendous lawyer, a brilliant person. I have listened to him speak before. I've watched all of the trials, or I've seen the verdicts that he's had in his trials, but he is on the forefront of some of this AI stuff, and I am really hoping that he can share some of his knowledge with us to help us integrate AI in our practice. Matt, come on up.
Just a show of hands, just so I can kind of orient what we're going to do today. How many of you have used ChatGPT or Gemini, in your practice? Like you've logged in, you know how to get in there. Am I on here? Okay.
Audio, people, I'm gonna turn it down a bit.
How many of you have not used ChatGPT, Gemini at all? We got one. Okay. Hang on to your butts. All right. So what we're going to do today is we're going to do the Deli and Pony show. We're going to do a little bit of kind of different ways to do things. So I'll show you how you can do it kind of at the beginner level. I'll show you, if you've never used ChatGPT, I'll show you how you can do it at the intermediate level. And I'll show you some of the more advanced things you do. And what I hope that you learn as we move forward here is that the more advanced stuff is such an easier path. So like the overwhelming thing that I've learned from AI is that it's a really, really good way to take 3 times as long to do the same task. But once you're done doing it the one time, though, which takes 3 times as long, the next several times takes basically no time. And that's the force multiplier that AI offers for you. Okay. And what I'm going to try and focus on here is this trial application. And so preparing for this, the core concept that everyone I think will agree with is that it just takes so much work to get to trial. Like just to get to trial, it's so much work. And then trying the case is so much work. And you spend so much time, energy, and effort. You're going through the record. You're going through the depositions, making sure your evidence is right. You're cutting up depositions. You're fighting about depositions. Guess what? You didn't cut it right. Now you're doing it again instead of working on your opening. All this stuff that makes trial so stressful. And a lot of that also goes into presentations. It takes a lot of work to do a presentation and do all of that, or at least most of them. So I tried to find the easy way out to do this presentation. So what did I do? I went and asked ChatGPT to go and find last year's seminar. And so there's a little tool. So if you're familiar with ChatGPT and Gemini, they have knowledge cutoffs where they say, I don't know anything after August 1st, 2023. Who's the president? No one knows. What's going on in Iran? Who knows? But now they have what's called tools. Tools are what allow these chat, I'm going to call them, AI agents, to be able to go on the internet and get more information. So here you can go, if you click the little plus button on ChatGPT, you can say, hey, go search the web, get some more up-to-date information. So I check the little box and I say, go find either 2023 or 2024, the 2025 versions of this seminar. And guess what? Lloyd Bell posted the video. And so it was, and also Jeb Butler and Matt Kahn, they posted the video of them talking. And not only did they post their video, they posted everyone's video. And ChatGPT was able to go through and find where they had linked that. So what did I end up with? I ended up with a YouTube link. Awesome. We're halfway there. So I went and found the YouTube video for last year's seminar. I then told ChatGPT, I then told Gemini, can you please go and find me the transcript for this? Because I'm not watching it. Like I'm here to lead, not to read. I want you to go find the transcript. So we told it, hey, go through, find the video. And so what it did, let's see if it'll play for us. I guess not. So what it did though is it went through and found the transcript. It wasn't embedded in YouTube video. So it went to a website, found the website, extracted the subtitles that YouTube had generated for the video, turned it into a text file. Great. So then we take that over to Gemini. Why did we move from ChatGPT to Gemini? Because Gemini has a much larger context length. Context length is your enemy. Now, when we talk about using these different tools, that's the first thing that needs to be in your mind when you're using it for legal work, for your trial work, is the context window. Let me put this in perspective for you. So ChatGPT, using the basic models, we're talking about like Harry Potter, for example. It can fit like the first book, maybe book and a half into its context window before it's like, I don't know what we're talking about anymore. Whereas Gemini can fit all 7 books plus all of the movie scripts too into its context window and tell you all about it. So you want to make sure that you're using the right tool for the right task. If you're going to throw 10 depositions at ChatGPT, you're going to have a really, really bad time. But if you do it with Gemini, there's a pretty good chance that you're going to get the result that you want. So we can talk about some techniques to do that, but that's maybe for another day. But a typical deposition transcript runs about 250 pages. And so ChatGPT can hold about 1.5. Compare that to Gemini. Gemini, it can hold somewhere around 8 depositions on average. And another example, Affordable Care Act. ChatGPT can only fit the index, whereas Gemini can fit the entire Affordable Care Act into it. So big difference in context windows. So think about how big of a text you're wanting to work with, and then think about, hey, when it starts doing weird stuff, 9 times out of 10, it's because you've exhausted your context window and it's just lost the plot. That doesn't mean the AI is bad. It just means that it has no idea what you're talking about anymore, and you're going to need to reorient it, or even better, summarize what you're doing and then start in a new chat. So like if you're wanting to put in 1 deposition, give you an example. You want to put in 8 depositions in ChatGPT. You take your first deposition, put it in ChatGPT. You say, summarize this focusing on X, Y, Z. Great. Now you start a new chat. Next deposition, summarize this, focus on X, Y, Z. And you just keep copying and pasting your summaries until eventually you've got your 8 summaries together. And then you can continue to work on it that way. But it's a whole lot easier just throw them all into Gemini and be like, summarize them all. Make me a nice chart, find discrepancies, do whatever you want to do. So what Gemini then said is like, wait a minute, this is a really long transcript. You've got 8 presentations, but okay, I'll go through and I'll tell you everything that we learned. So what did I do? So what did I do next? I then moved over to Claude. I took all the lessons that we learned from last year's presentations. I took them to Claude. And I said, Claude, go look at my presentations that I've done and then take all the lessons learned from the last one and let's just plagiarize it. Like, let's just take all the very best ideas, let's steal them all, and then let's see if we can find ways to make AI apply to those existing ideas. Claude says, No problem. So here we go. Here is Claude's presentation. So Claude puts together the presentation, and I thought, cool, easy peasy. But it ended up taking me like 3 to 4 times as long to finish this because, like, boy, there are a lot of junk in there. But it was a good starting point, and there were at least 5 to 10 things that it had that I'd never thought of that I was like, oh, that's really good. I'm going to include that in the presentation. And so we'll go through here. And the biggest thing that I hope that you take from this is that AI is not a shortcut. Like, all it does is make you able to do more. So like, who's going to use AI effectively at trial? Good trial lawyers. You're going to be doing the exact same things. You're just going to use AI to do it. It doesn't suddenly make a bad trial lawyer a good trial lawyer. You can't just say, AI, help me get big verdict. It's doing the exact same things that you've been doing before. So it makes the prepared lawyer look so much better, though. And because, especially after SB 68, made this graphic, by the way, awesome. Like, Claude really understands me and understands my humor. I appreciate that. But the point is that every little advantage is going to matter. And so when you're dealing with like great trial lawyers and great trials, you got to have every tool that you got. So what does a good trial lawyer do? At least according to last year's speakers, and I agree with all these actually, is that you got to know the record cold. You can use AI to indexes, inventories of evidence to help you learn the record, know what you're going to pull out, and be able to, like, at a finger's notice, be like, hey, that exhibit over there talks about this. This deposition covers that topic. You can create topic maps for your depositions. It's about surfacing documents that maybe you've not thought about. Because I don't know if many of you have done this to me. You get 20,000 documents, and because I just hate myself, I will go and look through all 20,000 documents. And then I'll go and continue working through my case. And then some issue will come up and I'll go, geez, I know there was something about this in those documents. Guess what? I took terrible notes. I didn't know it was important at the time. I just know that it's over there in the haystack. And then I'm going to have to go do it again. And then 6 months later, I got to do it again because I just suck. And I just can't keep good enough notes. AI really helps with that, where you can say like, hey, here's the topic maps of the deposition. I want to make sure that I know what we're talking about in each of these depositions. So I know at least which stack of hay I should start with when I start going back through the documents. It also helps with figuring out your framing of the case. Like every case, like if it takes you 5 minutes to explain it, you are going to lose. Like, it's just the truth of the world. It's the simpler story wins 99% of the time, short of that one sentence being a huge lie, which does happen. But it can help you think about how to simplify your case, how to create personas, to be like, hey, how do I lose my case now so I don't lose it at trial? Like, go through this deposition, go through the questions that I asked. What did I miss? What was it that they asked that I think is wonderful that a juror is going to be confused about? It does a very good job of doing that kind of stuff. And so we'll talk about kind of how to do that. So the first is like finding like the key fact in like that haystack. So you can use ChatGPT, you can use these tools to go through and think of it like as like an associate. So like before we go through all this stuff. So now you can scrape all the depositions into an index. And so the first thing that you should do, if you're going to take away, I'm going to give you your like takeaways as we go along. Takeaway number 1 is when you order your deposition transcripts, ask for the TXT file. Like I don't need PDFs anymore. I don't need E-trans. I want the TXT file. That is just the literal text of the deposition and nothing else. I don't want to have my deposition court reporter's name plastered on every single page to confuse the AI. I don't want to have some proprietary format. I just want raw text, because you can take that raw text and shove it into these AI tools, and you're not going to lose your context window on it trying to figure out how to read a PDF or how to convert an E-tran. You just get raw text, because if you try to extract the text from a PDF, like you copy and paste it, guess what happens? You get line breaks. And the line breaks confuse the AI, or even worse, you only end up with the compressed version where it goes bump, 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 and the AI goes, well, I'm going this way. And now you got a bunch of gibberish and you get bad outcomes. So get the text file so that you've got clean working text to work with, at least for your depositions.
Is the text file okay to file with the court?
No.
Is it coded?
I mean, it's just text. I mean, it's literally like it's like a nothing special document.
We're going to file that.
You're going to still get you're still going to get your official copy, And you're going to file, you probably will still file the PDF with the court, but we have started filing what I call fancy text files because I want to be able to search them cleanly and I want the court to be able to as well. And I've only had federal judges get mad about that, but state court judges seem to appreciate it. All right, so the other thing that it's useful for is going through online junk and mess. Like imagine you're looking for former employees, former witnesses, or just other things that go on. Like you go on Google and they got 500 reviews. You sort by lowest, try to find good stuff about the apartment complex, try to find good stuff about the trucking company. But I'm not going to read them all. So what you can use AI for is to find that 5-star review about the company meth party. Like, so you just can point it at these pages and say, like, I want you to go through every review on this page and identify things that either identify potential former employees, people who have similar incidents, or just general stuff that I would want to know about. And how do you do that? You just open up ChatGPT. You copy the hyperlink of the page that has the reviews. You put it into this thing and say, go look at this page and pull out whatever it is that you want it to pull out. And it's going to spit back at you and it's going to say 10 things you don't care about most of the time, but sometimes it's going to pull the good thing. And the good news is that most of the time there isn't anything there. So you've at least checked the box. I mean, like I've looked at it. There's nothing here for me to look at. It's very useful at doing that. Then for jury selection, this is awesome. All right. So you got a couple of different ways that you do jury selection. Like the ideal way is you call the clerk and you harass them until they give you the list of names that are going to be on the roster. Then you go and do research on the 800 people are going to be in the panel so that you're ready when the 60 people are pulled from that panel, and then you can do it. That's the typical way that we do things. That would be like, if I could do that in every case, I'd be happy. You got about a week to do all your research. It's a little bit more work, but at least you know it's done. But unfortunately, that's not how it works all of the time. In fact, not most of the time. Like increasingly, we're getting people who refuse to give us the rosters, refuse to give us anything even the night before. And then what happens is then you show up at trial and they go, hey, here's your panel. So what do? We create these little charts and we do it across there and we try to anticipate what's the numbering going to be in the courtroom, all that kind of stuff. That's all fine and good. But what you can do instead, just take a picture of the thing and hand it to Gemini and say, transcribe this document, turn it into a chart. Just literally just take this information and just put it into text format. Convert this picture into text so that I can use it to put it into a Google spreadsheet. I can put it into an Excel spreadsheet. I can email it to my team and say, look up these people, because if you've also, I know this situation, I've got the roster. My co-counsel wants the roster. We've got one roster and we're just fighting over this thing left and right. This way, you take a picture, scan it, email it to the whole trial team, let everyone decide what they're going to do. Do whatever research you want to do. Or even better, you can, and here's an example of a juror roster, which is pretty funny. I loaded this one into Gemini and immediately it goes, hey, I know what that is. And it's from the 1987 Superior Court case, State v. Foster, which was on racial profiling, which I thought was pretty cute that Gemini saw the picture that I had, looked at it and was like, I know where that came from. And I was like, cool story, but can you please transcribe it now? And so it did. So then it turns that into this nice table. So same thing applies when you're dealing with medical records, anything that is just like handwritten notes or stuff that's not easy for you to get scanned because you're either in a time crunch, which is most trial situations, or you've got the defense counsel's brief and you just want to deal with it. Boom, 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 takes pictures of each page, throw it at Gemini, have it transcribe it, email it out so you can then start doing your Westlaw research or whatever it is you need to do. You can then Control F and search through the document they just filed because it's been filed, but you haven't gotten the e-copy yet. They'll email it to you. They swear, here's your paper copy. That lets you quickly run through that. And this is something that you can do with all versions of all of the tools. Gemini is the best though, because it has a thing called vision. So vision is just its ability to identify the markers on a page. I keep grabbing. Well, there. Lets you, it'll identify the marks on the page. So it'll be here's the corner of the page. Here's where the text starts. Gemini holds the patent and created that system. So it's the best at identifying and reading documents right now. There are some other tools like Mistral, which is another step above that, Mistral. But that requires an API. It requires some coding. It's what we use, and we'll talk about how you can use that in the future. I have found Mistral to be incredible, particularly with medical records and handwriting. But if you're in a bind and you're just like have your phone available and you just need to get the text out and get something to your team, Gemini is your answer. It's lightning fast. It's second or third most accurate thing out there. All right, next is you can then take your list of jurors and then you can unleash ChatGPT, Gemini, whatever tool you want to use on property records, campaign finance, corporate filings, court history. They've been in their professional licenses, all this stuff. You can just say, hey, tell me all you can about Jane Doe who lives in Georgia, and go and look. You got to create a prompt that tells it what to do and look at public records that have for Secretary of State filings, for campaign contributions, for blog posts, for newspaper articles about this person, and let it go and do its thing to find things about them. Now, when you're doing this, you then come back and you say, hey, who are the jurors that are good for me? Who are the jurors that are bad? Or you can just say, hey, this is all I got. Don't do any research. Here's my panel. Just use the zip codes. Who are the people who live in the zip codes that might be the most problematic for me if we're just playing like pure stereotyping human beings? Like if that's all if you're in federal court, you got 15 minutes, do what you got to do. Like try and figure out as best you can. I presume like that's the worst, by the way. Like where the judge goes, I'm going to pick your questions. I'm going to pick your 8 questions out of your panel. I'm going to ask them for you, and then we're going to pick your jury. Like, thank you. Love that. Love that. All right. But ethical note here. Same rules apply to AI that apply to your own, background, juror research. Just use open records. Don't let the AI friend people, follow people, go on their social media accounts. Facebook, Instagram, Twitter, not Twitter, actually, Facebook and Instagram are generally inaccessible to the AI tools unless you've, created some little workarounds, which we can talk about. But you want to make sure that the AI tool is not going to do anything, particularly on your behalf with your accounts, to access jurors' profiles by friending them or following them. That is a huge no-no. You will get in trouble. You probably will not get to try your case. So don't do anything silly. Don't do any fun, don't do anything, don't play games, is kind of the way I look at it. But maybe some games. So trying a case in Texas, 6-week trial. And I do all of our juror research, and I've been the person who does the juror research for, every one of my cases forever. And they've got this hotshot juror consultant there with them. And everyone in that trial team was so nice, so wonderful on both sides, except for this one dude. And he spent a lot of his time just kind of like making fun of us for not having a consultant. And then as we started getting into jury selection, like I was like real time pulling up people's, information and stuff. And he started sitting behind me and like looking over my shoulder at what I was doing. And just to be silly, I did the research on him. And his little submissive page popped up. I did. And so I turned around and I said, is this you? And he goes, you did that. And I said, what do you think this ID verified means? And then he made a big stink about it, which was the wrong move, frankly. And then everyone in the courtroom knew exactly what I'd found online about him. And it was 4 years old, so it could have not been me. But I really enjoyed that jury selection. Like I was such a jerk. I really it was so much fun. And I was, he's married and he also had his son there. It was really weird. Very inappropriate behavior. Shouldn't have been mean. You can also use the AI for vetting your experts. You can use this for going through all of their little documents that everything they've written ever. Because if you're like me, you get a doctor, they've written 40 papers. I might read 5 of them that look relevant, but like, I'm not going to read all 40 because we're busy and we got other things to do. So like ChatGPT to the rescue, Gemini to the rescue, Claude to the rescue. Like they do a phenomenal job of going through those records. So as you're going through, think about your expert file and what you're pulling, be expansive. Like, don't worry about trying to find what's the best documents to look at. Get them all. Just go and like, hey, if they got 100 papers, don't be like, go find these 5. Get all 100. Put them in a folder. Convert them to text. Shove it into the AI and tell it to go through. Yes.
Assume we don't know how to even do the most basic instruction to AI. Tell us exactly how you would open up the program and tell it to go look for, let's just say that example, an expert's papers.
You got to do that work. Like you can like if you're talking about the most basic level, do the same thing you're already doing. Everyone in this room knows how to go and find expert papers. You either ask the expert to provide you copies of them, or you go on to Google Scholar, or you go onto JSTOR and you go and get those papers. Like nothing about that has to change. The only thing that would change is that once you have that paper, you either Control A on the PDF, copy all the text, and then go to ChatGPT or Gemini.com, paste in that text, and then ask it questions about it.
So if I had 20 PDFs, can I take all 20 and copy paste them into Gemini and say, tell me what this doctor's ever wrote about DVT prophylaxis?
Pop quiz. Can he do that in ChatGPT? No. Can he do that in Gemini? Yes. Good. You add the right.
Got the context.
That's exactly right.
But you copy, paste it, and then you ask it a question. Right?
Yes. Like at the most basic level, that's how you can do it.
Is there a way to download it, or does it have to be copied and paste?
There is ways to download it, but we're talking about the most basic example first. So like, yes.
I was going to ask, your comparison on the context windows, is that just comparing the free versions of each of those models, or does that change based on kind of what level you're?
It definitely changes based on what model that you're using. And it also changes based on the model's ability to make use of something called memories, tools, as well as like, it's called dreams for some of them. So like what can happen is that the AI, some of the more advanced AI models will go, oh, I'm running out of space. This looks like a deposition. I'm just going to put it over here. And then in its own little context window, and I'll keep going. And then it'll go look at the deposition when it needs to. But those are the more advanced use cases, and I'm gonna get into some of those examples. But at your most basic level, yes, you do nothing else different than imagine that you copied that and put it into an email and sent it to an associate and said, tell me every time they said DVT or whatever it is example you had. So you would just literally just send it to GPT instead and say, or Gemini instead and say, tell me every time this happened. Like that's your most basic level. It's that easy. Yes.
Have you used Lexis AI? Have you tried using that?
I got thoughts.
I'd like to hear them because I think I might have similar thoughts because
the thing is that all this stuff is junk at its like most base level. And the question is, can you find diamonds within the junk? And can you get really good at knowing where the diamonds lie within the junk? And so LexisNexis and Westlaw are going through that same exercise themselves. They're trying to do a good job of finding diamonds for you. But at the same time though, like there's a lot of junk. And so it's a product that's in development and it's going to get better over time. But right now, you know, as your experience probably is, it's kind of like, what are we doing here?
So you would use these other AI.
I would not use any of these tools for legal research at all, period.
Yeah, not.
Including Westlaw. And I'll tell you what you can do instead though. And so we can I got a slide a little bit later. It'll be better showing. You had a question.
Yeah, you were talking about putting let's say you have an opposing expert, they've written 50 articles and you want to know, or they've got 50 depositions out there. You want to know if they've ever testified to something that's different from what their opinion in this case, like we had in an earlier presentation. Can you get Claude or Gemini to do that for you?
Absolutely.
Here's all the depositions. Here's all the articles. Tell me when they've ever said something opposite to what they're saying today.
Absolutely. Like 100%.
How would you ask AI to do that?
Just like you just did. Like you copy in the text, you move it in. That's your like most basic, like if we're asking like, what's the level 1 approach? Copy it in there, ask it the question. Like that's your level 1. Like, how am I doing that? The level 2 is to do a little bit better prompting and a little bit better sanitation of your data. So it's kind of a garbage in, garbage out situation. What would be better is if you were to do some sort of, because again, this stuff takes, the output is amazing, but it takes longer to do it right. I like how trial work works. So the better practice is to take the deposition, have it go through it, and have it outline what are the major topics covered in this paper. What are the major topics covered in the paper, as well as what are the citations for those major topics. Then you want to go through and say, like, hey, what is it? What are the main theses of the paper? What is the evidence that it relies upon? Boom, done. Save that as a separate file. Great, I'm done. You do that for all 50 papers. Then you take all 50 papers and you say, give me the overlap of these papers of where they had covered the same topics and the same information. Turn them into subsets. So now we're like, okay, great. Now I got 10 folders where I started with 1. Then you go through each of those 10 folders that have intersecting topics so that you're not feeding it all 50 depositions. You're now feeding 50 papers. You're now feeding 7 papers on one cluster of information. Then you're saying, what is the information that might contradict in these 7 papers? Gets that. Then you do it for the next folder and the next folder. And then you take the summaries of the summaries of the summaries until eventually you're left with like, these are my 4 rifle shots. And it's no different than the manual work that you would do if you did it yourself. Like it's literally, you go through, you highlight the paper. This is what was important in this paper. This is what's important in that paper. Do they look the same when I get done? You're doing that same process. And it's the difference between like literally just copy and pasting in there. I would equate that to like skimming all of the papers, whereas going through the process, summarizing them, understanding what, having the AI understand what they're about before you get to the step of now tell me the contradictions, is where you're actually having the AI read it and process it and understand what the paper's about. It's like an iterative process every single time, and you're always fighting against that context window. So you're going to want to always be thinking about, if I've got 1 book's worth of text, how much space is that going to take up for me to do that? And when do I need to stop, summarize, and then start again? Does that kind of make sense? It's again, none of this stuff is like, it gets easier as you do it, but the process itself is hard. But it's not hard because of the technology. It's hard because it's hard. Like figuring out how an expert contradicts himself is not something that's like obvious. Otherwise, they wouldn't have a job. They wouldn't get to testify if everyone who read their couple of their papers could like kick them out on Daubert. Like it takes careful preparation. It takes understanding like what these papers are about. And you can get the AI to help you do that. It just takes time, energy, and effort. But what you can do is you can then take the depositions, take the papers, and tell the AI, once you've done that hard work, say, here's the theme of my case. Here are the major issues in my case. Which of these depositions are most helpful, harmful to it? What in these depositions talked about these key elements of my case? And then do the flip side and say, what is the defense going to say is the most important things about the case to counter what I'm saying or to develop their defenses? So give you an example of how I would do this. I would take the defendant's pretrial order and their answer. I would then take a deposition and I would say, cool, here's the pretrial order, here's their answer. What in this deposition are they going to think is the most important? And do I have an answer to it? So, and you would do that for every deposition, and you're going to get very actionable, very helpful stuff. And it doesn't take computer programming or knowing how to operate AI with like expertise. It's literally nothing more than just think the same way you would talk to an associate. Like, because how would you ask an associate to do these designations? Read the depositions, read the pretrial, read the complaint, then go and mark up things. It's the exact same process. You're just telling the AI to do some of it for you to speed the things along. And the best way to use this is to tell it why you're wrong. Like, because you probably read articles about something called glazing, which is where you tell the AI like, hey, I got an idea. I'm going to get dog poop out of people's yards, and I'm going to go to their door, and I'm going to try and sell it to them for $5. And the AI will go, I think you're the next Bill Gates. This is the best idea I've ever heard. Would you like a business plan for your pooper scooper seller idea? So AI is notorious for just thinking whatever you say is amazing. But if you ask it to and you orient it and say, how about we don't do that anymore? Instead, tell me why I'm like the dumbest person on earth and how I'm going to lose my case and how no jury will ever, ever, ever believe my client or my thing. And then it comes back to you and it'll hurt your feelings. And like I did it. So Like, I had it go through 5,000 of my emails to try and like identify like where like the bottlenecks are, what are the things that I do routinely, like what is the like the tone and like the I was really looking for like discovery dispute emails and stuff. And I was like, it came back and it gave its report. And I was like, all right, so like, what is your report? And it said three things. One, it said you work too much. It said that you send emails on holidays, you send emails on weekends, you send emails at 2 a.m. You've got 17 emails on the 4th of July. What are you doing? Okay, that's fair. And it's like, also, you email your wife instead of talking to her. There are many things that you should pick up the phone and tell her instead of emailing her. All right, that's fair. And then third, my 70% of my emails are one sentence or less, which was interesting. But it's able to then really figure out like what's going on here, where the problems lie. So you ask it, what's wrong with my case? It will find something. And if it can't find something, it'll make it up. And that's good too, because what is the opposition really good at doing? Making things up. So you can at least think about what are the most logical things that they're going to make up and throw at the wall. And you're going to have an argument about it. You're having an argument against it, hopefully. So you put up your little AI sparring partner and you give it your opening statement. And you say, how can I make this easier to understand? Where does it drag? You pull up your, you put up your direct examination. And here's a little tip. What will make the jury like this person the most? Because it's really good at that kind of stuff. And it'll be like, you have this one throwaway question about how they went to a soccer game. Make that half your direct. You do that, the juror's gonna like them. Everyone likes soccer. Everyone likes dogs. And it'll find those little human things that sometimes you put to the side, because what do we do as good trialers? We try to put the human first. We try to put the human being and let them tell their story and get out of the way. And I've found that the AI does a very good job of helping me get out of the way of my own cases and focus on the person that I'm representing and to be able to present their story to the jury. Because one of the things that the AI tells me quite frequently, and I don't like it, but it's true, is that I like to talk. And in particularly, I like to talk about me and the things that I'm interested in, the things that I think are important of the case. And I need to talk a little bit more about what's important to the client, at trial at least, and talk about like where the client's perspective is. What I think about some hazard at an apartment complex or some trucking wreck is kind of irrelevant. What really matters is, what did my client think about it? What did they feel? That's what the juror is there to do. And the AI does a really good job of like just knifing out the lawyer in the room. To be honest with you, I don't know that I would do another direct without having the AI run specifically to get me out of the room. Because apparently I can't stop myself from just sharing my own opinions about the case. The other thing that it does a very good job of is creating graphics, demonstratives. I always use the word demonstratives for your AI stuff. And pretty much you imagine it, it can make it. This is one that Claude made for the presentation on its own volition. I didn't even ask for it. It was like, you should throw in a graphic, and it made it. And so there's some issues with authentication, but you can have your experts say that it's accurate or not, because these are accurate, or they're not. And if they're not, then just tell the AI what's not accurate and have it remake it until your expert says, yes, that's what it looks like. Or yes, that's what I think will be helpful to the jury. And how do you do that? You just go into the magic AI box and you say, make me a picture of XYZ. Or even better, drop your MRI scan report into there and say, take out the identifying information first. But you say, I've got a herniation at disc L, whatever. I've got these problems. Drop that report into there and say, visualize this. And this is what it will pop out. And it is so much better than some other things you can get your hands on. Like, it's like really good at doing stuff like that.
Which AI visualizes that?
This one was Gemini, which is probably the top tier right now for image generation, but ChatGPT is quite good as well. And then there's some specialized tools that will also do it that you can find online. But they're all quite good at this kind of thing. Like, most of them are pretty bad at like lifelike images, but in terms of like diagrams, exemplars, like schematics, just fantastic. Even the worst ones are very good at doing this kind of imagery. And the thing to keep in mind is through all of this is that like, this is just connecting and doing what you've been doing before. Like there's nothing different. This isn't like a sea change in how you try cases. It's not, literally nothing has changed. All you're doing is doing a better job of connecting the data points that you were already connecting and looking at, and doing it with a little bit less work and sometimes a little bit more accurately. And as you're going through and thinking about like, how can I use AI in my practice? How can I do it? And the biggest multiplier that you're going to see is not in the summarization. It's not in the like the sparring partner, stuff like that. It's going to be in like identifying alternative sources for information. So let's say, for example, that you've got a trucking case and you want to go through and you want to find all of their out of violation instances, or you want to find every time that they got cited for texting, or you've got a hospital that has, multiple investigations, or a workplace that's got multiple OSHA investigations. And you want to go through every single one of them and look at them, but like, there's just so many. Like, imagine that you're trying to figure out every violation like Swift Transportation had. Like, I don't think you could do it. Like, I just don't think a human being can go through every single inspection report that these larger companies had. You can't go through every single sweep log, for a security report when they produce something this tall. But what you can do is you can have the AI go through it and look for specific things. And the magic things that you want to see on it, when you're on the internet and you see the words API, that means that you are no longer going to that website. It means that you're going to copy that URL and take it to ChatGPT or Claude because you're done browsing that site. API is an access protocol interface. So what does that mean? It means it's a tool that allows the AI or any kind of system to interface with that website without your involvement. So what does that mean? So give you an example here. All right. So let's say you want to look at property records for Fulton County. Fulton County has an API. No longer going to QPublic and messing around. I'm going to go into ChatGPT and I'm going to say, tell me about this address. And then I'm going to copy and paste the page that has the API instructions on it. And I'm going to say, and here's your API. So here's what I did. I literally just copied and pasted the API page of Fulton County. And I said, go look up the records for State Bar. Like, can you do that? And here's its answer. It says, of course I can. I can go to the Fulton County GIS and Board of Assessors. An API key is not required for this particular page. Some of them require keys, some of them don't. And I can do it. And I said, great, now do that for the State Bar. And just spits out, the parcel information, the owner, the address, all of that. So let's say, for example, that you, for whatever reason, property records matter in your case, and you go to the county, you just type in county property records API or Georgia. Georgia, what is it? It's the, on this page, GIS, yeah, Georgia GIS API. And you go in there and say, hey, where's your API instructions? Go to that page, go to Gemini and say, look up all the property records for these entities, these addresses, this street, whatever it is that you want to do, point it to the API, it'll go and browse it. Now, if you do the same thing and say, hey, go look up the State Bar's, address information without giving it that API information, maybe it finds the API on its own, maybe it doesn't. But more often than not, you're not going to get an actual meaningful response back from it. But if you point it to that page that says API, it'll know how to access it. And if it needs a key, all you got to do is sign up and say, give me an API key. It'll generate a key for you. You take your key, you take it to ChatGPT or Gemini or Claude, whatever it is. And these API keys are everywhere. Like, it's amazing. Like, it's like my favorite thing right now. Like, it's just like collect all these APIs and services. And because I just keep a little Word document of like all the APIs. And so, like Court Listener has an API. You can do, FEC data, complaints, SaferSys has one, NHTSA has one, like all these kind of like whatever your practice area is, just think about the government website that you interact with the most. Go to Google, type in that website, and then they add the word API. And then see if they've got something available. And if so, that means that from now on, you can just go to these AI tools and say, go look up X transportation company, or go look up the property records or the crime grid or whatever it is for this location. And it'll pragmatically do it for you and put it into a nice format. And more importantly, it'll filter it for you. So you could say, hey, go look up all the property records and only give me the ones that come back that are owned by this collection of people, or that have been sold in the last X days. Like, use whatever your imagination is, but it lets you do that at like lightning speed. So that then brings us to Claude. So with Claude, what you can do is go in and start collecting your documents. So instead of living inside of ChatGPT's website, you can start living on your own computer and your own file system. We'll talk about some of the ethical issues that are around this in a second, but just top level, what Claude has and ChatGPT has this as well. ChatGPT has something called Codex, and Claude has something called Claude Code. You can download Claude Code to your personal computer and then point it at a folder on your computer and say, do this or do that. Go through these. So when you talk about those 20 depositions, what do I actually do? I put all the depositions in a folder. I tell Claude Code, go through each and every one of these depositions one by one. I don't want you looking at all 20 at once. Go through them one by one, create the summaries, do that. I create what I call like a rule book of like, here's how I want you to handle depositions. And so you save that text file in the folder with the depositions, and then I just tell Claude, go read this document and then go read the depositions. They read the playbook, whatever it is. So you're starting to automate without actually programming or anything, because no programming at all here. This is nothing more than just telling your associate what to do. The email you would send to your associate, you save as a text file in that folder, and then you download Claude Code and tell Claude Code, go look in this folder. The instructions for what to do are sitting right there, and it'll go through and do it. So this one, all right, it's hard to read here. Maybe people online can see it better, but this is my collection for tools that I use the most frequently. So I've got like GSCCA in there. I've got Secretary of State records. I've got the DOT records. I've got medical board licensing and violations, and I've got the state bar, or I've got whatever the database is for lawyers that has an API. So I can just be like, hey, how do I call this lawyer? And it'll just pop up and tell me. So I'll show you kind of an example here of how I organize it. So I'll create and I'll just have a folder, and I'll just inside of there, I'll put text files, tell it what to do. So here I've got an inventory that tells it, these are all the things that exist for you. So this is what I use for medical records processing. So I've got a playbook for extracting, turning PDFs into text files. And it's literally nothing more than just a tool that says, if there is text embedded, extract the text, save it to a text file. If there is not text embedded, go to Mistral, use Mistral, extract it that way, save it to a text file. That's all it is. No programming, this is not hard. Then I have another tool that says, it's a tool that I made that looks for social security numbers, medical record numbers, last names, things like that. And I just have it go over the text files and delete, or well, I don't delete them, I index them, but you can just delete them if that's easier. And I delete all the personally identifying records from the records. And you do that the same way you would for trial. Like if you're telling an associate, redact these records so I can introduce them. What are you looking for? Dates of birth. You're looking for addresses, medical record numbers, billing. I'm looking for all this kind of stuff. If you see it, remove it. And it's not an AI that's doing that removal. It's kind of not like you're not like sending your personally identifying information to an AI to remove it. This is just, it's going through, it's removing it for you through something called regexes, which it'll build for you if you ask it. And then we're going through, and from there, it gets more complicated. But like the core principle though, is it's just me giving instructions for it to follow. So it's like, can we convert everything that's like, what is, abbreviations, type 2 diabetes, what is that? And all I did is I just took the medical dictionary and I just plugged it in there, and I was like, here's the acronyms for these things and the common abbreviations. If you see them, just swap them out. That's all I did. And then guess what? Many of these bodies that distribute medical standards of care and guidelines have APIs. So then I say, cool, now we know that now if I want to know what is the standard of care for whatever it is, go look at the API and see if you can find the standard of care. Pull it in. Use that as part of our summarization process. And all this is just like one thing building off of another from just plain text files. So this gets pretty fast once you've gone through it, but it takes 5 to 10 times as long as it normally would to even do it the first time, because frankly, I never thought about how I was working up my cases. It's like, and I think that that's the other brilliance of this, is that it actually makes you think about what is the proper process to review a case for medical malpractice, or to review trucking case records, or to go through and think about organizing depositions. Like some of the stuff I just never thought about. I just did whatever I felt the moment needed without thinking about what's the right way to do it. Whereas now I'm going through and being like, okay, what do we do first? Well, first we make sure that like we've got all of our records in order. I want to make sure that I know who all the providers are. I want to make sure that like there's no gaps where someone has said he went to this hospital and didn't do it. Like, you know, it just literally, I'm just putting in a text file being like, run through this checklist to make sure we're not missing something. And the AI is able to go through and do that. And then this is really hard to read. Sorry. You can access this PowerPoint, by the way, and I'll have it up for you tonight at wfirm.com/AI. And also on that page is every PowerPoint that I've done, wfirm.com. wfirm.com/AI. And then the last like 5 or 6 PowerPoints that I've done are also on that page. And there's about 14 hours worth of videos as well on just specific topics to drill down on this stuff. So I apologize if it's a little hard to read. But this is like an API endpoint that you would see on a page that just says, like in this particular one, it says, it's a collection of first names, last names, and this is medical providers. So this is just a collection of Georgia. This is how you access to determine if a person has a medical license in Georgia. They have an API. This is how you access it. I just plug it in there and say go. All right. How much time do we have left? Because I think we're out.
Yeah, 5
Okay.
minutes, 5.
We'll skip this. I'm kidding. So couple of things to be aware of. So the run-of-the-mill AIs, like if you just go on chatgpt.com or gemini.com or claude.com, those, what I'm going to call retail models, you can opt out of training, but that doesn't necessarily mean that it's going to happen by default. And you absolutely should not ever upload confidential information, privileged information, anything like that into those tools. There are enterprise plans that you can purchase. There are special licensing agreements that you can get with all of them that will allow you to either get HIPAA compliance or get whatever standard that you need. And they go like super high all the way up to like, we're going to bomb people in Iran level classified, which apparently is, are y'all familiar with this? Okay. Oh, no. So here's the deal. All right. So Claude, the thing that I've been showing you is what they use to select the bombing targets in Venezuela and Iran. And so
Iran, that's why we bombed the girls' school.
that's exactly right. And it hallucinated and used old data and decided to bomb a school instead. And then Anthropic found out about it and was like, what are you doing? And they cut off the Department of Defense from being able to use Claude because they were like, we don't support this. And then ChatGPT and Grok then both said, we would like to bomb people. And they got the contract. And so Claude lost theirs and other people are going to be making money bombing people. And they're using these, and they're using the exact same tools that we are, which is crazy. But Claude Code has some additional protections to it, as well as the APIs that they offer. The APIs can get wildly expensive. Like I've had bills that were, $10,000, $15,000 a month because I didn't understand what I was doing. So be super careful with the API calls that some of these tools offer and stick with like Claude Codes, like Max Plan, or like have a plan, like have some fixed billing. Don't just let it do whatever it wants. Or you're gonna have a really bad time like I have. Other thing is to tell your clients, do not use AI, like scream it in their face as loud as you can. There are a couple of opinions that have come out now that says that you using AI is okay, but your clients using AI can breach the privilege. There have been multiple instances now where courts have allowed discovery of a client's AI usage and determined that even when you're sharing legal planning information, it is not privileged. Recent case, this is from less than a month ago, US v. Hepner, this is out of New York. Federal judge said, "No, absolutely not. Like coverable, no privilege, give them all your super secret chats." So be mindful of your clients using AI. And the telltale sign is when you get really nice professional emails from your clients. That's how I know they're using AI. And I immediately tell them to stop doing that. because like it's dangerous for you because they're going to get some weird ideas in their heads. It's also dangerous for them because they can lose their attorney-client privilege if that were to come up. And the last thing is that these tools are super, super dumb, and that they will get you disbarred if you're not careful. Check everything and don't use them for legal research. So going back to that example earlier when I talked about the text files, here's how I do legal research with these tools. I will go through and do the work myself on Westlaw, and I'll pull all the cases. And I will get all the cases that I think are relevant and necessary, and I'll put them into a folder on my desktop. Then when I'm getting ready to start writing or I'm starting to do the briefing, I will then point Claude to that folder that has my curated list of cases that I know are accurate and have the information in law that it needs. And I'll ask it to pull from them to help me improve my brief or to fact check it or do whatever. And it does a fantastic job. I have yet to have a misquote or a hallucination by doing it that way, because you're just limiting its universe so much that it doesn't need to think about anything. It's just pulling source information. And that's the way that I would continue to do AI legal research. And that's pretty much it. If you have any questions, I'll stick around for a little while. But otherwise, you good?
It's the bar. Is there any opinions about the attorneys?
Sure. All right, so a couple of things. So the question was about whether the bar has spoken on this, and the answer is that the bar has spoken quite a bit, but hasn't said very much. Is the short answer, and the reason why is because you got a lot of smart people who are trying to do the right thing and try to navigate this very complicated thing. I would remind everyone in here that Rule 1.1 imposes on you a duty of candor, diligence, and competency. And so knowing these tools, I believe, falls under Rule 1.1, which is what the courts are relying upon when they sanction you back to Kingdom Come for using it improperly. Georgia has not adopted the national standard for Rule 1.1, which includes technical competency. But I would not be surprised if we got some movement on that in the near future. I know that the Supreme Court is considering it. It's been proposed. There are a wide variety of tools and resources available to you through the State Bar. There's a standing committee on AI. We've produced some wonderful little toolkits that you can access at the State Bar website. It's under the toolkits directory. And as well as that wfirm.com/AI has a whole bunch of stuff that you can use. And if you do have any questions, just shoot me an email, or even better, just ask ChatGPT. It's going to be more up to date. It's faster. It's going to be nicer. You'll get more than a sentence. It'll be great. Excellent. Thank you, guys.
Thanks, Matt. I'm going to go to his website tonight. That's great info. A lot in my head. But I appreciate everyone attending today. And one more time, a shout out to Solve It Mediation and Rita Carroll. Thank you for sponsoring today. And everyone, please give them a look next time you have a mediation. Solve It Mediation. And that will wrap up this year's jury trial seminar. Thanks to all the speakers and